thought that bacon and Brussels sprouts would probably go pretty good, especially when you chuck some cheese sauce on it. People either seem to love them or hate them.
I'm not a huge fan, but I like how Dad makes them. How you do them are good.
See?
manako.
Morena kia tātou, kia kara kia tātou. Kata ia te kawa, kata ia te kawa ka whakamau, te kawa ka nanao, te kawa ka rurua, te kawa ka reireia, te kawa ka turuturua, te kawa i whakahauti atu rā kia tāne. Tāne nui ārangi ko tāne te rangona, ko tāne te pupuke, ko tāne tuarea, ko tāne te rawea, ko tāne whakapiripiri, ko tāne mahutae. Tēnei te whakahuake mai e te tipua, mai e te tawhito, mai e te kawhiongariki, mai e tawhiwhia tuki nā tua. O i ka takina te mauri ahua noa ki runga ki enei taura, ki runga ki enei tauira. Kia hua noa ki runga ki enei tāne, ki enei wahine, he tūkuna te whaioro ki a tāne, te waiora tēnei te matatau ki a ke whakatū tāre waki te rangi. Whāno, haramai te toki, haumie, hui e, tāi ki. Kia ora.
Tēnā koe, Sue. Just putting in an appearance today, Kitu appearing for Y203. Thank you, Sue.
Tēnā koe, Mr. Kitu. He mihi tēnei ki a koe te rangatira, ai te huakina e koe o tō tātou nohoanga ai te rānei, kia koutou katoa ko hoki mai ki tēnei uinga, tēnā koutou. Good morning and welcome back to the final day of week 4 of this inquiry. Ms. Wilson.
Tēnā koe, Sue. Sorry to interrupt, my friend. Could I seek leave to depart during the day, please?
Certainly.
Thank you.
Tēnā koutou. Our first witnesses are Jan Dufer and Dr. Sharon Jamal, who will be appearing separately via AVL to present their evidence, which is on the record of inquiry as A121 and A118. So if we just check the Zoom on.
Tērā mā o te tribunera e mihi nei kawaki kia koutou, kia mihi hoki kia tātou rangatira mo tōna whakaaro i tēnei wā tātou karakia hohonu, nei rā te mihi atu kia koutou katoa. Ko Jane Defu tōku nei ingoa, he uri a hau no te maunga tito hea o Taranaki. Engari, e tipu ake i roto i te tau iho o te waka a Māui. Tēnei te mihi hoki kia koutou katoa. This morning I would like to, Sharon is in transit at the moment, she should be online in a moment or two. Dr. Sharon Gemmell, both of us who have submitted briefs. What we would like to do is not to talk about the briefs, but just highlight some areas and add some additional matters. Sharon has just come online now. So, nei rā te mihi ngā māua kia koutou katoa. Okay. The biggest issue that we see that is facing all of this, and for Te Atiawa since 1993, was the establishment of the laws that have affected our tikanga, our customary rights, and the way in which those could be exercised. And we have been involved in all of those cases out of necessity to protect our natural rights. Te Atiawa o Te Tauihu goes from Kahurangi Point right through to the end of the Marlborough Sounds. So the area is huge, and for that to be lost, minimised, marginalised, has affected the iwi hugely. So what we'd like to do now is pick up some individual examples of what that might look like. So I'd like to pass over to Sharon now at this point.
Tēnā koutou katoa. For Te Atiawa, it's a great privilege to be put our issues to the table, but also as an individual, I, on behalf of my whānau, filed 2 claims into MACA, both for direct rather than going through High Court. And the reason why our whānau did not go for High Court was sheer cost. Our whānau didn't have the cost to enter the High Court. And that's a shame, because what we see is other people impeding into our rohe. One of the things that we do want to be very clear on is we don't support the Act in the form it is. Back in 1997, when we filed into the Māori Land Court with concerns about the claim, about the foreshore, was because we would go to the council hui's for applications on marine farms, and no one was really interested or understood what we were talking about when we spoke about wahi tapu and crossing through areas for our kai moana gathering, and they did not see that as an issue. So in the end, we filed, and we had hope that we might actually get somewhere. When we saw the 2000 Act come out, 2004 Act, it was disappointing, and this Act also is disappointing for the simple fact that it doesn't acknowledge our customary rights as mana whenua iwi. It doesn't acknowledge us to do our tikanga the way we do our tikanga. And the exclusive or overlapping doesn't necessarily fit for us in Te Tauihu, particularly in the Queen Charlotte Sounds. So one of the things that I did want to point out was that in the bay, not far from where Matua was talking on Monday, Matua Trevor Watson was talking, I'm also further around from him, and we have a special place our whānau has used from the time of our conquest in the 1820s. We do not dive, fish, or gather around our urapa, yet we will sit on the shore and have to watch people come and climb over our tupuna, dive, take the kai moana from that. And that's actually quite hurtful to see those sort of things happening. And that's why we wanted to put in our claim. It was like when a few months back, we built a jetty down there, and the council was very clear, you can't put a signpost on the jetty because it is for everybody's use, because everybody in New Zealand must be able to use your jetty. And I said to them, well, okay. I said, I don't see everybody in New Zealand looking after our foreshore in the bay. So yeah, those are the ones, when they're talking about the exclusive, one of the things when we filed our whānau one was that though we are in East Bay, Amahanga or Port Gore as it is known, we go there and have been since the turn of the 1830s. We gather our kai moana from there. We also do certain things there. We use it as a gathering post for going out getting the titi, but we hold no land there. We don't need to hold the land because we've always had an arrangement with our Ngāti Hinitui whānau. When they went back to Waikanae, we would take care of business there, and we have done that for them. The other issue that we have wrestled with is this exclusivity is the fact that my mother often talked about her grandfather and her would go into an area up the Tory Channel and they would smoke fish. Again, we don't have land there. However, has been an arrangement we've had with the skipper whānau since we arrived down here through the Keenans and that. So those are the sort of things that exclusivity doesn't quite work. Now, we're not a hapu of some of those ones, but we've had an unwritten right to those areas. So in the long run, what I was saying is that the test is difficult, and that's why a lot of our whānau and hapu did not apply for because they couldn't meet the test as it is today. So those are the main points. What we did, our feelings when I've talked to some of the whānau and the hapu is very clearly is that we would like to see this act repealed. And what we would like to see is an act that comes out that is in line with the treaty that will allow us to do our kaitiakitanga our tino rangatiratanga, because that's what's missing in here, is there's no tino rangatira. And we take care of our own. We take care of our bay. We take care of our rohi. The shared areas, if you were to ask me, would I share tōtara nui with anyone as a whānau, as a hapu, we would happily share it amongst ourselves and our Te Ateo people, but we would not be happy to share it with other iwi. So it's about knowing how our tika is. That's me. Back to you.
Kia ora, Sharon. I think the key to all of this, Sharon's given a brief outline and the issues that we all face. The other issue, of course, in my brief, and talking about the issues with councils and the effects that they've had right across our rohi, with the Environment Court hearings in Golden Bay, extremely expensive just to protect our patch. And the law, LAW, is not allowing us to exercise our rights at all. What we have today is has a minimal improvement. However, it's not going to get to a point that we can exercise our rights in a way that iwi should be able to practice their own LORE. And so,
one of the things with that, I just wanted to point out to the tribunal was translocation of power. I heard the kōrero on during the week, and my brother and my niece are commercial power divers. And I said to him, hey, what do you think of this translocation? And he said, when we were talking about it, we have two parts of our bay. We call it the front garden and the back garden, and often we will use the back garden for our power and other shorties, and we will actually relocate them to the front garden for immediate use, like if there's a tangi coming up and we're ready to go back up to the mainland, or if the family's in there, rather than to go over the back if the weather's rough. So we have a back garden, a front garden, and we've done that little relocation for right through from time. But the interesting part was that MPI issued a special permit to commercial divers, and they were able to do a translocation of power stocks, and those power stocks were to go into the Cook Strait. It's a good idea. However, what they did do is they took the shorties from our back garden. So, and we don't have ownership over that. So the divers came in, and we've been nurturing that. We've been in our nursery ground since the 1830s. So it's, I can understand, but MPI did not know, nor did those commercial divers know, that those shorties were our backyard. So those are the sort of things why we believe that this case is really important for Te Ateo and for our whānaus. So, those are one of the things that I did want to raise, was about the shorties and the power relocations, because we have often done that. And Uncle George Martin, who's long since gone, talked about his mother-in-law, Tinipere, and she was up in East Bay by Matua Watson, and she actually had, she used to nurture her mussel farm there, her mussel garden. So she was one of the very first people to have a mussel garden in that part of East Bay. So, we are not against those sort of issues, but it's about maintaining and being a paitiaki. Back to you, Jane.
Kia ora. I think the last point that I'd like to make is, in fact, around there are many policies that local government have that allow them to issue licences on a commercial basis through resource consents, and a lot of those resource consents today still greatly impact on our kaimoana. And particularly over in Golden Bay, you have commercial cockle farming, there is all of that. So we actually have great difficulty in utilising our own kaimoana for the benefit of whānau. Nō reira, kei te miha kia koutou, kei a koutou I tēnei wā.
Thank you both for your evidence. I understand the Crown has some questions for you initially. Mr. Melvin.
Tēnā kōrua.
Kia ora.
Ko Jeff Melvin tōku inga, he roia mō Te Karauna. I'm not quite sure where I'm supposed to be looking. Over there, right. And hopefully you can see me.
Yes.
You've mentioned this morning in your kōrero that you have an urupa on Cemetery Island in your bay. Can you tell me what the status of that island is in terms of its ownership? Is it Māori freehold land?
DOC about 1970 returned it back to the whānau. It is a name now of our tupuna John Daniel Love, and the trustees have now passed, so we're actually in the process of looking at appointing new trustees. The whole island itself is actually an urupa, and there is approximately 100 tupuna there.
So, if I understand you correctly, the island is in whānau ownership.
Yeah.
And so that means you have control over who goes onto the island. Is that right?
Yeah, we do, but by the time I hitch the boat up and row out, you know, those people, they're not going to listen to me. My brother went out once and told somebody to get off, and yeah, I just said to him, don't do it again. It doesn't solve the issue, you know. We have a kaitiaki there who's been looking after that in the water for us, Taniwha. But we see people going in there and diving around that island, and we don't do it, and to us it's hurtful. So what we want to do eventually, whenever we get the South Island customary regs in and that, we'd actually like to put a mātaitai around it. We would have preferred to have had something there in place now, but we haven't.
Mm. And the jetty that you mentioned in your kōrero, who installed the jetty?
My husband and my brother during COVID.
Right. It seems surprising to me that if you built it, you're not allowed to put a sign on it, but that's...
Apparently, when I asked, because what happened was at Christmas time, we went to bring our boat in, and we actually had to stand out while other people were on around the jetty. I rang council, and they said that when you apply for a resource consent, one of the conditions of the resource consent is that you do not put any signage on your jetty. So what we've done is we built a shed after the dock foreshore reserve, and we've put a signpost on our property saying the jetty is under private ownership, but we're not allowed to put it on there. Apparently it's part of resource consent.
Are you familiar with the Wāhi Tapu provisions in the Marine and Coastal Area Act?
Not really, no.
Right, because they provide for a customary marine title group to seek a Wāhi Tapu protection right in respect of Wāhi Tapu in a area where customary marine title has been recognised. So they afford a measure of protection for Wāhi Tapu in the common marine and coastal area.
Okay, but I need the customary marine title first.
Well, yes.
And unfortunately, we are right down that list. It's a shame that as Te Tauehu was the people who put the claim in 1997. It should have been the first iwi to be heard, not right down the bottom of the ranks. And yeah.
Well, there's no particular pecking order, so I'm not quite sure why you say you're right down at the bottom of the list.
I'd say that because it's taken me till March the 30th to actually find somebody who would explain to us how to get an application into the High Court, because we hadn't entered High Court, but because others are claiming our area, it took me that long to find somebody within the government to show us that we can now apply to be heard through the High Court process. As I said earlier, we never applied ourselves into High Court because we were worried. We're only a small whānau, and we didn't have those sort of funds. And I have asked, is there a time? And they said that we aren't and won't be heard in the short while.
Yes, there's an opportunity for you to appear as an interested party in High Court proceedings.
Yeah. And as I said, I only got that email from the government on the 30th of March that I could do that. I wasn't aware of it earlier.
I think the issue that sits here is what we were talking about earlier. The fact that we have to go to court, that it costs a fortune every time we need to protect what we believe needs to be protected through customary. And I think this is the point that comes out of all of this. The Act has made some changes. However, it is still a very expensive process. And if you don't have the resources to do that, then essentially you have no control over who comes into your rohe, to your whānau area at all. It will be governed by the law. And this is the shortcomings of the Act. It is also the shortcomings of local government, and we can keep going.
Are you aware that there is funding available for third-party interest groups to appear in the High Court and present their case?
I was made aware of that on the 30th of March this year after continuing ringing to ask the questions, because they were supposed to have had a hui in Nelson just prior to COVID. And then when I rang after that, trying to find details, because it was frustrating me that other organisations and that were being funded to go, and we had no funds, and we were doing the research as best, and I have to just, But I am aware now, but I wasn't aware up until March the 30th.
And you've mentioned or referred to in your kōrero this morning to the tests in the legislation, and you've described them as very high or restrictive. But are you familiar with the recent decision of His Honour Justice Churchman in the Whakatohea case?
Yeah, I am, but I don't think it goes far enough. And I read it, I looked at it, it's not, it doesn't allow for the different layerings as such. And like, if I'm, as a whānau, we have our own bay, and then we have other areas where we have continually utilised. Like when we gather the mutton birds off our island, though it is known to be our whānau, we will take other whānaus, we invite them to come with us to do the gathering. Well, not me, because I don't go there. But we invite people to go and do the gathering with us. But those are unwritten rules that we have. They're not things that I've actually written down.
I think in terms of that you're mentioning Whakatohea here, he's made a good decision that it's the Act is quite narrow, and so there's only so much that he could have done to interpret between the lines in the sections of the Act. So amending the Act is not going to change the actual foundations of the Act, and it's that needs to be changed. It needs to be repealed, and ensuring that the treaty is enshrined in that new Act in a way that gives recognition to customary rights, that those customary rights attach to hapu and whānau and not just Māori in general. That there's reasonable public access. We all acknowledge that everybody should have certain access, but it's how they do it. Do they come in and pillage our paua beds, our cockle beds, and we have nothing left? So that's an area, and understand that public-wise that's the case. However, recreational fishers have more rights than hapu and whānau do. So the fact that we get equal treatment and there is due process and it's done in good faith, and yeah.
Tēnā kōrua, thank you for answering my questions. Thank you, Sue.
Morena kōrua, Ron Crosby, a member of the tribunal. I just have a few questions, and I'm happy as to possibly whichever of you sees fit to answer. But possibly it might be best if I just address one particular precise matter to you, Dr. Gemmell, and that was the issue of your choice of the pathway that you took, which was to seek government or Crown engagement rather than High Court proceedings. Have you had an opportunity of seeing what High Court proceedings have been issued by other Te Tau Ihu iwi which might overlap your area?
Yeah. Oh, yeah. I've seen them.
And I mean, if you tell me if I'm wrong or if I'm missing any iwi, but I would imagine that there would be claims by possibly Rangitane, Ngāti Apa, Ngāti Rārua, Ngāti Toa, possibly not Koata and Tama for your area, but I take it those other iwi have claimed in your area.
Correct. All but Ngāti Tama and Ngāti Koata, but the other 5 iwi are. And that's what makes it a mockery.
Now, did they all issue High Court proceedings, or did some of them only seek the Crown engagement pathway as well?
Rangatani Korohaupo have done Crown High Court, and so has Rangatani Kaituna, Ngāti Toa, and I'm not 100% sure Ngāti Rārua have, but all that, yeah.
Right.
So the Korohaupo, including Queer and Apa and Rangatani Wairau, and then there's Rangatani Kaituna and Ngāti Toa. And that's basically, we're going to end up us having, well, as an iwi group, they're going to have to end up, Tatia's going to have to fight again and go back into what they're doing at the moment with the South Island customary regs, defining who is in there, whose areas are they. Which makes it a mockery of what we did with the Waitangi Tribunal when we did our hearings.
And the timing, I take it that you were referring to earlier of you being down, I think you used the terminology along the lines of down the bottom of the list. Do I take it that that timing apprehension that you've got is because of the High Court proceedings for the Te Tau Ihu area being lower down in the ranks, or is it something that has been advised to you in terms of the Crown engagement pathway?
When I've spoken to the Crown, they've said that it'll be quite a while before Te Tau Ihu gets heard. I asked, well, how can we start on the direct negotiations, because my whānau's only claiming a small thing, and they said that, well, I have to wait. So I wait.
Right.
I only hope it's in my lifetime. I have to wait.
Possibly this is a broader question and maybe for you, Mrs. DeVew, but the issue of the whole Ngāti Apa litigation initially arose out of the aquaculture boom in Te Tauihu, and I just don't have a feel at the moment of whether or not Te Awa, I know that they were involved heavily in all of those RMA processes, but what's been the result in terms of Totaranui or in terms of the Tasman Golden Bay areas as far as Te Awa is concerned? Have you achieved any great holding interest in aquaculture areas in those localities?
Kia ora, Ron. If I would go back to Anthony and them, who you're aware of, and ask that question, the answer would be no. We've had to go into bat to get what we could get. If we talk about East Bay and trying to get water space, we were considered the same as everybody else, and Te Awa has no water space in East Bay. And that's one of the vital areas of the iwi over in the Sounds. So that, and we've had to do that. It hasn't been by choice. It has been by necessity. And so that once those areas are put in place, you have no customary, you can't access it because of the farms. And so we've been prejudiced all the way through in those cases on that basis.
Dr. Gemmell, again for you, you referred to MPI relocating power to Cook Strait. Was that as a consequence of the Kaikoura earthquake? Was that part of that reseeding process for that or not?
No, the power industry is gravely concerned about how, the power species at the moment. So what the power industry wanted to do was to start doing some reseeding and translocation. So that's why they did it. My point was that they took it from our patch that we had been using as a nursery ground, but the aim is to actually develop the industry. That's why the power industry did it. So I can understand why they did it, and I don't have a problem with it. They don't know as yet the outcome, how many actually survived it. But it was more the fact that they knew, they saw the shorties and they took our garden that we'd been nurturing and used it away. So, yeah, that was the point that I was trying to make.
Thank you very much, both of you, and thank you for the effort that you put into your presentations for us. Thank you.
Kia ora.
Tēnā korua. This is Judge Armstrong. Hopefully you can see me as well.
Yep.
You can now.
Mr. Few, my question arises from your brief, but you both may wish to comment on this. So in your brief, you have said that a number of developments have impacted on Te Awa's customary fisheries, and one of those is the land reclamation that has taken place. So I'm just wondering, are you aware of how extensive the reclamation has been in Te Tauihu or within Te Awa's rohe?
I think there's two parts to this, and Sharon can answer the second part. There's a whole number of areas that is reclaimed land, and a lot of it, of course, the fact that it's on the foreshore and is extended out has ensured that we lose any access to those stocks that were in that space. Probably the biggest impact would have been the one that in Waikawa, but Sharon will talk about that in a minute. So all those, we've just, as we do, we try and do the best that we can. In some places we've relocated species in the hopes that they survive in another space, and that hasn't happened. That was happened with Picton and moving the cockles to Shakespeare Bay, and the majority of them died. And so that's just one example, and I'll let Sharon talk about the other one.
Yep. Thanks. Just to follow up with Jane, the cockles were moved from Waitohi to Shakespeare Bay for the development of the ferry terminals coming in. So those beds were really, and they died. They just, you can't put what it's, I suppose it's like putting the Love family with the Keenan family and trying to put us all in one house. It doesn't necessarily work too good. So they just pulled them and moved them, and that's not the way you do with the species. With Waikoa Marina, they did the same back when they decided to put a marina in there. They removed our scallop beds. Again, they said, oh, well, we'll relocate, and they relocated to Whatamonga, but the next door neighbour scallops didn't like them, so therefore we lost our scallop beds because they had a scallop war. So both Waikoa Marina sits on our scallop beds. Our whānau did complain with the new development that's going on, where the marina is now putting in more land and more marinas over our beds. However, the iwi did a negotiation with Port Marlborough, and now that is actually happening. And it's we've now lost our kupa beds because they weren't able to be translocated because they wouldn't have survived. So those are the two main areas that we've lost. With the, Waikoa and Waitui is no longer the way they were, basically for that reason. They've changed them for industry and for marinas.
Thank you. Do you know approximately the size of those areas that have been reclaimed, either in square metres or acres?
Oh, heavens. I'm no good on measurements, never get me to measure anything. If you're familiar with Waitohi at all, if you've ever been on the Picton ferry, it would be from the ferry right through probably, we're talking hectares, we're talking a large block of land, because we had the lagoon, and that's been covered over, reclaimed over, so now they've got the football field and all the trucking stops and that. So it's a large, it's in hectares, it's maybe, I couldn't tell you how many hectares.
In Nelson, you've got from Walters Bluff right across the Nelson port, right round the foreshore haven. So it's hundreds of hectares. Over in Golden Bay, you've got the Tarakohi development, and the list goes on.
Yeah.
Thank you. Now, you've mentioned, Dr. Gemmell, that, well, it seems that iwi were involved in perhaps one of the more recent developments or ongoing developments. Were Te Atiawa involved at all in the earlier reclamations? Were they consulted or involved in that process?
We were involved, but it was at the time of the early stages of the iwi growth mechanism, and they spoke to some of the whānau, but what they never envisaged was what we've got now. When people come and say, look, we're going to do this area, to do the marina, they also had to put our Waikoa stream into culverts. The people had no vision of what they've got now. And I was at a tangi last week at Waikoa, and one of the whānau came and said to me, my God, have you seen the marina? And that's how we see it. Now, I have 2 boats parked in the marina, but I don't like it. It's wrong, and every time I come in, when I see the new build, it is very hurtful. Our whānau did, and the people opposed Te Atiawa, but the Te Atiawa Trust did go ahead with it and did an arrangement, but it was wrong to do that.
Now, Mr. Melvin, in his questioning with you, referred to the recent judgment of Justice Churchman, because Justice Churchman has also made some findings about reclaimed land, and he found that whether it's been either lawfully or unlawfully reclaimed, the reclaimed land vests in the Crown and is not available for either a customary marine title or protected customary rights. How would that impact on Te Atiawa in relation to these areas that have been reclaimed?
Hence the reason the Act needs to be repealed.
Thanks, Jane. Yeah. I think for Māori, I think when these sort of things happen, we've got no choice to accept it. And that's why I tautoko what Jane said. If we don't start making that stance, it's going to be too late. We've got to be able to, I agree with Jane. That's why we have to say it has to be repealed. It needs to be put back under with the treaty articles, and that's how it should be.
Thank you. Those were the questions I have for you, but Mr. Crosby has some questions that have arisen, so I'll pass it back to him.
There was just one response that you gave to the judge's question about the background and the past development of the port at Waitoi, for example, and I would imagine it would have been the same at Nelson as well, Mr. Pugh, but could one or other of you, just for the sake of the record for this inquiry, just give a brief description of the dispersion of the iwi into Tauihu and the lack of iwi organisation? One of you used that phraseology of the process of iwi restoration into Tauihu, and could you describe what the situation was, for example, in terms of marae development and the like, in a quick nutshell for the record for this inquiry?
Kia ora, Ron. If we go back to the 80s, there were no iwi as such.
You're meaning the 1980s?
Yeah. Yep. If you even prior to that. So if you come into the late 80s, people were aware that we need to start doing things, and it was imperative that as whānau and as iwi we needed to get together, and that's when you saw the establishment of the Runanganui, because of what was happening in the fishing space. It became essential to pull everyone into the table. In the early 90s saw the establishment of iwi trusts. But prior to that, everybody worked in their own space. And there were not a lot of, when you look at the tribunal hearings and the histories, iwi were decimated in terms of the ability of what they could do on the land, and most of them no longer had land. Same with customary, that was the last bastion, if you like, that they were able to still gather food from. So it became essential for iwi to essentially stand up and be counted, really. And so you saw the development of the iwi and the Te Tauihu to what we have today, but it was by necessity, not by choice, that we had to say, well, enough's enough. We have to stand up and be counted. And it has always been against the law, LAW. And iwi across Te Tauihu, as I said before, Te Atiawa runs from Kahurangi to the outer sounds. And you have Ngāti Rārua, who's in Golden Bay and Whakatū and over to Wairau. You have Ngāti Koata, that's essentially D'Urville Island and through to Whakatū in that area. And then you have Ngāti Toa's an interesting one. Oh, don't get me started. Essentially, they believe they overarch us all, and we say they don't. In terms of Ngāti Kuia and Koata in the late 1830s developed an arrangement between them, which is why Ngāti Kuia survived when the Raupatu came south. So, and all the heke. So that's quite a special case. Ngāti Apa, well, essentially the only place that I was aware of them was in Port Gore, and nowhere else. And does that answer your question?
So in summary, when the port developments occurred, the initial port developments, there was no iwi structure, no marae, no organisation for those developments to approach to seek consents.
Yeah, sorry.
Thank you.
Because the marae across Te Tauihu, the first one was opened in the early 90s, right through to Onitahua in 2001. So prior to that, there were no marae.
Thank you very much.
Thank you both. That completes the questions that the tribunal have, but again, I just want to thank you both for the evidence that you presented to us. Tēnā korua.
Tēnei te mihi kia koe, e te rangatira.
Kia ora.
We might go to talk again. It's too soon for Derek.
You sure? Sorry. Sorry, we're just organising witnesses, Your Honour. Right. Our next witness is Dr. Ken Kennedy, and he'll be referring to speaking notes, which I will file later, Your Honour, if that's permissible.
Ka whanake rari o ngā taranga tūtu ki te rangi. E ke tangaro ke panuku, ui e, tae ki e. Unu hea te pau, ka te pau mua, ka te pau roto, te pau te parau i ataranga mamau. Heke iho i o wara. Tā ki whara te ara ngā te roho, he ara whanau ki te pō. Te pō nui, te pō roa, te pō mati re rau e ko te pō whaireki. E ko taku waka ko te arawa i ngahu i te korokoro te parata. Eke tangaro ke panuku. Whānau. Hara mai te tōki. Haumi e hui e. Tāe ki e. Koe nei te karakia. Whakataki e nā te roirangi. Te wā te whakaheke ngā o te waka nā rākau tapu mātahi pū, a atua matua ki te korokoro o te parata. Te mutunga iho no tōna karakia ki ngā tua Māori, i mutu ai ngā mahi hu kerikeri, nā tangaroa, me tāwhiri mātea, ka mai marino te moana, ka ora e te iwi, ka huri hea te ingoa te waka, ki te waka a te aroa. Nā reira, ko te tīmatanga o ngā kōrero, me mihi atu ki tō tātou maturi te rangi, e ai te kīroti i te ao Māori, ko i o matua kore tērā. No ho maina nā i o matua kore i tiki o te rangi. Nā te rangi i hanga, nā te whenua i hanga, nā te moana i hanga, nā e homai tēnei pai, rangi pai hureri te rā nei, ko ia te tīmatanga, ko ia te whakamutu ngā ngā mea katoa, nō reira whakapainga tōna ingoa. Tuarua, e te haere tōni ngā mihi ki tō tātou kingi Māori a kingi tū heitia, pō tatau te whero te tuawhitu. E whakaaro nui i tīmata mai ai, i te tau, ko tahi mano e warurau, e rima te kau mā waru te tau. I whakakākao mai ngā rangatira o ngā iwi katoa te moti, ki te waka o te arawa, ki pūkawa, o rotea nāti tūwharetoa, ko te take, ko te raupatu o ngā whenua Māori e tauiwi. I enei rā, ko te raupatu i te takutai moana o te karauna, i enei rā tonu. Te take, ko taia tinana mai au, i tēnei huhuinga i te rānei. Hoi anō, ko riro ia pōtatau te pero, te tuatahi o ngā kingi, he ki iho. Ki tō mātou kuini Māori a te ātarangi kāhu, nāna ko kingi tū heitia, tō tātou kingi Māori tēnei rā, pai Mārire. Me tōna whakapapa, kia ngā tipiki aorangi, o te arawawaka, he ki iho, te tehi o ngā pū manawa e waru, o rangitihi, a kaua tapu arangi, nāna ku piki ao, whakapapa he ki iho mai, te ure tārua, mai ki te kingi tūheitia, o te rā, te kingi tanga i tēnei rā, pai Mārire. Tua toru, kia koutou ngā me mō te rōpū, whakamana i te tiriti o Waitangi. Mihao, te kai whakawa, tēnā koe. Te pāpā pau, te tuahine rā winia, te mātanga e Ron Crosby, nā mihi mai oha kia koutou. Kia koutou anō hoki nā roia o te karauna. O tira ngā roia Māori e paukaha nei ki te pai ai nā huatanga katoa ia nai tātou te iwi Māori. O tira ngā roia katoa e tau nei. Tēnei ka mihi atu. Koutou anō hoki whakarongo mai na nā i runga e te ipurangi. Pū ngā were. E whakarongo mai na nā mā Zoom. Tēnā koutou katoa. Tāia te kawa ko te kawa tēnei ki a iwa matua kore i tiki o te rangi. Te no hanga tapu o re hua, wawau wa re hore ki tapu o re hua tonga maranui. Te tau mato o ngā tua ka rangi nui, rangi no, rangi pauri, rangi pōtangi, rangi petu, mā rangi whekere. Te ao nui, te ao wheneka, te ao whetara. Te unuhanga te hoinga, tāne te kapu ko te rangi neo, wariki ko te ao tū rōka pū hāorangi. Oho mai rangi rua mati rangi taonga i te maranga e mawaka tapu uru i ka rangi tapu atua matua. Ka noho a atua matua wai heke tua. Ka apota ko rakauri nā rakauri ko nā te roirangi. Te tohu ngōrunga te waka o te arawa. Me hoki anō ke atua matua. Ka noho atua matua o karikaroa. Tana wahine punarua. Ka apota ko hau mai te whiti. Ka reri ki muri ko tia, ka reri ki muri ko hei, ka reri ki muri ko MACA, ka reri ki muri ko ora, ko oro. Nā hau mai te whiti ko tamate kapua. Nā tia ko hei, nā tia ko tapuika, nā hei ko waitaha. Me hoki anō ke a hau mai te whiti. Nā hau mai te whiti ko tamate kapua. He ki iho, ka haumata moe te waka moe tahanga, unuku mai raratonga rangitihi pakahirehira. Upoko pakahirehira, i te kai tōnu upoko ki te akatea. Nā nai puta e te korona pū manawa e waru o te arawa. Engari ke te āwangawanga nā uri o tia, nā wako hei. Nā te mea, no te arawa no rātau, hoi anō, ka noho a rangitihi a rongo mai turuhia. Ka puta ko rātou rua, te kuri miti i te henua hou mai te whiti. Ka reiri ki muri ko tauru au. Ka noho a tauri o au e a tāne moitara no te whānau apanui. Ka puta ngauri. Ka moe a rangitihi a kahukare. Ke aputi ki wahu ka rangi whakaeke au. Ka reri ki muri ka rangi auhia. Ka moe a rangi whakaeke au. Ia uinuku rauiri. Te tūhira nā tū hoi pōtiki. Ka puta ko rangi te aorere. Pitu pitu kōrero tēnei pāna ki tērā pānau tanga mai. Noho mai na nā rangi whakaeke au. I ngā taha taha o te awa rangi taiki. Ki te rāwa pā a puke tapu. I te teko. Kei muri e te hōtero o te teko i nei rā. Te rāwa pā. Engari hapu ana te wahine nei unuku rauiri. Ka karangahia mai te matua nā rangi whakaeke au a rangi tihi. E tama, whakahokea mai ki a te aroa, ki tā māua, ki taku pā, tū watawata i a rangi whakakapua, i o kawatapu a rangi ki Mauria. Ka mea mai a rangi whakaeke au ki tala hoa wahine. E kui, me nā ka whānau mai e kōtiro ta paena ki te awa o rangi taiki e rere nei. Me nā ka whānau mai he tama. Ta paena ki te ao o te rangi i runga ke nei. Ka whānau mai he tama. Ka ta paena ko rangi te aorere. A nei a Kennedy. Tuaka nei mo rangi te aorere. Rotu i tēnei hui. Aha koa pakeke mai au. I raru i te maru o tōku tūpuna hau mai te whiti. O nā tipiki ao. E tū hire mai rā i rungi tōna marae. Te pauna manui o nā te inukura. E te pai, ke te mau tonu anō au. Tōku whakapapa ki ngā whenua o rangi te aorere. Nō reira, nā rangi te aorere ka puta ngā uri. Ka apata ki kawa. Ka reri ki muri, ko tū te whaiwha. Ka reri ki muri, ko hene te kāwa, ka reri ki muri, ko kai ure. E uri a hau no apataki kawa. E uri a hau anō hoki o tū te niu, tū te whaiwha, ka puta ko tū te niu. Anei anō hoki a Kennedy o Ngāti Rangi te aorere. Me hoki anō ki ngā whakapapa o ngā pūmano e wari o te aro. Ka moi a rangitihi i a papaparanui, ka pute katu haurangi. Ka moi a rangitihi i a manawa kotokoto, ka pute ko rāka i ao, ka reri ki muri ko kawa tapu arangi, ka reri ki muri ko apu moana. Nā tū haurangi, ka moi i a rongo mai pāpa, te māhine nā kahunganu, ka puta ko inuku kōpako. Anei, anō hoki, a unuku kōpako, te mana whenua o te tūmu kaituna. Nā unuku kōpako, ka puta ka whakaue, nā whakaue, ko te waka heimoa, nā te waka heimoa, ko rangi wewehi anō hoki, te tehi o ngā hapu e toru, te mana whenua o te tūmu kaituna, tua ngā huru māwha, te tahata o te moana a toi tu huatahi. Te kai whakawā, e miharo, tuhi kōrero au e nei kōrero e rua ngā tau ki muri pēr. I te marama kohi i tātea, i te rua mano, me te tua ngāuru mai ua te tau. Nā te mati uru tā pēr, te tōmuri whakaputai e nei kōrero. E āhua rereke, e tehi o aku kōrero i te rānei. Me titiro tātou ki te whiti tua ngāhuru. Si. He rere ke ngā kōrero o Ngāti Rangi Te Arere, o Ngāti Rangi Wewehi, me Ngāti Unuku Kōpako. Tā mātou hia i nāia tonu nei, tā mātou kia panaia te ture, taku tai moana, rua mano, te kau mātahi, ki waho, me tīmata anō tātou, kia whakatūngia he ture, e hanga e tonu ana ki te triti o Waitangi Kātika. Hoi anō me titiro tātou ki te whiti tuawhitu, i whakahengia te ture taku tai moana o te krauna ki tā mātou mana whenua, te taku tai moana o te arawa a te tumu kaituna tua ngāhuru māwha. He hai, ka whakahua nā kawa o te arawa i raru i ngā taketake, o te waka o ngā rākau tapu mātahi pū ātua matua. Hei tauira manako, o wānauri, i heke iho ia oho mairangi, no hoa ki tawhiti areare, mai rāno. Ko ngā kawatapu o Ngāti oho mairangi o te arawa, hokatahi mārima e nei kawatapu. Ko te kawa tuatahi, ko te kawa kia i o Matiokore. Ko te kawa hokatahi mārima, ko te kawa tapu o te pātaunaha o e neira. Ko te kawa tapu mo te whenua, ko te kawa hokotahi mātahi, ko te kawa tapu hokotahi mārua, ko te kawa mo te moana. Ko e nei o ngā kawa tapu o te arawa, ngā kawa tapu mo te whenua me te moana, i whakaritea mai i ngā rā o nomata. Tai rawa mai ki e neira. Nā reira mai te wā, i tai mai ai te wako o te arawa, ki make tū, kore rawa e whati te tū honotanga o te moana ki tēnei whenua Māori a te tumu kaituna tua ngāhuru māwha. I tēnei rohea te wairiki, te tumu kaituna tua ngāhuru māwha i Wainganui, i a papa moa me te nuti awa o te kaituna ki te tumu ki Maketu. Me hoki anō ki ngā kōrora Māui, nāna te ika a Māui, i hiake, ko te upako o te ika, kei konei, kei poneke, te whanganui ātara. Ko te hiko o te ika, kei te nōta, te rerenga wairua, nā te kuri, nā te rarawa, te awa pauri, nā puhi nui tonu. Ngari ko te puku o te ika o te puku o te ika, ko te rohe o te wairiki, mai ngā kuri a whāre ki tihirau, mai Maketu ki Tongariro. Te kai whakawā, i rongo au, i nā tahira, ko nai tūhoi te manawa o te ika. Aha koa he ingoa atu i te pūtake o te tehi o ngā iwi o Ngāti Manawa, te pūtake o tāpiu au, engari ke au nei ko te manawa o te ika, ko te rotanui a kahumata momoi. Hea hai, e waru ngā pū manawa i reina, nā manawa katoa o te ika a Māui. Nō rere kororo noi hoa tēnei. Engari, he mana moana mātou i i tērā peto o te arawawaka. I roto i ngā taunaha whenua. Ko tapu i ka tērā. Ko kaituna tērā. Ko waitaha tērā. Ko maketu a rohoki. Nā te arawa i kawea mai na tērā ingoa maketu i hoai ki tawhiti are are. O eno me titiro tātou ki te wāhanga tueiwa. Ko te whenua Māori e kia nei ko te tumu kaituna tua ngāhuru māwha. Ko enei whenua me timata mai te tumu kaituna tua māwha, tua ngāhuru māwha e tatana ki te huarahi o Papamoa. Mai te moana toi te huatahi ki te raki. E haere whakatetonga tō te kai ki te huarahi a pere e tatana ki te awa o te kaituna. Me te huatahi, me te huarahi matua ki te rāwhiti. Ka haere atu te whenua Māori nei i ngā tahata o te awa o te kaituna ki te kotinga o te tehi whenua Pākehā. Ka haere whakate raki tō te kai ki te moana toi te huatahi anō. Ka hoki mai ngā tahata o te moana. Ki te kotinga o tumu kaituna tua ngāhuru māwha me mā whenua Pākehā o Papamoa. Koe nei te whenua Māori e kia nei ko te tumu kaituna tua ngāhuru māwha. I te tau kotahi mano e warurau e tori te kau māono ki te kotahi mano e whā te kau Māori ma te tau ka tū e pakanga nui i te tumu pā. Nā te toa o te arawa i taua pakanga i whakaara nui chi ai te kōti whenua iwi taketake i te tau kotahi mano e warurau e iwa tekau kia riro ai te mana whenua o te tumu kaituna tua ngāuru māwha ki ngā hapu e toru o te arawa, a Ngāti Rangi te aurere, a Ngāti Rangi wewehi, me Ngāti unu kukopako. Nā ngā tikanga o te atu o te riri, a tūmatauinga, i tō ei a te arawa i taua wā. Riro ai te whenua Māori nei, ki e nei hapu e toru o te arawa. Me titiro tātou ki te whiti, tua ngāhuru wāhanga B, nā kōrero kaiti akitanga o te tumu tua ngāhuru māwha. Mai te tau ko tahi mano e warurau, e iwa te kau te tau, tai atu mai, tai rawa mai ki te tau ko tahi mano e iwa rau, e whiti te kau mātoru, i noho mana motuhake. Tēnei whenua Māori mō ngā uri o Ngāti Rangi Taurere, o Ngāti Rangi Wewehi, me Ngāti unu kukopako. Kore rawa e nei iwi, e nei hapu, e toru o te arawa i whakaai, kia timata mai ai, nā mahi whakawhanaketanga a te Pākehā. Ki rungi i tēnei whenua Māori i rotu i e nei tau. I te tau kotahi mano i warau, e whiti te kau mātoru te tau. I whakamauni chi ai, hei kaitiaki Māori whakapūmau, hei pau whakahaere tuatahi i te whenua Māori nei. Hoi anō i te tau kotahi mano i warau e iwa te kau, whakakorengia te mahi o taua pau whakahaere whakapūmau, ka huri ki te whakawhiwhi ngā mema tūturu o Ngāti Rangi Taurere, o Ngāti Rangi Wewehi, me Ngāti unu kukopako, he puari kaitiaki, he arahi i ngā ahuatanga katoa o ngā mahi whakahaere o tēnei whenua Māori mo ngā hapu e toru a Ngāti Rangi Te Aorere, a Ngāti Rangi Wewehi, me Ngāti Unuku Kōpako. Nā, ko rero ki te tua ngāhuru mā toru ngā mema kai tiaki i tau wara, hei mahi whakahaere, mō ngā hapu e toru, a Ngāti Rangi Te Aorere, a Ngāti Rangi Wewehi, me Ngāti Unuku Kōpako. Engari, ko whakangaro atu e te he o rātou, ki o rātou mātua tūpuna ki tua te ara. Toko ono te toenga o rātou nā pau kaitiaki, tūturu i nāia tonu nei. Ko Pirihira Fenwick te tehi, ko Malcolm Short te tehi, ko Andrew Bidwa te tehi, ko Unuku Fairhall te tehi, ko Emere Rota te tehi, me Waldo Hoi Hauia, aha koa no Ngāti Barau, tēnei tangata, a Waldo, te tehi o ngā wāwai, ko te tehi o ngā wāwai no hoki, no te tehi o ngā hapu e toru o te arawa te tangata nei. E rima mano me te rima te kau nā tāngata, whai pānga ki te whenua Māori nei. He uri rātu katoa o Ngāti Rangi Wewehi, o Ngāti Rangi Te Aorere, me Ngāti Unuku Kōpako. E rua rau e whātikau nā he ke tare, he ke te rā, i te whenua Māori e kōre ake nei, ngā pāpāringa te roto o te toi te huatahi. Me titiro i te whititua ngā huru ki te wāhanga si, he hae ngā hapu e toru, a Ngāti Rangi Te Aorere, a Ngāti Rangi Wewehi, me Ngāti Unuku Kōpako, i tukuna atu tēnei tono ki te rōpu whakamana i te tiriti o Waitangi, i raru i te whakamaru o te kauni hera Māori o Aotearoa. Whakamauni tia e te kauni hera Māori o Aotearoa e te ture, whakawhanaketanga hāpori Māori, ko tahi mano e iwarau ono te kau mārua. Nā te tehi o oku karaua o Ngāti Henekora, hapu o Ngāti Pikiao, a henare te reiwhati Burkau i Arahi, te whakahautanga o tau ature, whakawhanaketanga hāpori Māori, ko Walter Nash, te Premier Aotearoa i taua wā. Mai i taua wā ki tēnei rangi takoto nei, kaore te kauni hera Māori Aotearoa me ana mema kotoa, e whakai ana ki te ture takutai moana. Rua mano te kaumātahi. Nā te mea karekau he wānanga tikanga Māori i tēnei ture takutai moana. He uawa mo nai mātou ngā iwi me ngā hapu huri no te moti. Ki te whakarite, ki te whakatutuki, o mātou wawata e pāna ki ngā hihia o tēnei ture takutai moana. Rua mano te kaumātahi. Engari ka whakae mātou ngā hapu e toru o te arawa a Ngāti Rangi Te Aorere, a Ngāti Rangi Wewehi, me Ngāti Unuku Kōpako. Kia panae tēnei ture takutai moana ki waho. Me tīmata no tātou kia whakatūngia he ture takutai moana, e hāngai tonu ana ki te tiriti o Waitangi. Ki te hoki mai te ture takutai moana ki ngā hapu e toru o te arawa. Nā te mea, ko ngā hapu e toru te mana, kia pupuru tūranga o ngā pānga mo te tumu kaituna tua ngā huru mā whā. Engari, ka titiro whakamua nā whakaaro o mātou ngā hapu e toru, ta mātou hihia kia mahi tahi ai, nā hapu e toru, me ta mātou rōpu whakahaere. O te whenua Māori nei, kia para te huarahi hei oranga mo wā mātou tamariki mokopuna I ngā taukau dino. Ana e whaeke nei, he tauira e rungi I te whakatauki mā tini mā mano, ka rapa te whai. Ko au te tehi o ngā mema o te puari kaitiaki, te kōtahi tango o te arawa, he rōpū kaitiaki I ngā ika mō te arawa waka. E tāpiri atu nei ki te uhu kai moana, me moana ika no hoki. I tēnei wā e arehi nei e te arawa, I ngā iwi, ngā hapu, mai ngā kuri a whāre ki tihirau, mai makitu ki tongorero. Kia whakakotahi ai, nā iwi me ngā hapu, e arehi nei I te kaupapa ahu moana, I te moana toi te huatahi, I rungi ngā whenua, o te rohe o Wairiki anō hoki. Tautoko ana te whālo apanui, te whakatōhea, nā chiawa, te arawa me nā te rangi nui o tauranga moana. E te haere tonu mātou ngā kōrero kia nai tai, kia nai te rangi, kia nā te pūkenga. No reira e te pāpā e pau, ko wai te tangata mo nai tūhoi hei tuku kōrero ki te kōrero I tēnei kaupapa whakahirehira. Ka haere au ki te uru taumatua, ki tāne atua, ka haere au ki te tī, ki rua tāhuna rānei, no reira taku pātai, whakamārama mai ko wai te rōpū hei whakautu taku pātai. Hoi anō, kei te tautoko Ngāti Parau anō hoki, ahakoa te rongo atu. I ngā karai kreme no Ngāti Parau I tēnei huhuinga, kei te tautoko Ngāti Parau, kei te tautoko anō hoki ngā iwi o me ngā hapu o hauraki I tēnei kaupapa pakahirihira, kaupapa ahu moana I te rohe o te Wairiki, I arahi nei e ngā iwi me ngā hapu o tēnei rohe. Nō reira te kai whakawa, tērā pēr, kua mutu waku kōreri konei, tēnā koutou, kia ora tātou katoa.
Tēnā koe te rangatira, te mihi tēnei ki a koe koutou ko ngā pūmano e waru o rangitihi. We do have some questions for you, Dr. Kennedy, Mr. Melvin?
No, sir, thank you.
Okay.
Tēnā.
Tēnā koe.
Well, the Crown doesn't, so we'll move to our side.
Probably not a question as such, Dr. Kennedy, but really just to wish you all the best in the cooperative approach that you've outlined just at the end of your evidence, and it was refreshing to hear that, and I do wish you well with that. Thank you.
Thank you.
Tēnā koe. Kei te papa, ngā mihi ki a koe, me o kōrero I whakapuakina mai tēnei ata. Hoi anō, hei whaiwhai ake I ngā kōrero a taku hoa, mo tēnei mea te mahitahi me wetahi atu. Pātai tāku mō ngā tikana o ngā pūmanawa I waru o te arawa I runga anō I te whānui o tō rohe, mai make tū ki Tongariro, he wāhi nui tēnā. Hoi anō, pēnā e tika taku rono I wō kōrero, ko ngā mea e noho I te takutai, koea pēr nā mea ka tiaki I tērā wāhi mō koutou katoa o te arawa. Hoi anō, ka tae anō e koe te kōrero mō hea hanga ngā mahi tahinga I Wainganui I ngā mea noho ki tai, me ngā mea noho ki uta, kia mārama ake kia mātou, pēhea nei te whakahaere te arawa I tōna rohe, pēnei a mātou nei, he wā ka haere atu mātou o uta ki tai, engari kareo i ki te i roto i o kōrero, engari tērā pēr kei a koe wena kōrero.
Ai. Tēnā koe mō tērā pātai e te tūhene rāwinia. I tīmata mai ai tēnei kaupapa kia whakatūngia he kaupapa ahu moana. I karanga hea e te rūnanga o Ngātiawa ki whakatāne. Haere atu ai, nā iwe me ngā hapu mai ngā kuri a whāre ki te irau, mai maketū ki Tongariro ki tērā hui, tērā pēr e rua ngā tau kimuri. I tēnei wā, kei te tangi tonu au te nākau mo te tehi o wā mātou kaumātua a Willie Emery. Ko ia te kanohi mo te arawa i tau wā, engari i ngā wiki tata nei, e huri ai ona kanohi ki tua ki Pairau, ko tai atu ia, ki ona mātua tūpune te kōpau te whenu. Nā Willie Emery, te pau o tēnei kaupapa mō te arawa i te rāwa. Te take, kōruhia ngā kōrunu mō tēnei kaupapa ahu moana, nā te mea e hara tēnei kaupapa kia mahi tai ai he ui kotahi te kaupapa. Ko te kaupapa, te nui o te kaupapa, ka tika me whakakotahi ai, nā iwe me ngā hapu o tēnei kaupapa nui. Ko tīmata ke mai mātou te kōrero. Me te tautoko anō hoki i te whakatōhea, nā tā rātou mahi whanaketanga i tā rātou whanga o Pōtiki. Tautoko ake, nā iwi katoa, ke nā te whakatōhea anō hoki. Engari, ko ronga hau tō pātai, he aha ngā mea kiuta, kei te pai tērā. Ko te rohe a te wairiki, ko te rohe o te ahi pūtea, te ahi mo te wera, te wai, ne? Te ahi tipua, te ahi tupua. Ko tēnei rohe te wairiki, heria mai, e nā ona tuahine, te ahi tupua ki te rohe te wairiki. Anei mātou o te arawa e hihi ana kia tūhono ai, te ahi tupua, ana ki ngā iwi katoa, te rohe a te wairiki, kia whakapuake, kia whakawhanake, tēnei mahi ahu moana. E nō reira, e hara i te mahi mo te moana anake, he mahi anō hoki, i rungi te whenua anō hoki, te take o tērā kaupapa. Nō reira kei te tautoko, mai maketū ki Tongariro, ko tūwhare tō anō hoki te tei, te taha o ngā iwi, te takutai moana. Kua tautoko matu katoa. Me te tautoko nō hoki a Ngāti Parau me ngā iwi o Hauraki. I haere mai ai te Premier o Aotearoa Jacinda e toru ngā wiki kimuri ki te tautoko nō hoki tēnei kaupapa me te whanaketanga o te whanga o Pōtiki o roto te whakatōhea nō hoki kei te tautoko nō hoki o nā whakaaro mo tēnei kaupapa nei. A tērā tau te marama o hune ka te atu mātou ki te tari o te minita pāka. Tono mai ki ai e kia tautoko tēnei kaupapa nō hoki. Te minita o te tai ao. Nō reira tēnā koe.
Tēnā koe mō ina whakamarama mō ngā mō hehia whakahaere ahu moana i nei tau nei. Engari, ko taku pātai tuatahi hea ngā kōrero o mua mō ngā whakahaere i te moana, ngā kai, ngā mahinga kai, e rā momo, hei whāngai atu i ngā mea o uta o te arawa waka. E hara i te mea, hei te, me ki pēnei, Kua rono koe wetahi kōrero e kōrero ana nā mātai nā mahi rāhui, e rā momo mahi, nā tikana, e pāna ki te takutai moana, he pātai noiho tāku mō pēhea te whakahaere a te aroa i auara, koa mō nai nei, koa mō ngā mahi ture nei, engari ko ngā tikanga e pāna ki tērā. He momo oha tēnā te whāngai i tō rahi mai te tai ki uta, nā mea o uta ki tai, i pērā koutou i ōna rā?
Ai. Me hoki anō ki takutu ingaroa. Wetehi o ngā tauira hei whakamāramihi o kōru. Ko te tei ko ngā ahu ota, ne? E maha ngā ahu ota. Ki runga i te tūmukai tūna tua ngā huru māwha. I whakarau rangahau hi e ngā kaihua kanga i te tau 2000. I whakarangahau tia anō hoki te tūmukai tūna i te rātau. 2018 ko kite atu e rātau i ngā anga pipi, nā anga tuatua, nā anga tītiko, me ngā kōhatu hangi anō hoki. I ngā rā o mua nā ngā iwi te takutai moana i kawea mai ki uta nā ika o te moana. Ki ngā whānau, ki ngā marae, ki ngā hapu o te arawa i tau wawa. Ko te tehi o ngā tohunga mo tērā mahi, ko te whānau read ki maketu. Tā rātou hihia ki te whāngai, ngā whānau me ngā hapu, ngā iwi, ki uta, ki te tākere nui e te waka o te arawa, nā ika o te moana. Koe rā te tehi o ngā mahi i ngā rā omo.
Tēnā koe mo e nā whakamārama. Hoi anō, ka waiho nā tohenga mo te manawa o te ika Māui. Ki konei. Nā mihi kia koe.
Tēnā koe.
Hei te rangatira Kennedy, tēnei te mihi ake ni kia koe. Mō e nei kōrero rangatira kua whakatotohia nei e koe ki te aroaro o te rōpū whakamana i te tiriti o Waitangi. Nā, kai te tiroa hau ki tō wāhanga whakamutunga te wāhanga te kaumātoru o kōrero. Ko te pātai pēr he pēni ana nā. Ki te mate he toho rā, ki tai, kai te mārama pēr ahau, tātou katoa, ko te mana o te rā toho rā, kai te iwi, kai tai e nohoana, me nai i u, i pai te toho rā ki maketu, ko te iwi pēr o te ara wakairi rai nohoana ko rātau. Ko rātau te wahaki, ka pēhea rā, te toha i ngā hua o te toho rā, kia whai wāhi ai ngā iwi o uta. He kōrero au o mua mō te toha i ngā hua o te toho rā, i pai me ki maketu, kia whai wāhi atua i ngā iwi o uta, pērā i ngā mea kai rotorua e noho ana. Tai noa pēr ki ngā mea kai tūwhare toa e noho ana, kia whai wāhi rātau.
E pātai pai tērā e te pāpā e pau. Ko te raru ki rungi i te moana, ki rungi i te whenua Māori e te tumukaituna. Ka ki mai te kauniera arohe o tauranga moana. Nō rātau tiki kia toha ai nā huatanga e pāna ki te rā huatanga mena mate ai te tehi tohora ki rungi te whenua te tumu kaituna. Ko te raru, mai te taona nui o Tauranga Moana ki Papa Moa, no nai te rangi me Ngāti Ranginui, Ngāti Pūkenga te mana o te whenua. Mai Papa Moa ki Maketu ko te aroa te mana. Ko era te raru e wānganui ngā kaunihera a rohe, ngā kaunihera a takiwā, te rohe a te wairiki, ka re rātou e mohe ona ki ngā tikanga o nai tāua te iwi Māori. Mēnā he mate toho rā i rungi te whenua te tumu. I te rātau i karangahia mai te kaunihera rohe a Tauranga ki au. Kia hui tahi ai mātau ki Tapuika o tēnei kaupapa. Ka mea mai au ki a rātau e hara no koutou te mana o te whenua no mātou o te arawake. Nā mātou te kororo whakamutunga mō tērā kaupa, nā mātou o te arawa e whakahaere i ngā tikanga kia pai ai wera koro e koro mai e koe mō te matenga o te tohora. Ai roki, koera te mate nui ki oka nei e whakaoro me hui katoa mātou, katoa o te arawa, tēnei kaupapa, kia tukuna atu nā hua o te tohora ki ngā iwi me ngā hapu o te arawa. Ai.
Anō reira, kai te noho pai ngā pūmanawa e waru o te arawa, kai te tautoko tētahi i tētahi, kai te kotahi o rātou whakaaro mō te mana o te arawa ki te takutai moana me tō rātou hia pēr ki te whakahoki ato i te mana kia koutou ki a te arawa.
I rungi ngā kōrero tātou kuia karau e te wāi a rātou, ko te mana i tērā taha o takutai moana ki Maketu, i ngā rao ona mata no Ngāti Piki au i tīmata mai ai, te whakatūngi e ngā pātū watawata ki Maketu. I mua i ngā iwi katoa o te arawa, koera te take i tū wai ki Maketu, te tīmatango ngā pā no Ngāti Piki au katoa rātau, ko hau mai te whiti te tehi ka tū ki Maketu, ko kahu mata momoe no hoki te tehi, ka tū ki Maketu, ko kaua tapu arangi no hoki te tehi, ka tū ki Maketu, nā pā tawhito o te arawa i tau wawa. I haere tawhiti mai a Ngāti Pukaue i ngā rā o e nei wā, kia whakatūngia he marae mō Ngāti Pukaue ki Maketu, engari ko ngā marae tawhito o Maketu no ngā marae o Ngāti Piki au.
Ko te takutai moana, kai wahu i te rohe o te arawa he takutai roa. Mēnā e tiki nātua nei ngā kōrero o mua, mai ngā kuri a whārei ki te kitau. Kai waenga nui, ai te rā rohe, he hua ngā iwi, ko ngā i te rangi, ko ngā tikahungunu, ko te arawa, ko mātātua. Engari, kai te kite ake au i tō kōrero whakamutunga, i mua i te haerenga ki ngā pātai e kimi ana koe i te tahi huarahi e tae ai e koe te arawa te kōrero ki e tahi o ngā iwi kai taua takutai rai na hoana. Ngā iwi pēni a ngā tiawa nei, kua kōrero ke pēa koe ki ngā tiawa. Kua whai wāhi koe ki ngā kōrero ki ngā whakaaro o Ngāti Manawa. Ko tū hoi tā we whai nei koe me tō inui koe rā, tāu hei haerenga ki te kōrero. Ka wea hari rua tāhu, nā kāre aro i e rā. Te moana. Ko te uru taumatu anō pe te wāhi hei haere mō te arawa ki te kōrero me pehe ara te whakakutai. Ahoi anō, i raru i tērā whakaaro, ākua, pērā te roa o te takutai i wahua atu te moana atoi me tauranga moana, mārama tonu ngā iwi ki ora taurohe. Mārama rātau, mātau o mātau atua nei, ka whai wāhi ki ngā hua o mautohora o whakaari. He wāhanga tō tēnā iwi, tō tēnā iwi. Kua kore nā ia nei. Engari, kai te rongoake, kai te whakahokia mai e ngā tiawa, tērā tikanga kai te whakaorahia, nā te mea, kua nui haere ngā titi ki mautohora. Kai te pērā o koutou whakaaro o te arawa, me nā ka hua ngā kai, me hoko ki ngā tikanga o mua.
I hare mātou o te arawa ki te rōpu whakamane te titi mo te mau te rara mō titi ne. Ka puta mai ngā kōrero te arawa, koe rā te whenua i takato ai, tā mātou tohunga o te waka o te arawa nā te raurangi, i mō titi. Ka mutu wāna mahi ki roto o tūwhare toa, ka hoki mai nā te raurangi ki makatū, tai atu ki mō titi noho ai. Koe rā tā mātou kōrero ki ngā iwi o te takutai moana mai ngā kuria whāre ki te hirau. Ko tā mātou tohunga nā te raurangi takatoana i te mautere o mō titi i tēnei rā. Koe rā tā mātou take ki te rōpu whakamana i te tiriti o Waitangi mō ko Waitemana o tērā mautere. Nō reira, kei te mohi o mātou o te arawa, ko te rohe o te arawa te takitai moana, mai wai rākei ki Papamua, ki Maketū, ki roto Pukehina, Ngāti Whakahemo, ki Ngāti Mākeno, tai atu ki te awa te atua, ki Matata, koe rā te rohe. Kei waho atu o Tamarākau, he kō atu me te maha o ngā kaimoana i reira. Kei te mohi o mātou, koe rā te wahango o te takutai moana mō te arawa, tērā waho atu o Tamarākau, nā kaimoana mō mātou o te arawa. Kei te pai, kua riro i a te whakatōhea, tā rātou wahango o te takutai moana, waho atu i o Pōtiki, tā rātou wahanga kai, engari ko mātou o te arawa, kei te mohi o mātou, kei hea ngā kai moana mō te arawa, engari kia pai ai te whakahaere o tēnei kaupapa ahu moana, ka tika me whakakotahi ai, ngā whakaaro katoa, ngā hapu, ngā iwi, i te rohe o te wairiki, ka tika me kōrero tātou.
Ka pai o whakamarama me o kōrero hei te rangatira Keneti, pai tiki te iako i tēnei nohanga o te rōpū whakamana i tiri tō Waitangi.
Engari kanohi monati rangi tiarari tēnei rangi. E whanaunga tāua e pa.
E tika. E tika. Nō reira, tēnei ngā mihi aki ki a koe, kua mutu aku pātai ki a koe.
Tēnā.
Tēnā koe te rangatira. Kaore aku pātai, engari e tautoko ana au e ngā mihi, kua mihi ai te tepu nei. Tēnā koe i tō kōrero mai kia mātou e pāna ki tēnei ka whakahirira. Tēnā koe.
Tēnā.
Our next witness is Natalie Coates, whose evidence is on the record of inquiry is A124.
I mua te he waeta tēnei no Ngāti Rangi Te Arare. e tamae e tamana ku koe I ki mina ku koe I ranga hau ki te pō uri uri ki te pō tango tango o horo te ki mai ue nuku rau wiri I te puta he wahine tapai ki te au o te rangi e tūnei. Ki te puta he tāne tapaina ki te ao o te rangi e tūnei. I toko nā e tō tupuna o tāne whakapiri ki rungara. Koia te rangi pua te ae tūnei. Kia ora tātou.
Tēnā koutou katoa. I te tuatahi he mihi kia tika kia koutou ngā rangatira o te rōpū whakamana I te tiriti o Waitangi. Kia koutou katoa aku huamahi, te kāhui roia, ngā mihi kia koutou katoa. Kia tātou katoa e tai mai nei I te rānei ki te whakawhiti kōrero mō tēnei kaupapa whakahirahira tēnā koutou. I must say it's a little strange being up here giving evidence. Ki te muro o te ahi me ki. I much prefer being a lawyer. And I'm getting a whole new appreciation for looking at that list of cross-examination, who intends to cross-examine you and being slightly nervous about that. So ngā mihi nui kia koutou katoa I tuku kōrero mō te tribunara. I do not intend to read my evidence in full, given time limitations. The plan is to speak to particularly salient parts of it and also to provide updated commentary, given the intervening 2.5 years almost since this evidence was prepared, and on reflection on a few matters over the past couple of days and refamiliarising myself with what I wrote a couple of years ago. So in terms of, if I start at my qualifications, I do not intend to read those out at all. The only thing I'd add to that is that when I drafted this evidence for the New Zealand Māori Council towards the end of, I think, 2019, it was in my capacity as a law lecturer at the University of Auckland, not in my capacity as a lawyer. Since then, I've reverted back to full-time practice, and the only reason I mention that is because I was subsequently, or have subsequently been involved, or was involved in the Edwards proceedings as a lawyer representing Te Whānau Apanui in that case. So Te Whānau Apanui participated as an interested party in the Edwards proceedings, and there was overlap in relation to the claims that were brought by Te Whakatohea. I mention that because the 10 weeks or so that we had to sit and think more deeply about the evidence and the Act and the application of the Act to the messy reality of Māori rights and interests in this space did give me a greater appreciation, I think, than I previously had for the mechanics of the legislation and how it works, as well as its limitations. So suffice to say, I've thought a little bit more about how the Act works and how it applies than I did when I drafted this evidence. We also, of course, now have the benefit of an actual decision in those proceedings, which is, of course, relevant to not only these proceedings, but also aspects of my evidence as well. So I intend to, as I work through my evidence, talk to where Edwards has an impact on my analysis. In advance of those specifics, however, I did want to make a few broad observations on that Edwards decision. So first, I commend the initial decision of Justice Churchman, as well as the hapu of Te Whakatohea and Council, that paved the way for that decision to occur. The way that the threshold tests for CMT and PCRs were interpreted by Justice Churchman were better than I anticipated that they would be interpreted or could be interpreted based on the wording of the Act and overseas jurisprudence and the language that was drawn upon when I drafted my evidence. I think that decision helps alleviate some concerns about Māori getting their foot in the door and meeting the threshold tests for PCRs and CMT. That is relevant because if the wording of the Act had been interpreted strictly, like the way in which a number of the parties, including the Crown and the Landowners Coalition who participate in Edwards, submitted it should be interpreted, which is in that stricter manner, it would be difficult for Māori to obtain any interests in this space, which is of course worse than if you have something. So on the whole, and in the context of the bounds of that existing legislation, that decision I think is a good one. But, there's always a but, I did want to point out the obvious that the High Court decision in Edwards is unlikely to be the last word on how this Act is to be interpreted. There is, of course, the potential for it to be appealed, and if not this case, there will inevitably be case law that goes up the court hierarchy. I am particularly interested to see if the Crown appeals the decision, and if so, on what grounds they appeal the decision, and if those grounds seek to limit the way that that's been interpreted. There are of course, other parties involved in Edwards, including the Landowners Coalition, who was represented by Mr. Finlayson in those proceedings, who was, of course, the Attorney General that was part of the government who passed the 2011 Act. And they argued for a narrow reading of the test, which is consistent with some of the concerns that I expressed in my evidence as to how that might be interpreted. I understand that the Attorney General, at the time that the legislation was being passed, anticipated that CMT, for example, would only be awarded to in respect of a very narrow area of rights in the narrow areas of the takutai moana. If my calculations are correct, the 4th of June, just for your information, is when those appeals need to be lodged by, and then there's 10 working days after that for any cross appeals. I only mention that because it's the second, as you'll already be aware, no doubt, it's only the second decision that has attempted to interpret the legislation that has come out, and in my submission, evidence, there's still uncertainty as to how those tests might be interpreted. I think, though, the more important point to make for the purposes of the tribunal is that although Edwards provides useful precedent on how those threshold tests are to be interpreted in New Zealand, it does not speak to what an applicant group, of course, gets if those threshold tests are met. So those are enshrined and codified in the Act, and whether those rights and the Act more broadly is consistent with te tiriti o Waitangi. So whilst Justice Churchman's effort to centralise tikanga in the application of the threshold test should be rightfully praised, those tests are only one part of the equation, and the decision does not remedy the flaws of the existing legislation. So in terms of my brief of evidence, the first substantive part of it talks broadly about tikanga Māori, and then broadly about tikanga as it applies to the takutai moana. Given the expertise of the tribunal in respect of tikanga Māori more broadly, and the pukinga evidence of specific hapu and iwi that I understand have given evidence in relation to the takutai moana, I have no intention to, what's that Pākehā saying, try and teach my grandmother to suck eggs. Or perhaps, more appropriately in this context, teach my queer to sakapakina. So I'm going to take those parts as read. Suffice to, I think, simply emphasise that Māori, as you'll well be aware by now, are a seafaring people. We come on advanced waka technology and are a small island nation. The takutai moana has always been part of the rohe of Māori communities, has always been utilised and is central to Māori identity. There exists a complex web of varying collective rights that runs the length of Aotearoa, that extends out to the high seas. I do not, in my evidence, intend to wade into who holds those rights. That's a matter for particular hapu and iwi to determine. So any reference I make to Māori more broadly should be read in light of that being held by the particular hapu and iwi as is relevant and appropriate to the particular groups that are involved. What is abundantly clear, though, is that 1840 Māori asserted full authority and dominion over the takutai moana in their rohe, and at paragraph 54 I suggest it's difficult to think of any area in Aotearoa, and the applications bear this out when you look at the maps, where Māori do not consider themselves to be kaitiaki of their rohe moana and to hold mana whenua and mana moana over their rohe. At paragraphs 55 to 65 of my evidence, I set out the tests in the Act. That's a basic walkthrough of the key elements of the legislation. Unless it would be useful to go through them, I'll also take those as read and skip to the analysis part of my brief, which starts at paragraph 66. I know I talk fast, so just let me know if I'm going too fast. In terms of my analysis of the legislation, a PhD could, and I understand now has, thanks to Dr. Downs, could be written on the various dimensions and implications and mechanisms of the Takutai Moana Act, and how it's reduced and limited the rights that could have been recognised under the common law, and also whether it's consistent with Te Tiriti o Waitangi. My brief only picks up on a few of those matters that stood out at the time. So, at paragraph 66, I say case law clearly sets out that the existence and content of customary property is determined as a matter of the custom and usage of the particular community and not on Western assumptions about the nature of property. That is, the existence and extent of any such customary property interest is sourced and determined in the application of tikanga. When one examines the tests in the Act, however, it is clear that on the face of it, the elements of the threshold tests and the effect of the tests simply do not fit the customary reality and the variable nature of the rights that different Māori groups have in the takutai moana in accordance with tikanga Māori. For example, the concept of mana whenua that entails notions of authority, decision-making, control, and the right and obligation to exercise kaitiakitanga, I say is not reflected in the legislation. PCRs are designed to recognise specific activities and are incapable of recognising or providing for the broader and more fluid concept and exercise of mana. And even CMT, although it offers a suite of rights to applicants, if successful in meeting the test, does not reflect mana or even a lesser co-governance or decision-making partnership model. So what I mean by those paragraphs is that the starting point for the expression and recognition of the Māori relationship with the takutai moana under both native title jurisprudence and Te Tiriti o Waitangi should be tikanga. The language that Māori use in respect of the relationship that they have with the moana is the language of mana, rangatira, kaitiakitanga, manaakitanga, whakapapa and whanaungatanga. And if you strip the Act right back, quite simply when you analyse the Act against those concepts and the customs that flow from those, the Act doesn't reflect the nature of those interests held. Instead, it provides for the conferral of a relatively limited and defined set of rights, and only if certain threshold tests can be met. So I give an example of that in my evidence at paragraph 69, where I talk about rāhui. And I understand that rāhui has been the subject of much evidence before the tribunal already, which I do not find unsurprising, given that rāhui is one of the key mechanisms and way that Māori regulate their environment in respect of the takutai moana. It's how they regulate the environment and also control and regulate the behaviour of people in relation to that environment. The legislation is inadequate at actually reflecting and providing for the exercise of that central, long-standing and well-known custom that is directly associated with the exercise of rangatiratanga over a taonga. I do note that Justice Churchman points to the wāhi tapu sections of the Act as possibly being capable of providing for a rāhui, but He also notes how limited the opportunities are in respect of the exercise of the rāhui under the Act. I've reviewed the sections. Certainly on the face of them, they do not work well as a mechanism for the recognition of rāhui or of mana more broadly. That's because the wāhi tapu section requires that the wāhi tapu or specific boundaries and conditions are set out in the Marine Customary Title Order. Rāhui operate in an ongoing regulatory way to respond to arising environmental issues as well as to things such as death. Although the moana has a general degree of tapu associated with it, I do not think it would be accurate to generally reflect the whole area or the whole rohe over which you have mana as being a wāhi tapu, or apply for regular amendments to the court to change it, to add things as rāhui become necessary. So if you're looking for that expression of tikanga and the obvious manifestation of rangatiratanga through the exercise of a rāhui in the legislation, I say it's not simply provided for. In terms of PCRs, I talk about that at paragraph 71 of my brief of evidence. And PCRs are, of course, one of the ways in which Māori rights have been expressed in the legislation. They basically mean you don't need a resource consent for the particular activity, and if others are going to have a more than minor adverse effect on PCRs, then consent is required. In summary, all I really wanted to say about PCRs is that the rights that can be recognised through this mechanism are significantly limited, primarily because there's a multitude of express exclusions in relation to PCRs. So it excludes, of course, activities regulated by the Fisheries Act, which includes all the gathering of kaimoana, largely, aquaculture-related activities, the Wildlife Act, the Marine Mammals Protection Act, and only includes rights that manifest in physical activities. Basically, there is little left that PCRs can sweep up and be recognised. The PCRs recognised in Edwards, I think, supports that. The majority were struck out on the basis that the legislation expressly limited the recognition of those types of rights. So the remnant recognisable rights left were things like collecting firewood, stones and shells, non-commercial whitebait gathering, gathering sand, landing a vessel. There are a few limitations on doing those things anyway. So my conclusion in respect of 74 is that all things considered, gaining a protected customary right is a hollow victory for hapu and iwi who hold mana whenua in coastal areas. The overlay of statutes granting rights to others in the coastal area leaves an extremely narrow arena in which to exercise the legally protected activities. It suggests that the 2011 Act was designed principally to squeeze Māori into the existing legislative management regime with as little disturbance as possible to its framework or to other potential interest rights holders. I'm not sure if that last sentence is phrased quite right, because I think it's not just resource management but the entire legislative existing regime in which they're trying to fit these rights. But the point is, I think, is that the existing regulatory scheme in respect of the takutai moana and associated activities is an extensive one, and PCRs are really designed to fit into the cracks of that existing legislation, which is not an approach that looks at the relationship that Māori actually have with the takutai moana and what Te Tiriti o Waitangi might require in respect of the recognition of that relationship. So from paragraph 75 to 84, I talk about customary marine title. My focus in my evidence was on the difficulty of meeting the threshold tests that are set out in the legislation, and how, if interpreted in the strict manner, it could mean that that CMT is only granted in relation to very narrow and small areas around New Zealand, which leaves Māori effectively with no rights and interests in the takutai moana space. And I also talk about that potentially being a compounding injustice, given that a number of the reasons why Māori may not have been able to meet those tests if interpreted in the strict manner is because of Crown action. The decision in Edwards mitigates some of those concerns in that he did take a broad blanket approach to CMT in an area where there were extremely complex competing rights, both internal to Māori, and it isn't an area that is geographically isolated, like Apanui Ways, where they retain the ownership of the adjacent areas. So the manner in which he interpreted that, where I think he did a good job in centralising tikanga and limiting the relevance of overseas jurisprudence, helps mitigate the getting in the door part of the legislation. He allowed for joint and shared exclusivity, which means that Māori do not knock each other out necessarily if there's shared or overlapping areas in relation to the taku tai moana. And in relation to the substantial interruption test, I think there were some promising findings that were made in respect of the raupatu, not necessarily also knocking Māori rights out as being a substantial interruption. He left open, he left open in his decision how substantial interruption might be interpreted in different circumstances, so we're still not quite sure of the extent to which that will be a barrier to the recognition of rights, but at least in this particular case, I think that was a promising start. So if his interpretation withstands the scrutiny of the higher courts, which inevitably it will be assessed against, some of the criticisms that I've mentioned in my evidence fall away. In my evidence, though, I think one of the major omissions that I've subsequently identified is I do not really address the actual rights that attach to customary marine title, which is that codified set of rights that say this is what you get if you can meet these tests. That analysis, I say, is vital because it shows the disjoint between tikanga and the rights that Māori actually have in that space and what is recognised by the Act as being associated and translated to in a contemporary context. And can talk to those if needed, but I'm sure you've heard submissions or evidence on that already. At paragraph 84, I conclude that analysis section is saying, I think the appropriate starting point into any inquiry into Māori rights would be with the tikanga Māori applied by the applicant group in question. Otherwise, there is a risk that often arises in that zone of interaction between tikanga Māori and Crown law of trying to fit square pegs into round holes. I've since, writing the evidence, heard a better analogy by Rikirangi Gage, who talks about trying to fit Rangi's foot into Cinderella's slipper. The visual metaphors in that are quite good. To me, the associated CMT rights that purport to reflect mana in the existing legislative overlay, like trying to fit Rangi's foot into Cinderella's slipper, is a bad fit. One of the things that I think is relevant is that the issue is exacerbated by the siloed way in which the taku tai moana is approached in legislation and by the Crown in generally. We've got fisheries over here, we've got aquaculture over here, we've got the taku tai moana over here, we've got the Conservation Act over here, we've got the Marine Mammals Act over here. And they all deal with fisheries in the way that Māori interact with the taku tai moana in this extremely disjointed way. And this act comes along last and sort of looks at that framework and tries to work within that, as opposed to looking primarily at the relationship that Māori have with the taku tai moana and saying, what does a treaty-consistent approach to the recognition of those rights in that relationship look like in this broader space? One additional issue that I wanted to raise, though not in my evidence, in relation to the interpretation of the Act by Justice Churchman was the finding that multiple customary marine titles is not available under the legislation. And I only mention that because it has a number of implications that flow directly from that in terms of how Māori engage with the legislation. One of them is that clear and hard, fixed and fast boundaries will need to be drawn. because there can only be one in one place. That is, it doesn't necessarily allow for, you have to put everyone on that title. And so I think that's going to become a challenging proposition, because you're going to have to draw clear boundaries like a puzzle in relation to the takutai moana, which I don't think reflects the really complex way in which Māori actually have rights in relation to that space. What I think that also throws up is the difficulty and irreconcilability of the negotiated pathway with the court pathway as well. And certain groups may be left out. So, for example, in the whakatohia context, Tūhoi have a claim in respect of Ohiwa and the area out and around Whakaari. They chose, that was a direct negotiation pathway claim, not the court recognition pathway claim. They did not participate in the Edwards hearing, and the situation, given that there's now been a finding of one CMT in Ohiwa, is that they won't be able to be let into Ohiwa in respect of that multiple CMT framework now, even if they're pursuing direct negotiations with the Crown, because you can only have one title and that's already been awarded. The only way that that can be amended is if everyone agrees. So you would need to get the agreement of the existing title holders for them to come in. If that doesn't exist, they're shut out, which has some of the implications, I think, of the old Native Land Court, that people with legitimate customary interest in this space cannot have expression or recognition of their rights within this space. The same reasoning applies to the deadline that was imposed. For whatever reason, groups that have legitimate customary interest in this space may not be able to get recognition in this space because they didn't meet that deadline. For whatever reason, including that they may not have had a lawyer that told them that there was an upcoming deadline happening. So I think those are all issues around that arise in relation to how this legislation works in practice. From paragraph 85, I talk about what the treaty requires, and as you'll appreciate if you've read my brief, that's not my thinking in there. So I directly am quoting the 2009 ministerial panel that was appointed to review the Foreshore and Seabed Act in 2004. That panel was comprised of Sir Eddie Taihakure Jury, Richard Boast and Hannah O'Regan, and was informed by over 800 submissions. The reason that I put that in my brief of evidence was because it was a clear report that set out what a treaty-consistent approach might look like, that the Crown was directly aware of when they passed the 2011 legislation. That report was not intended to be the end point, but a catalyst for further discussions. But some of the key points that they made were that the starting presumption was that Māori had lawful interests over the whole takutai moana. For those to be extinguished, that needed to be done so clearly and plainly. And I think of particular note was that they emphasised the requirement of consent, that is the free, prior and informed consent if you're getting rid of people's rights. As far as I'm aware, consent was not obtained by Māori in respect of either the Foreshore and Seabed Act or the Takutai Moana Act 2011, and I think that process, which I haven't, again, talked about in my evidence, goes to another breach of the treaty in terms of how you engage with Māori when passing legislation that affects rights. I talk about the core principles put forward by the panel in support of their suggested approach at paragraph 93. And some of the core principles that they suggest are relevant to how these issues should be dealt with are the principle of recognition of customary rights. So that's a key one, right? How are these rights recognised and translated into a contemporary context? The principle that customary rights attach to hapu and iwi and not to Māori in general. The principle of reasonable public access. That word reasonable in the law is always a tricky one, because what is reasonable to some will certainly not be reasonable to others. The way that that has been actually approached in the Takutai Moana legislation is that public access is the primary right. That's an elevation, I say that's an elevation of what, so that common law right of navigation is part of the common law framework of New Zealand. Common law is subject to and affected by Indigenous rights. So I think it'd be interesting if that had been pursued in the courts as to whether, for example, the ability to place a rāhui should reasonably restrict public access in certain circumstances. What the Act does is elevate that idea of public access to being the primary right given to all New Zealanders. The only limitation on it is and I think, and on my reading of the legislation, is the wāhi tapu provisions, which, as I've sort of already mentioned, I don't think provides well for the way that Māori actually engage and regulate the environment. The principle of equal treatment is something else that they talk about, and the principle of due process, the principle of good faith, the principle of restricting alienation, the principle of compensation, and the principle of the right to development. Some of these have been picked up on in the legislation, others have not been. So, for example, that principle of good faith is about negotiations that had already started under the previous legislation being honoured. The Crown has attempted to do that through the Ngāti Porou legislation, and there was an agreement with Te Whānau Apanui that is also being pursued through treaty settlement negotiations. But others, less so. So, for example, compensation. And I understand that there's very little provision for that within the legislative scheme. The panel went on to make a number of additional suggestions, including the establishment of a bicultural body to oversee the coastal marine area and develop proposals for a national settlement that could provide for a percentage of income streams to be set aside for the benefit of entitled hapu and iwi. I think that idea was drawing on how the Fisheries Act came about, and the creation of Te Ohu Kai Moana that was to work with Māori in respect of how fishing rights would be allocated. Mechanisms to provide for interest at the local level, including co-management between Māori and local government of particular areas of foreshore and seabed. Regional negotiations between hapu and iwi and the Crown. Customary uses being provided for through things such as exclusive reserves under hapu control or by provisions prescribing general harvesting rights by regulations. Customary authority being supported by the full right to manage reserves and regulate customary activities and to be fully engaged in the management of coastal marine areas. Ownership of the foreshore and seabed, that was just a final point, requires a negotiated solution. At paragraph, just sort of a final point on the panel, one of the things that they didn't engage in significantly is around the questions to do with the legitimacy of sovereignty of the Crown or the relationship between kāwanatanga and rangatiratanga. Given that, I think my conclusion in the final paragraph that the findings are consistent with shared sovereignty is perhaps overstated, given that wasn't engaged with specifically. But this report was a starting point for a greater kōrero on what a treaty-based approach might look like, and ultimately key aspects of that framework proposed by the panel were not adopted by the Crown in the passing of this legislation. So I apologise for adding a whole bunch more to what I originally drafted, but yeah, that concludes my evidence as in the primary sense. Kia ora.
Thank you, Ms. Coates, for your evidence and for the updates you've provided. They've been extremely helpful to us. So as you've already indicated, there are a number of lawyers who would like to question you about your evidence. Now, I had Ms. Thomas as the first lawyer. Is she present?
Oh, ka pai.
Kyle?
One down.
Okay. So the next I have is Tuko. So who's going to be questioning Rangatika iu, kai a koe.
O tēnā koe te hoa, e te pakehiwi maere, Ms. Coates, tēnā koe. E mihi ana ki a koe i tō taenga mai tēnei rā, ahakoa ngā taumahatanga kei runga i a koe, ngā whakaro nui ki tō hua pūmau, a Kiritapu. Ngā manaakitanga te wāhi ngauro ki runga i aia, ki runga i a koutou ko te whānau i tēnei wā haere a kene. We represent Tuko Law, and we have 7 groups in this inquiry. So just for your benefit, that's within Te Tai Tokero, also Hapu within Ngāti Maniapoto, and your relations in Tauranga Moana, Ngāti Rangi. So my questions, e te kai whakawā i paina kia noho? So my questions are going to focus on the treaty framework produced by the 2009 ministerial panel, and you have touched on parts of this in your presentation, and thank you for that insightful presentation. We look forward to discussing that further with you in due course. So you acknowledge at paragraph 90 of your evidence that the panel sidestepped the question of the issue of sovereignty. Would you agree that ministerial review panels are generally bound within the confines of Crown sovereignty, so with seriously challenging Crown authority?
I don't think that is necessarily written into terms of reference, so could potentially have the capacity to suggest beyond that, but they tend not to. Yes. So just to, I guess, expand a little bit on that, I think that issue of sovereignty and rangatiratanga is one of the big issues that needs to be grappled with in this space, because ultimately the rights that Māori had in respect of the takutai moana were the rights to exercise control over the entire space. And so what that means now in the context of contemporary New Zealand, I think a challenging one that the treaty is supposed to provide the answer for.
Yes, and that's the importance of highlighting this issue and this inquiry. And so moving on to the question, do you agree, and you did touch on this, but just for the purposes of clarifying, do you agree that the recommendations of the panel were primarily its own perspective because they had not fully yet explored that treaty framework with Māori?
Yes, and I think the panel acknowledged that that was a starting point as well.
Yes. So you are aware the panel, you did say this, supported a longer conversation with Māori, and on that treaty framework for the takutai, you agree with that?
Aye.
Do you accept that the legislative process for MACA was undertaken in a very short time frame?
Yes, my understanding is that it was.
So moving on, coming to the nature of how that conversation would take place, and I note at paragraph 96 of your evidence, you talk about a shared sovereignty model, and you just clarified your views on that. But you talk about the Treaty of Waitangi being the base of any future model. The claimants that we represent in this inquiry, they speak to te tiriti, that being the document that was signed and understood by their tupuna, and that view has subsequently been upheld in Y1040 and other treaties. In your view, in order to give mana to the claimants' views of te tiriti, and with the view of evolving treaty jurisprudence, do you agree that the Māori text of the treaty ought to be the version that a framework for the takutai moana is to be evolved from?
Yes. I note though that that the English text isn't irrelevant. It's also supposed to provide for property rights and the expression of them, and I don't think it has the way that the legislation codified and provided for those. So I think there's a relevant level of support and assistance, or bare minimum threshold that's also breached in relation to the English version. But in terms of the foundational way in which this should be looked, I agree that's the Māori text of the Te Tiriti o Waitangi.
Kia ora. And finally, this is my final question. Do you agree that any discussion about how Te Tiriti applies to the governance and management of the takutai moana ought to be between Te Tiriti partners and the Crown?
Yes.
Tēnā koe. Those are my questions, Your Honour.
Kia ora.
Tēnā koe. I see the next on the list is Miss Black.
Tēnā koe, sir. Tēnā koe, Ms. Coates. My name's Lisa Black. I work for Benny & Law. It's very nice to see you in person after emails and phone calls and what have you. No, kia ora. I have two sets of questions. And the first set is on the Edwards Whakatohia decision. Thank you for your update. It sounds as though it was quite lucky that the decision that sets the precedent, sets so much precedent, took as much of a tikanga-centred approach as it did. Would you agree with that?
Yes, I do. Pleasantly surprised by that decision.
Kia ora. In your view, is it appropriate that recognition of Māori rights comes down to the luck of getting the right judge?
Yes. I mean, that's not ideal. That's not ideal. Could it have gone other ways? I think all of the academic commentary that has been given.
Kia ora. So, in terms of the permission to use part of that statement, the principle that permission to use the taonga, could that refer to permission stemming from either a property right or a governance right?
The reason I'm pausing is because these terms are being phrased in the language of Pākehā terminology instead of tikanga. So I think I've sort of broadly touched on the point, but native title and the jurisprudence that has developed in respect of that is limited because of the way that the hierarchy of laws exists in New Zealand. That is, that form of right is a common law right, and legislation is elevated above that, which is why I think there's the challenges and the way that the rights have been translated have been about fitting into the existing legislative scheme, which is, I think, a different question than what is required under Te Tiriti o Waitangi, which is about the rangatiratanga of taonga. So I think my answer is yes, but I think it's hard thinking about those terms in terms of property rights and governance, because I think tikanga as a system of law is broader than the way that it's currently being recognised in the limited way in the state legal system.
Oh, thank you. That's extremely helpful and precisely what I was getting at. So,
Ms. Black, I don't want to interrupt your flow, but I see we've reached the time for the morning adjournment. So perhaps we will adjourn and you can continue your questions after the break.
Thank you, sir. I think Ms. Coates has pretty comprehensively answered the rest of my questions with that statement. So
does that complete the questions you have?
It does, sir.
Okay. Oh, well, that's helpful as well.
Kia ora.
Well, thank you, Ms. Black, and thank you, Ms. Coates. We will take the morning adjournment and we'll reconvene at 11 a.m.
Tēnā koe.
Catch the latest seasons of Grey's Anatomy only on Star on Disney+. More Meredith.
Me?
More Bailey.
Perfect.
More new season 17.
Damn.
Streaming exclusively every week.
You won't regret it.
Now there really is something for all of us with Star on Disney+.
Looking for new songs? YouTube Music is your personal guide to the world of music. Built to help you find exactly what you're looking for. Sign up for YouTube Music and upgrade to Premium for 1 month free.
I just wanted to thank you.
Lovely to see you.
Mr. Melvin.
Tēnā koe, Ms. Coates.
Tēnā koe.
Mr. Melvin for the Attorney General, for the Crown, in the wrong jurisdiction, sorry. I'm sure the Attorney General is paying close interest in any case. Thank you for your brief of evidence and your additional kōrero this morning. In your brief, you're critical of the Act, it's the current 2011 Act, for not reflecting the concept of mana whenua. So you address this around paragraphs 68 to 70 of your brief. you also say that the question of who has mana whenua can be complex because there are different mechanisms by which mana over an area is acquired and retained. I think you say that earlier in your evidence. And that in determining which tribal groupings held mana whenua over a particular area, one has to apply various take and evaluate competing claims of right. And in your discussion of tikanga in relation to the Takatai Moana, you say at paragraph 43 that there exists a complex web of varying collective rights that runs the length of the New Zealand coastline and extends out to the high seas. I might just close that door because So if mana whenua were used as the test for establishing customary interests in the Takatai Moana, instead of perhaps the current test of exclusive use and occupation, there would still be significant complexities in determining the nature and extent of rights that groups have in particular areas, wouldn't there?
Yes, that's Māori society.
Yes. And do you agree that had neither the Foreshore and Seabed Act nor the current Act been enacted, then the New Zealand courts would still have needed to have grappled with these complexities when considering claims to customary title to the Takatai Moana in a immediately post-Ngāti Apa situation?
Yes, because the decision was that the Māori Land Court has jurisdiction to hear these types of claims. But I think, as I said, there's two parts to it. One is what could be recognised under the common law, and the second part is, given the relationship that Māori have to the Takatai Moana, what does Te Tiriti o Waitangi require?
Do you have any insights as to how the courts might have dealt with those complexities?
Mana whenua?
Yes, and
well, there's little case law in the New Zealand context, obviously, on that, which is why, in terms of talking about the limitations of it, people have drawn from the Canadian and Australian jurisprudence where it's more developed. But as I sort of said as well, and I think this is where Justice Churchman got it right, he distinguished those, how it's developed overseas to the continuing developing jurisprudence here, of which I think there is increasing case law that is better conducive towards the recognition of customary rights through the court framework. But of course there's challenges. There's challenges in figuring out what these customs are and how they translate into the common law framework, as well as a Te Tiriti o Waitangi framework.
And as you've noted in your evidence today, challenges dealing with the complexities of the contemporary world, the existence of many other, multiple users of the Takatai Moana.
Yes, that's right, and I think the current constitutional framework that exists in Aotearoa, New Zealand, being another challenge in terms of that not necessarily reflecting Te Tiriti o Waitangi either.
And do you have any insights as to how those multiple interests would be, how the challenge of dealing with those multiple interests could be achieved successfully in developing a framework for rights in the Takata Moana?
I mean, I think it's easier to identify problems with it sometimes than solutions. But in saying that, I mean, the panel did make the panel in 2009, I think it was, made a number of suggestions as to how that can be dealt with and some of the key principles that could be followed in developing that framework. So it's not an intractable, impossible issue to resolve. And I think even just looking at the way that that act is being applied now, there's a multitude of things that you could say could be better and more reflective of a treaty partnership.
You touched on Rahui this morning. Would you, and you've identified what you say are limitations in the legislation in terms of its ability to recognise or give recognition to the imposition of Rahui. But would you accept that it remains open to Māori communities to continue to impose Rahui outside the framework of the Act?
Yes, and they still do. We saw that most recently at home in relation to the eruption of Whakaari. So I think that speaks to the issue of pluralism in Aotearoa and the state legal system and what it operates and enforces being separate to the operation of tikanga Māori, noting that there's now significant overlap and we're trying to figure out how those two intersect in an appropriate way. But yes, Māori will still keep doing what they're doing regardless of what the legislation necessarily says. But that doesn't mean other people necessarily respect that, particularly given the Act guarantees things like public access when Rahui are designed to limit and exclude that.
Yes, although the Wāhi Tapu provisions in the Act are an exception, provide an exception to the public access guarantee, and Wāhi Tapu conditions could be imposed to give some recognition to Rahui, couldn't they?
I don't see how, based on the current wording of the legislation, and I note Justice Churchman being optimistic about that, but in terms of the legislative framework, Rahui does not fit neatly into that, because it's about the authority over the entire rohe, and the particular provisions require the identification of specific boundaries and conditions, which is something that is evolving.
So it would have to be within the confines of a specific area relating to a Wāhi Tapu or a Wāhi Tapu area. But
yes, that's right. But I think the way that Rahui operates is that the tapu changes over depending on where the particular area is. So if an environmental Rahui is required, that moves. So I guess in terms of the way that the legislation it seems to be designed to recognise particular permanent wāhi tapu areas as opposed to the active way that Māori engage and govern the takutai moana through concepts such as rāhui.
There is, though, at least the possibility that a wāhi tapu condition could be that public access is restricted to a wāhi tapu or wāhi tapu area when rāhui relating to that area is in place.
So, yes, it is potentially possible to draft a condition that says within this entire rohe, we can place rāhui as and when is required. I don't know if that is consistent with the way that the drafting of the legislation currently works. If it is, that's great.
Well, no, I'm not suggesting it could be done in respect of an entire rohe, but within the wāhi tapu areas or wāhi tapu specified wāhi tapu locations recognised through the wāhi tapu protection provisions of the legislation.
Yes, that's right. So there may, for example, be a particular ana or cave that is tapu, but that kind of reflects that permanency of a wāhi tapu place as opposed to the dynamic way in which rāhui occur under tikanga.
Just coming back to the situation immediately following Ngāti Apa, would you say, given that there is little New Zealand jurisprudence in terms of customary rights, that it's difficult to predict how the New Zealand courts would have dealt with claims to customary title in the takutai moana?
Yes, I think it's always difficult to predict how courts are going to deal with matters. That's why we exist. To complicate things.
You're talking about lawyers?
Yes.
Now, at paragraph 74 of your brief, you talk about the overlay of statutes that exists. So this Act is part of a much wider framework of multiple statutes that relate in numerous ways to govern and regulate and protect and address issues relating to the takutai moana. And you say the overlay of statutes granting rights to others in the coastal area leaves an extremely narrow arena in which to exercise the legally protected activities. And there you're referring to protected customary rights. But would you agree that the reference to others in your sentence can and does include Māori, and including hapu and iwi?
Yes, I'd probably amend that to say granting rights.
And I'd just like to pick up on a point that my friend Ms. Black put to you, that it was a matter of luck that applicants in the whakatohea proceedings got the right judge. That it's not really a matter of luck, is it? Because judges come to their job under an oath to exercise or to come to their judicial task objectively and fairly, and to uphold the law. And that's essentially what Justice Churchman has done, isn't it? He's been guided by what he considers the law to be.
Yes, that's right. Although I do think it speaks to jurisprudential ways in which you conceptualise the role of the judge and whether you're a positivist or a realist. But overall, judges go to the job with the intention of applying the law as they see it, and he did that. But that doesn't mean, as we've seen, that different judges could interpret things in a different way.
And you suggested that he might have been influenced by the fact that his decision could have been appealed, but
all judges are influenced by that.
It's not a primary influence, though, is it?
No. All I was meaning there was that I think the trajectory of jurisprudence and the development of the way that tikanga is looked at in the law is changing, and part of that has to do with the way that the Supreme Court and upper courts, including the Court of Appeal, are starting to look at these issues in a positive way, I think.
And all legal systems, and all systems of law and LAW law and LORE law evolve.
Yes, although... Oh, sorry, you were going to ask a question.
That's the question.
Yes, although I've always rejected the putting of tikanga into the LORE category.
Yes. No, I didn't mean to categorise
but
it that way.
They evolve, yes, for sure.
There's been a lot of criticism in this inquiry about the fact that applicants under the Act must apply to the High Court as opposed to the Māori Land Court if they are seeking the court determination pathway. There's a long history in New Zealand in the general courts, isn't there, of those courts recognising and upholding Māori rights and interests?
I wouldn't say that that's long in terms of if you took all the cases on a few hands and added them all up, but certainly the courts have been grappling with these in various ways over the years. But the Māori Land Court does that as its bread and butter every day.
But it's been grappling with them for since
the conception,
since the beginning.
Yeah.
We've heard in evidence this week from Dr. Frame, for example, the case of the Bordick case, which recognised Māori custom in terms of stranded whales.
Yes, I think I was probably referring to not the length of time to which it goes back to, but the quantity in which these issues have been addressed.
Yes, and that will in part reflect the fact that not many cases have gone to the courts in terms of Māori custom, which is a point we touched on earlier, isn't it?
Yes, and I think that Māori are strategic in that respect, and that they don't go to places where they're unlikely to get recognition. And I think the increasing recognition is now meaning that Māori are increasingly taking these types of cases to the courts because they're being recognised in a better way than they have been in the past, as we've seen from case law.
But you don't reject the proposition that the general courts have a tradition of upholding Māori rights and interests?
Not always. We parata, right? And there are cases that are pepper-potted throughout history that speak to recognitions, but there's just as many that speak to the limiting of Māori rights and interests as well.
Tēnā koe. Thank you, Ms. Coates.
Kia ora.
Thank you, sir.
Kia ora, Ms. Coates. The principal focus, as I understand it from your evidence, is on the starting point, really, of being mana whenua for the issue of what's the best way of dealing with Māori customary rights. And it interests me that the response really, it seems, from the Edwards or Whakatoia decision by Justice Churchman was to accept a recommendation by the Pukenga that a Pou Te Rāwhare construct was used to avoid grappling with the issues of hapu iwi. And and he then concluded that, and it seems to me, and correct me if I'm wrong, that he then concluded that the best way of dealing with the CMT issue was to have the single CMT issue identified, and which he duly did. But it does seem to me, have you got the decision with you or not?
Yeah, I do.
All right. If you have a look at paragraph 169, he concludes that the structure of the Act is consistent with a jointly held CMT rather than two overlapping CMTs for the same area, each held by different parties. And then he says, if there were multiple CMTs for the same area, then there would be practical problems with the exercise of rights which flow from the grant of CMT. But he doesn't seem to give any, unless I've missed it, he doesn't seem to give any reasons for or describe what those practical problems are.
No, I didn't see that either.
Right. And I may be being unfair to His Honour, but it seemed to me that the practical and immediate practical problem was indeed that very one of the raruraru between the hapu or hapu iwi slash of Te Whakatoia, which he avoided neatly and on a recommendation from the Pukenga of the what he described, or they described, as a construct, the Pou Te Rāwhare. And but I didn't see in the judgment either, and again, correct me if I'm wrong, any analysis or any consideration of the 2 points you've made about the potential for cutout of people, and I'm obliged to you for the reference to the Tūhoi claim, or those who might have missed out through the deadline. Is there any discussion that I've missed?
There's no discussion that I've seen in relation to the deadline, because it's a statutory one upon which he can't really, I guess, deal with. In terms of the interests of others that might be left out, he somewhere in here, I can point out the references perhaps later, but he does talk about the fact that people who do have overlapping rights or have pursued different pathways at least get notification, and so could participate in the case before the court. So Tūhoi could have participated even though they're not pursuing even though they're pursuing a different route.
Yes, I did see that, but
yes.
but that
doesn't solve the problem.
No. The decision doesn't seem to address the problem that you've identified of, well, how on earth under the Crown pathway did Tūhoi have any opportunity of advancing a claim for a CMT when there's a judicial finding that there should be a single CMT for that area?
Yes, that's right. And given that the legislation then subsequently goes on to say that or set out the limited ways in which CMT can be amended, there's barriers if the Crown finds, through their negotiated pathway, finds that they do have rights and interests deserving of recognition. How do they reconcile? That's not provided for under the Act or addressed in the decision.
And when we look again at the statement that he makes, if there were multiple CMTs for the same area, there would be practical problems with the exercise of the rights which flowed from the grant of the CMT. I would have thought that those very same practical problems are now squarely before those members of the Po Te Rāwhare and, in due course, the High Court, because they've been asked to come up with a draft order which requires them to reach agreement, so that the practical problems still remain, do they not?
Yes, because ultimately the rights that are associated with do you give permission for this resource consent to go ahead? If there's multiple groups that have the right to say no to that, you deal with that either inside of the Po Te Rāwhare model, or if that didn't exist, you still have to get the same group of people together to, I guess, agree a path forward, or at least each has the right to say no to that and give a veto right if the rights thresholds have been met, which in this case they said it has. So I think you're right. Either way, you've got to grapple with the problems of how these rights manifest themselves and how multiple groups who might have multiple interests in one space exercise their rangatiratanga in respect of the rights that are associated with the legislation.
The other concern that arises out of this concept of the Po Te Rāwhare that was used in the Whakatoia situation is if one translates that to almost any other area, whether it be Taitokoro or Te Tauihu or large areas, there's no guidance in this decision as I see it, and you correct me if I'm missing it, there's no guidance as to how one decides where are the boundaries of a Po Te Rāwhare.
Yes, and of course the boundaries issue was one that was reserved for a hearing next year, so even the Edwards decision hasn't decided on where those boundaries might exist. That is, between this area and this area, where he's found that 6 hapu have interests. Do they all have interest over the same place, or are there areas within that are delineated? And then how those, as a party that has a bordering, represent a party that has a bordering interest, what direction that line goes in, because ultimately that line will determine whether Te Whānau Apanui and Ngaitai who border that boundary fit in or not. So
and Ngāti Awa on the other side.
Yes, exactly. So ultimately it's going to involve, as I said, this sort of creating of this puzzle where you're drawing out different hard boundary lines between where people have interest and do not.
Yeah, and the point you make of particularly for Ngaitai and Whānau Apanui is if you get a curve in a coastline, of which there are numerous around the Motu, then there's going to be an intersection.
Yes, and does that mean then we need to draw out a bubble in the overlap in terms of a boundary line, and that becomes a separate joint title, or how that works is complicated because of that one CMT finding.
Right.
Which I think is where he had to land based on the language of the Act, but it's a limitation of the Act.
I must admit, another issue that just arises, I mean, there's the whole treaty issue of whether or not the Tūhoe situation is, or whether a treaty consideration arises out of that, but also just a natural justice situation as well, and that their rights, you would assert, as I understand what you're saying to us, you would assert their rights have been trampled in reality because they just now don't have a door open to them.
Yes, I think that's right. In that I'm not asserting, I'm not aware or don't have evidence of what their interests are in that space, but the fact is they've pursued a direct negotiations pathway and now appear to be locked out of Ohiwa because their CMT has been granted there in the High Court.
Yeah. It just rings a bell with me, and an unfortunate bell, because as counsel once for an applicant in respect of the tendering of bus contracts for schools, I took a review case to the High Court where we were successful against our people being unsuccessful. The successful tenderers were not served, taku here for that, and we ended up with a 6-day case in the High Court, then an appeal to the Court of Appeal. We get to the Court of Appeal and Justice Cook says, well, where are the successful tenderers? And I said, well, I hadn't served them because they didn't have the contract. And he said, well, you've got to go away and go and serve them all and make sure that they are here, or at least have that opportunity. But your response, as I understand it, to that is, well, Justice Churchman has identified that Tūhoe had that opportunity and they had that statutorily, and that might address the natural justice issue.
Yeah, I mean, he doesn't mention Tūhoe specifically in the legislation, but he talks about the fact that Ngāti Awa, even though they weren't seeking to have their rights determined in the Edwards proceedings, they participated as an interested party. He included them in the award despite them not seeking that interest. So because they were there, he felt comfortable doing that, but the fact is that Tūhoe, for example, weren't there, and so to the extent that they may have had any interest in that space, they're now left out of that area on the way that that's been interpreted.
Different issue, if I can. You've drawn attention to the panel's, the review panel's recommendations, and I just wanted to ask you about if you could turn to your paragraph 94, and it just intrigued me, and I couldn't recall, and it's only triggered my mind rereading your evidence and hearing you today, that the panel had recommended the establishment of a bicultural body to develop proposals for a national settlement. And can you assist in terms of why that was bicultural, whereas if you look at C, that's a regional negotiation recommended between Hapuniwi and the Crown as representative of the public interest. Why the difference between the two? Do you remember?
I would have to go back to the report.
Oh, that's all right. If you can't remember, I've got to go back to the report. So
but I think,
right.
Yeah, I'm not sure. I think what they were trying to do there was to basically suggest that, yes, there should be a national settlement, and there needs to be a body beyond just the panel that works out, kind of akin to the way that the fisheries model developed, what that should look like in that national settlement sense. But I can't remember more than that. Apologies.
No, that's right. Any other two matters that I wanted to just seek your assistance on related to the statute? Have you got it for you or not?
Yes.
One was just in the terms of the wahi tapu, if you look at the interpretation section, section 9, I've got that right? Yes, it is 9. It's defined as having the meaning in section 6 of the Heritage New Zealand Pohere Taonga Act 2014. And have you looked at that or been engaged as counsel at all with that interpretation or the way the courts have looked at that in the past?
No.
It uses terminology from memory of sacred, and my understanding of the court's approach has been, and I'll read it to you, wahi tapu means a place sacred to Māori in the traditional, spiritual, religious, ritual or mythological sense. So that's traditional, spiritual, religious, ritual or mythological sense, but a place sacred to Māori. And my understanding of the way the courts have, both in the RMA sense and more generally, looked at that type of situation is that they've required specific evidence as to detail as to what makes that particular place sacred as distinct from another. Have you been engaged in any of that type of litigation?
No, I haven't,
All right.
personally. But again, I think there's that distinction between kind of taking out terms from tikanga such as wāhi tapu and defining them in legislation and seeing that as a kind of manifestation of a custom as opposed to looking at it in the systemic sense and the way that tikanga operates in that interactive way.
Mm. And as I understood the exchanges you had with Mr. Melvin in terms of your response on the wāhi tapu issue and rāhui issue, you're saying, well, rāhui, particularly for conservation purposes in relation to natural resources, do not lend themselves to that identification of a level of sacredness, if one uses that terminology in that legislation.
I mean, ultimately, the placing of a tapu over an area for conservation purposes does attach a level of sacredness. But I think the issue is more the dynamic way in which tikanga operates, which I don't think the legislation provides for.
Right. All right, I think it was the final point, but another one might crop up, but it was section 94.2. And I'm not sure the reason I'm drawing attention to that and seeking your assistance, sort of your views on it, is that Justice Churchman in a number of places, and you've made the observation today in response to Mr. Melvin, has said that the mere fact that a CMT or a PCR may not have been able to pass or be granted because the threshold test could not be met won't prevent Māori being able to carry on their own customary rights. And I just wanted to, and I'm not sure whether you heard yesterday a question I posed in the RMA sense, well, I'll pose it again to you. If one contemplates an applicant for a resource consent or a suite of resource consents for a major development being challenged by Māori because of the adverse effect on a customary right, which was not protected by a CMT or a PCR, what weight could a decision maker give in terms of upholding that objection on the basis of adverse effect on a customary right without that statutory protection, given the provisions of section 94.2?
Thinking on the fly.
That's why you're there.
Section 94.2, it only talks about protected customary rights and customary marine title, which are defined by the Act as being recognised by the Act, and therefore those things that fall outside of those definitions, such as I would say rāhui, don't fall under that section because they're not protected customary rights or customary marine titles. So that section wouldn't necessarily preclude, I think, their consideration in contexts such as that, because it's still a right that exists under tikanga, which more generally is part of the common law of New Zealand.
Which could still be given recognition under Section 6E or Section 7 of the RMA.
Yes, and I think the Court of Appeal decision in the Trans-Tasman Resources case can assist a little bit with that question, because they spend quite a bit of time there, the Court of Appeal, talking about how tikanga can be recognised in that EEZ context because it's sourced, and I can provide, maybe email the particular provisions of that decision.
Yeah, no, I've read those.
Yes,
yeah.
well, I think that helps a little bit with that question, in that they do talk about tikanga as being sort of separate to the way in which it's been recognised in the legislation, which I think is what that provision is intended to cover. I don't know what practical that effect that has, that section 94.2. But I do think that tikanga exists separately to the way that it's manifested and recognised through protected customary rights or customary marine title.
Right. Thank you for that. And just if I can... possibly there is one last question. Section 51 2E, if you would. So it's an exclusionary provision that a protected customary right does not include an activity E that is based on spiritual or cultural association unless that association is manifested by the relevant group in a physical activity or use related to a natural or physical resource. What impact does that have in terms of rāhui?
I think that's a good question, because rāhui often it's a change of status of an area, not an actual activity. It prohibits an activity, but is not activity in itself, apart from the karakias and things that are done to place there. So it's the placing of the tapu as a status that has those spiritual and cultural associations associated with it. So I'm not sure whether that excludes rāhui or not. It potentially has the potential to.
All right. Thank you very much.
Kei te tuakana, tēnā koe. Tuakana Ngāti Awa nei. Tēnā koe. Ka nui te mihi atu ki a koe me o kōrero mārama pai mō ēnei kaupapa. Most of my questions have been asked, but I do want to ask you some questions around the so you used the tūhoi example, and not because I'm tūhoi, but I'm actually just interested more from the perspective of over the course of this whole hearing. Since we started, we've listened to many claimants talk about being forced into either the High Court or the direct negotiation process. So I'm more interested in that. You raised the issue around when you wrote your brief of evidence that you had some fears that they'd have a strict view of the legislation, and pleasantly surprised a more centralised tikanga Māori judgment being put out there. But one of the things that occurred to me as you were talking about the example of the exclusion is whether you, for other iwi or claimants who have put in through the direct negotiation, whether they, this will set the precedent that is basically going to cut them all out of CMT more broadly, and that will end up back here again, looking at more breaches because it's not treaty focused or tikanga focused in that way. Just your comment on that.
So you mean the impact of this particular hearing, or the impact of the application of the Act in relation to treaty breaches? Sorry, I'm trying to get where your question's
the example you gave of tūhoi being excluded because they took direct negotiation
whether
pathway.
they might come back as a result of that, saying, look...
Oh, I'm just talking about others, not about tūhoi. I'll just put them aside for now. I'm talking about other claimants who've come here to... who chose direct negotiation because they couldn't afford the High Court process. Those who do end up in the High Court get a similar judgment. They, by default, based on how I understood what you said around the tūhoi example, could also be excluded. And consequently, we end up, this hearing goes on and on because they'll be taking more grievances against that for following a process that the Crown had offered them.
Yes, I think that's right. A lot of people, from a strategic perspective, put in claims for both, and largely that was to see which one panned out better. Māori are strategic like that. But for those that did, because they have a relationship with the Crown, choose that particular path, for example, and not the High Court path, there's potential problems if the gun is jumped in the High Court and their claims are not heard or considered in that forum. A factor that Justice Churchman put weight on was that even though they didn't choose the High Court path, they can participate as interested parties, but I think that becomes problematic because they don't have a claim to be determined in the High Court. So even if Tūhoi participated, Justice Churchman and found that they had interest there, he can't grant them that CMT. So what then happens in terms of the granting of an order? Do they get included in anyway? I don't think he has jurisdiction to do that. And so I think there is that complication in the Act that means that rights, like under the Native Land Court, can be lost in terms of the way that it's actually applied in accordance with the legislation. And that will be another treaty claim, that they've lost rights through a process that the Crown said that they should follow to try and have recognition of them.
Thank you. Again, if we put my tribe aside, because a number of the claimants that did come in were whānau and hapu claims and probably don't have the infrastructure that settled entities or governance entities could have had to actively participate, as you say. I suppose my questioning was around what will happen to those smaller groups, you know, that might not necessarily have the strategy or infrastructure to support them. That was probably where my question was. Less around the more established ones, but yeah.
I think that's a real problem and ultimately comes down to how well the Crown funds some of these groups to participate and bring on legal expertise to help them traverse and gain recognition of their rights and interests in this space. And I'm sure you've heard evidence on the pitfalls of that Crown funding model.
So just back onto your brief of evidence, particularly around paragraph 36 and around whakapapa. Yesterday we heard from Dr. Frame and his discussion around different narratives as the kind of starting point for the customary law and his suggestion that the further back the narrative kind of gave a sense of the principle of priority and centrality. So around what you're saying in terms of that paragraph, ultimately we could all be included in that depending on what the starting point of whakapapa is.
That is, everyone has rights everywhere?
Pretty much. Just because you're giving evidence for the Māori Council, so you know you don't have a
but
you don't have a clearly defined boundary yet.
But I'm also giving evidence as I think I said I abide by the High Court rules, which means I don't advocate for a particular party. I mean, I don't understand the Māori Council's claim. I'm not their lawyer. But I don't think it's right under tikanga to say everyone has the same rights everywhere. People exercise, or groups exercise, mana and rangatiratanga in a complex lattice of rights, and come together for different ways and for different purposes. And where those rights sit is something that needs to be determined, I think, on a case-by-case basis. Because there are certainly areas, and I act for some clients who claim this, that they have mana whenua, hapu have mana whenua from this area to that area. And that means they have all the associated rights of paesinga rāhui, autonomy and authority. And the idea that you can step back to the waka and everyone has those rights is something that would be rejected.
That's not what your paragraph says, though. That suggests that you could go all the way back to your waka or to rangi and papa based on that.
Yes, you can whakapapa back, but I don't think the manifestation of rights and the principles of tikanga means that everyone has mana in that space because of that whakapapa. It means that there's a complex relationship along whakapapa lines, which might mean that you do let your whānau in to come and get a feed. Right? That's whakapapa and whanaungatanga going back to those traditional old relationships. But it doesn't mean that they have the right to put a rāhui in your rohe.
Hapai, good to see that you're still a smart student.
She was my tikanga lecturer at the University of Otago.
Tēnā koe, nā mihi kia koe.
All right, let's test how good she was. Kia ora, Miss Coates, pai te kite anō i a koe.
Tēnā koe.
Ka mihi kia koe. Kei te mōhio koe ki te tau o mātātua e ki ana. E noho ana i te kokoki o hiwa whakaoro uruara aku tāringa ki te tai o tuara o kānawa. E a ki ana mai ki utara ki te whānau a Tairongo. I'll just pause that there. And just go back to a question that the Crown asked you regarding mana whenua. And I've forgotten the length of the question and the real significance of the question, but it got me thinking about mana whenua and mana moana. Because one is brought up, one is taught that if you have mana whenua, and your whenua happen to be on the moana, you also have mana moana. And that is entrenched in the pātere that I've recounted to, part of which I've recited to you, that states that the mana lies with the whānau a Tairongo. 1, 2, and that the places outside of the whenua in the ocean are actually named after people. That gives a real significance. And therefore, the whānau a Tairongo would argue that that is my mana, because it states that the takutai or the moana is called tuara and called kanawa, and it crashes on the shore, upon which the owners are Tairongo. Now, MACA comes along and says the takutai is unownable, I think in your words. No one owns it, a bit like water, eh? Everyone owns water, or no one owns water.
Which is still disputed.
Is that similar?
So, in terms of the water, that's my understanding a policy position of the Labour government, not the law yet. But I think the idea behind it is the same, and I think it derives from the Pākehā understanding of the commons. That is, you don't own commons of which water is one and the sea is one. But that doesn't align with Māori thinking necessarily, which is not spoken about in terms of ownership, but in terms of authority and control over, which attaches rights to it and responsibilities.
Yeah. All right. Yeah. And then there's, you mentioned public access. The public must have access. Heka, nōku te whenua, nōku te takutai moana.
Yes, and I think that that what the Act does has elevated what is a common law right recognised under Pākehā law to legislation, which, in the way that the state legal system views that, now trumps all other rights recognisable, which includes Māori rights, which are also recognisable under the common law. So I think, and this is something I understand the ministerial panel explored, was that there are different ways of understanding Te Takutai Moana. Māori look at it as their own, as the rohe that they have mana over, that they can exercise control over, that they own, if you're talking about it in a Pākehā sense, that they can exclude people from through the exercise of their mana. But New Zealanders more broadly have come to expect that they have a right to go there. And so there are two different perspectives of that space. And the question is, I think, whether those need to be reconciled.
That's my question.
And my answer is not necessarily, and that was the answer of the panel as well, that recognised that particularly where rights are recognised under the state legal system in that proprietary sense, why, and on land, everybody has that right to exclude people, is the moana different in that respect? Māori see them as interconnected.
Yes. And we talk about whakapapa, and we talk about rights of whakapapa, and do those rights diminish over time?
Whakapapa rights?
Yes. Let me just unravel my my question to you. Just because you have whakapapa to an iwi or a piece of land doesn't mean to say that you have rights. Your comment?
I agree with that. I think whakapapa forms the basis of relationships that you have with whenua and with people. But I think one of the problematic Pākehā terminology is rights.
Yeah.
And the way that Māori tend to look at the world is not only what you can get from that, but what you give to that in terms of the reciprocal relationship that you have with the whenua. And to have that relationship, you need to, for example, exercise ahika and keep that warm. And so I think within Te Ao Māori there does become a hierarchy of interests in terms of space.
So what we have now, as I understand my limited knowledge of the decision by Judge Justice Church, is that and you may correct me on this, that ahika have the right to invite whomever they want into their poutarāwhare.
I think all his decision is, he doesn't say that as such, as I recall, but what he does say, or what the pukenga said, was that in relation to this area, there are 6 groups that have held it in accordance with tikanga, if we use the language of the Act, and that is different to others that may have used that area through whakapapa or whanaungatanga rights, for example. And so I think there's a distinction under the legislation. Customary marine title is supposed to attach to those that hold that mana whenua and mana moana, whereas protected customary rights are supposed to attach to those who might have used it in various ways, and you don't need that mana to have necessarily used it in various ways.
Okay. All right. I'm being left behind by your intellect.
Hardly.
But so let me just unravel that if I'm on the right track. Look, so you have 6 iwi that belongs to a certain part of a. They have the right, even though it's not stated by the court, but it seems they have the right to invite whomever they want into there, but they say they set the rules.
No. So what the decision shows is that 6 hapu from this area to this area, and in parts of it, not just those hapu, but also other iwi, so Ngāti Awa in relation to Ohiwa, they have, if only they could set the rules. So effectively what they've found is that they have customary marine title. Right, so these 6 hapu satisfy the threshold test to get you in the door, but what attaches to that is a really prescribed set of rights set out in the legislation that fits within the current legislative scheme. So it doesn't give you the right to exclude or invite people in, but it gives you the right under the Resource Management Act when someone is applying for a resource consent to say yes or no. It means that you can create a planning document that might influence what happens in that space. But they've codified and set out expressly what that means, and that doesn't mean or reflect tikanga. It's basically a set of associated rights that fit in to all of the other pieces of legislation that govern the takutai moana.
All right. All right. But getting back to tikanga and my example of Tairungo having the right to invite people in, and because that whānau did, and that's why Tūhoe have some access to Ohiwa and other iwi. But it was, again, reciprocal, as you may have stated. It was kai brought in from the hinterland. Blackbirds to Ohiwa, and we went back with whale. So, yeah, that was a good exchange. But but I think the whānau a Tairungo set the rules, just like Ngāti Awa seem to be suggesting at the moment, as I hear on the Puha Vine, that about the island Mautohora, because of the increasing numbers of kuia, titi, and re-enlivening the tikanga of shared access to Mautohora.
So I think the simple answer is that the legislation doesn't allow you to...
I'll that over and talk about that with my colleagues, especially Ron Crosby over there. Thank you very much. Ngā mihi.
Kia ora, Ms. Gates.
Tēnā koe.
I have a number of questions for you as well, but I just wanted to start with some of the comments you've made around protected customary rights. And you have described those as providing relatively limited rights, but you have expressed a view on some of the activities that it may include. And I was just wanting to talk to you about some of those examples. So at paragraph 61 of your brief, you have suggested white baiting as being a potential activity for which you could seek a protected customary right. So is white baiting not regulated by the Fisheries Act?
No. There's some regulations around the commercial gathering of it, but not the customary take, and I understand that's currently an issue that the Minister of Conservation is grappling with. But no, it's not. It doesn't. My understanding is it doesn't come under the fisheries legislation, which is why in Edwards a number of groups were granted the right to customarily take whitebait.
Ka pai. And one of the other examples you've given at paragraph 71, you've referred to some of the potential commercial exploitation of resources, including seaweed and sand extraction, and you've also referred to species of shellfish that aren't already regulated. So what does that include? Because again, I assumed that most, if not all, shellfish was regulated.
taipai tira. In terms of Edwards, there weren't any other shellfish beyond the Edwards PCR rights that have been granted. I don't think there were any other shellfish that hadn't been regulated, or that PCR rights were able to be granted in respect of. But sand and shingle were rights that I understand were able to be recognised, the taking of those for whatever reason, as well as the taking of, I think, wai for rongoa purposes. But I think that goes to what I was just saying before around how there is very little left in terms of what PCRs can catch.
Coming into Rahui, and you've spoken about that already today, and turning to the wāhi tapu provisions, and both Mr. Melvin and Mr. Crosby have asked you questions about that, and in particular whether those provisions can recognise and provide for Rahui. I tend to lean towards the view that you have expressed. It seems that those are designed really for the protection of permanent wāhi tapu. And you gave an example of an ana or a burial cave that might fall into that category.
Yes, I mean that's how I interpret it, and that's partly because you have to identify the boundaries of a wāhi tapu, whereas the way that Māori see Rahui is, here's our rohe, that is our boundaries broadly, and we can place wāhi tapu in that as required. And so the fact that you have to identify those boundaries and the conditions on a customary marine title, which needs to be approved by the court, I think doesn't really allow for the dynamic way in which Māori exercise mana in respect of the placing of Rahui.
And Mr. Crosby took you through the definition provisions of wāhi tapu, and again, it seems on the face of it that that tends to lean more towards a permanent wāhi tapu.
Yeah, I think so as well.
And it's likely, isn't it, that the majority of Rahui that are imposed by Māori are temporary in nature rather than being permanent?
Yes, there's the exception to that, and I think Te Whanau Apanui is an exception in that because of the drowning at the Motu River, there's a permanent Rahui that comes on every Saturday and every 12th of the month as well, I understand. But that was because of the absolutely tragic loss and the ongoing recognition of the tapu of that. But yes, generally, more in the nature of temporary than permanent.
And although there's that example of sort of a permanent ongoing Rahui for that, drownings and deaths at sea, I suppose, are a clear example of where there is usually immediate action or immediate response to something that has occurred.
Yes, that's right. I think within the space of usually a day or two.
Yes.
If not immediately.
And so looking at the wāhi tapu provisions in the Act, having to go through and get a customary marine title, obviously that's not going to provide for that type of immediate issue.
Especially the pace at which you can get orders and hearings under the High Court.
Yes. Even if you had a customary marine title order, it would seem to be a very clumsy approach trying to seek an urgent amendment to that order in order to provide for a Rahui on an urgent temporary basis like that.
Yes, if not impossible, given the timeframes in which Rahui are placed.
Yes. And when we look at Rahui, the purpose of Rahui, as we've heard in this inquiry, is not just to protect the area, it's also to protect people. And when we had our first hearing week in Te Tī in the far north, one of the karaua there was talking to us about one of the reasons for Rahui and the length of Rahui, where there is a death, is for a very practical reason, so that if fish have been feeding on the tūpapaku that there is a sufficient time for the fish to process and excrete the tūpapaku before it's caught and eaten by a human. And so it seems that's a clear example, I suppose, of where the purpose is actually to protect the people rather than to protect the area.
Yes, absolutely.
Now, if you go to the wāhi tapu provisions in the Act, so it's provided for under Section 78, but Section 79 sets out the wāhi tapu conditions that can be imposed. And so under Section 79, subsection 2, wāhi tapu conditions can affect the exercise of fishing rights, but not commercial fishing rights. So it seems that even if you could go through that process of using these provisions to try and recognise a wāhi tapu, commercial fishers could still go in there and fish, which would be, on the face of it, at odds with one of those clear protection mechanisms that a rāhui is trying to put in place.
I think that depends on how you interpret that provision, in that you could potentially still have that rāhui over that area and they catch their entitlement from somewhere else, provided it falls within the broad quota management area. That is, it may still exclude them for the, it could potentially still exclude them for the temporary purposes, provided they can go over there and catch their quota. Do you think that's right?
Well,
sorry,
it
this is
says
again
the
thinking
wāhi,
on the fly.
yes, wāhi tapu condition cannot prevent fishers from taking their lawful entitlement in a quota management area.
But they still may be able to take it if there's elsewhere in that quota management area that the wāhi tapu doesn't apply to.
Yes, I mean...
Maybe. It would be factually dependent on what they're getting and where. Crayfish they may only get within this narrow area, and therefore it does become impossible to get it, so it doesn't prevent it. But if it's catching fish, they could potentially go over there, provided that the quota management area is broad enough and isn't completely covered by the rāhui.
And there are some commercial fishing operations that may respect rāhui anyway, but there may be others who wouldn't. And I suppose that at least provides an opportunity for them to argue that they're not prohibited, even if there was an exclusion there.
Yes.
I'm just getting an indication from this end of the table that they've got further follow-up questions. I don't know if that means they agree or disagree with what I'm putting to you, but we will see. Now, Mr. Crosby has also raised with you the prospect of having a rāhui, or the ability to establish a rāhui recognised as a protected customary right. And so you've expressed the view that there may be some difficulties given the exclusionary provisions under 51(2)(e) around it excluding an activity based on a spiritual or cultural association that doesn't manifest in a physical activity or use. And it'll be interesting to see how that is interpreted. Are you aware of any other provisions in the MACA Act where rāhui may be accommodated? Because it seems it could really only fall within two areas, either
CMT or PCRs.
Yes.
And I think CMT is limited by the wāhi tapu section, as we've just discussed, and
yes.
PCRs, at least my understanding of Justice Churchman's decision was that even though those hapu clearly placed rāhui within that area, did not recognise that as a PCR and pointed to the wāhi tapu provisions.
Okay. In your brief, you have also spoken about the effects of Crown action and breach of the treaty and how that may impact on the ability of Māori to meet the tests under the Act. To some extent, that's been addressed by Justice Churchman's decision, and in particular you referred to the Raupatu finding, though my reading of his decision is that it seems that that was very much factually based in his decision, that he seemed to find that there was strong evidence of occupation and use of the takutai moana there, and it seems that as a matter of fact he considered that Raupatu didn't substantially interrupt that occupation.
They more relied on and accessed the takutai moana, and so that that's a factually limited finding, and it is unclear how that substantial interruption test might be interpreted in other cases, for example, Auckland.
Well, it seems to leave open the possibility that in a certain factual scenario, Crown action or inaction in breach of the treaty may have affected the use and occupation of an area by Māori. So it seems that it's still open that that could be an issue in another case.
Yes, I think that's right, and result in that potentially compounding injustice, in that the Crown is the reason for the loss of rights, and that loss of rights is not recognised because of the Crown's action.
Have you seen anything in the Act which would either suggest to or direct the court to take those types of factors into account when applying the test?
No.
And perhaps if I contrast that with Section 59. So Section 59 sets out matters relevant to whether a CMT exists, and it is only referred to as a matter that may be taken into account, but one of them is whether the applicant group owns land abutting the area. So it seems that the Crown has expressly put that forward as a matter that the court may take into account, but haven't given the court any guidance on where it may be due to the result of the Crown that the land was lost, or that Māori may otherwise have impacted on their ability to use and occupy the takutai moana.
Yes, that's right. They've said it may be relevant, such as in Whānau Apanui, they own 90-something% of the land abutting the takutai moana, and that naturally means you have more control over that area, I think. But the converse doesn't necessarily apply, in that you can still have those rights and exercise that mana, even if you don't own that. I think that has to be the case, given that Māori no longer own 95% of the land in Aotearoa, New Zealand.
Yes, Whānau Apanui, we're one of the exclusions, I suppose, well, the exceptions, I should say, to the general experience of Māori, particularly along the coastline.
Yes, that's right. And Ngāti Porou in certain places too, which is why I think they were first off the line for the negotiations under the Foreshore and Seabed Act.
Now, the last matter I was wanting to raise with you is the issue of a joint customary marine title and how that's going to work in practice. And I'm aware that that's really for stage 2 of the whakatōhea hearing, and that Justice Churchman has invited the parties to see if they can agree on a draft order. So we'll have to wait and see what that says, and that will likely be very informative. But if we are looking at the nature of a joint customary marine title, presumably that will mean that the rights held by all of those groups would also be joint rights, that they would hold it jointly if they hold the title jointly.
I think that's right.
Subject to any terms in the order.
Yes, that's how you assume it would imply. What I would be interested in is how that practically works out in relation to specific decisions. That is it a veto right for any one of the holders in there, or do they need unanimous consent, or those sorts of matters?
Well, that was the exact question that I had in my mind too. If they hold the title jointly, do they hold the rights jointly, and does that mean that they have to exercise them jointly? Because on the face of it, that would also require unanimous consent.
And what body does that? As in, are they going to set up a limited partnership agreement to hold these things, or some form of legal structure, or can they just have those as hapu? And I think that's the sort of detail that we don't know yet, and that may need to be negotiated and worked out between the individual parties. My assumption is that if a group can satisfy the threshold tests, which all of those individually have, then the right should you have the mana and the rangatiratanga to exercise those rights individually, although you have to do it under this umbrella that's been created.
If they had to be exercised jointly, requiring unanimous consent, the permission right that you've referred to, or the right to veto, is probably one of the stronger rights that Māori get under a CMT. But if they are subject to the views of other groups within the CMT group, it could severely limit, I suppose, their ability to exercise those rights if others don't agree.
Yes, you'll have to work with the other groups to which you have the shared exclusivity over the area with.
Thank you, Ms. Coates. That's very helpful. As I say, I think some of my colleagues have further questions arising from some of the issues we've discussed.
Kia ora.
Tēnā nō koe. We were just conferring on one of your responses in terms of the nature of rāhui and whether it's temporary or permanent, and you provided an example of whānau permanent rāhui, and I'm conscious that the judge is from whānau so say this delicately, but can it be permanent?
That's what they call it. They call it a rāhui still, and there is a sign, and it's enforced, that people cannot take kai from the Motu River on those days. And so, to an extent, I think there is an agreement that is, it's still going, whether it's permanent moake tonu atu, kei te whānau apanui tira.
Yeah, I suppose that's where my question is that rāhui is predicated on the mana of whoever puts it down or enforces it, right? So technically a generation could come along and decide, we're going to go and utilise that. Which kind of leads me into my question around the engagement you just had with Judge Armstrong about the joint CMTs. So in terms of the practice of tikanga, if you have this shared, who then gets to set if there's a rāhui or not? Will that fall under this in your mind?
Well, currently, as I've just sort of gone through, I don't think rāhui is captured by the legislation as it exists, and so you would have to operate outside of the legislative framework, which means that it's not enforceable, or go through the fisheries sort of framework, which they don't call it a rāhui, but there's the ability to place a temporary prohibition with consent of the minister that allows for a $5,000 fine and shutting down certain areas. But it doesn't speak to who places it, what that impact is, and who can exercise that. The Act simply doesn't, as we've discussed, kind of provide for the practice, that particular practice.
So whilst not explicitly saying you can or can't doing a rāhui, by the nature of having those types of rights through a legal framework, would infer that you would also therefore be the mandated or recognised group that could actually enforce tikanga Māori in the same space, considering it's a customary marine title. It would, suggest that you would be the group that could place a rāhui, or even though it doesn't specifically say in that, and what the implications might be on the broader collective group, or if there's a shared title, and I suppose it does kind of relate to the right of veto of whether you can place it when the other partners, I suppose, to the title might say, meh.
I think that's right, and that was brought up I think it's relevant in the whakatohia context, because Upokorehe, for example, were arguing that they argued that they have exclusive mana and authority within certain areas of Ohiwa to place rāhui, and they have been the primary ones that do that. But it's been found that everyone has interests in there. So what those translate to I think, impacts not only the legal framework, but has an ongoing impact under tikanga, in that it may open the door for the perception that different groups can do that, even though they may not have done it in the past.
Thank you. That was very helpful.
Koe mutu. Kia ora.
Sorry, I think Mr. Crosby also has a further question arising from some of the issues.
It's not really arising out of those earlier questions. It's just one that I'd omitted to put to you, and I would appreciate your response. And it relates to the finding at, well, I take it it's a finding, although it wasn't probably specifically necessarily necessary for the decision, but at paragraphs 271 of the Churchman decision, the following is stated in the first sentence: reclamation where a title has been issued or will be issued will have that effect, i.e. the effect of substantial interruption, as the land in question is no longer in the takutai moana. And it has just struck me that, and it's been exercising the minds of members, that is the customary right being barred as a result of not being able to meet the threshold because of the substantial interruption, and is that, would you argue, that that is a consequence of the MACA Act itself giving rise to the principle of compensation, or not?
I don't want you to repeat that that question again, but
Perhaps if I can just assist, because I know Mr. Crosby and I have been discussing this together, and this also comes to one of the issues I raised with one of the witnesses earlier today, because Justice Churchman has not only said that reclaimed land no longer falls within the definition of
the takutai
moana, but that it also vests in the Crown. So on the face of it, it could be argued that any customary rights Māori had there have been extinguished or confiscated. If that is the effect, then, again, as Mr. Crosby has raised, does that give rise to questions not only in terms of, well, whether that treaty compliant, but if so, whether there should be compensation for the confiscation of those rights or those interests?
I think that's a reasonable interpretation of the decision and the provisions. That is, I mean, he said that it is no longer takutai moana. The impact is that it's now owned by the Crown. Māori have continuously had a customary proprietary type right over there, which is now no longer recognised. So those seem to flow. Those conclusions seem reasonable to me.
Thank you. Thank you, Ms. Coates. That does conclude the questions that we have for you, but thank you for your evidence. It's been very helpful. Tēnā koe.
Tēnā koutou.
Ko tēnei mātou te waiata, kua tukuna atu ngā kupu ki a tātou. Kia ora, Natalie.
Kia ora. Just glad I didn't have them.
Tēnei mātou, o te ungaro ia mai e. Tēnei, kia koutou katoa. E akuranga tira, ani anga mate. Ia, moi maira e. Uritia, ko mana Māori, e rakura e. Moto mahunga, mo ake ake. Ko tō tātou reo, ko tō tātou reo. Rangatira reo, atahua. Ore rotia, inga wakato.
Good time for lunch, sir?
Indeed it is. We're slightly early, so that means that hopefully we can reconvene slightly early. So we will adjourn now and we'll reconvene at 1:20.
For the first time in history, we're seeing real-life superheroes fighting crime.
Do not throw that bus. I'm sorry, that's on me.
How can we not stop two chicks in their 40s?
I play dirty.
Put some more money in the bag.
Don't take this the wrong way. You're terrible at this.
your personal guide to the world of hip-hop. Get a free trial of YouTube Music Premium today. YouTube Music can help you find that song from last night. The one that goes...
Nobody listens to the radio, baby.
Use Smart Search to find songs with just a few lyrics. Upgrade to YouTube Music Premium. Uninterrupted music, dedicated to you. Try 1 month free.
Listen to music ad-free. YouTube Music Premium. Start a 1 month free trial.
YouTube Music Premium is dedicated to you. During your dinner party with friends and family, on long drives without a signal, and when your phone screen's locked. It's full of exciting features that make you feel like you're with the band, that help you find the music you've been looking for, and discover new music that you'll be listening to for years to come. Upgrade to YouTube Music Premium. Uninterrupted music dedicated to you. Try 1 month free.
delicacy. Succulent. Oh, wait. I know you. No, I definitely remember that. The Memphis Barbecue Chicken Burger. A succulent twist on a Carl's Jr. icon. Carl's Jr. It's good.
your personal guide to the world of hip-hop. Get a free trial of YouTube Music Premium today.
Our last witness is Wee Derek King, whose evidence is A122. He'll be presenting outside of his brief, which counsel will file speaking notes post-hearing. Kia ora.
Ko kahaununi te iwi, ko takitumu te waka, ko Ngāti Kapekape te hapu, ko mohaka te awa, ko hauara ki te maunga. Tēnā koutou, nā rangi tira maha, o Aotearoa nei, tēnā koutou. I'm going to speak in three parts to my submission. I'm not going to read from my submission, because I think I'll find I'll cover more if I talk off the cuff. I'm going to talk about the past, the present, and the future with our hapu of Ngāti Kapikapi. In my grandparents' day, our great great-grandmother, Ruia Aranui, fought for Ngāti Kapikapi. In 1851, she made it clear that Ngāti Kapikapi territory remained in our hands. And today, I live on our traditional land of Ngāti Kapikapi. We are one of the very few hapus in Ngāti Pāhuera that maintain our traditional lands. And I'm chairman of the Ngāti Kapikapi Marae, chairman of our Ngāi Koangareo, and chairman of the Takitumu Māori Council. I am grateful to the New Zealand Māori Council to give me this opportunity to talk about the takutai moana that affects me and my hapu. In my grandparents' day, their priority was to feed the whānau. And how they did that was through the moana, the awa, the whenua, and anything that we can find food on. In the days of the old, we used to go trekking with our grandparents to the Mohaka River and the Mohaka Beach. And in those days, the fish were plentiful. When you see the kahawai come in, they were black. The sea was covered in black. Even though the kahawai was a silver fish, the sea looked black. So there was time of plentiful, and there was time of feeding whānau and preserving kai. Now I hear about other people sharing their resources, and Kapikapi, Ngāti Pāhuera, we share all our resources with other tribes and hapus of the motu. Tūpari tō, they ask for hangi stones, which we provide, because those hangi stones come from Mount Tarawera, when it exploded. That's where we get the special hangi stones from. Mohaka, Harara, Taupunga, Opunga. They are like gold to Pāhuera and gold to other hapus. These particular hangi stones maintain the heat for 7 to 8 hours, so they're the very best in the country, we say. And in the old days, we used to trek down to the beach by horseback, wagons, and whatever mode of animals we could get at that time. And sometimes they even used the cows to pull the sledge. But that's how it was in those days. And we'll start at 3 o'clock in the morning. Everybody prepared for the fishing expedition. And the people up Kahanunu Marae, not far from where I stay in Ropinga, we trek down to our place and pick up my whānau, which was usually the young people, and we take all our fishing gears on the wagon, horse wagons, and make our way down to the Mohaka Beach. The woman, my grandmother and the woman with the mokapunas would come later on in the daytime. In the early hours in the morning, 3 o'clock we would start our trek, then the woman come with the children, 4 or 5, somewhere around here. So you see this great patrol of wagons and horses making their way to the sea. And when we get to the sea, our job as children was to, when the people are fishing, we weren't allowed to yell or run around them, because it was a very serious business to catch fish to feed our people. You had to catch it, because they didn't have refrigerators in those days. They didn't have all the modern convenience you talk about of today. So they caught the fish. Us children would take it up to the upper part of the lagoon in the Mohaka River, to scale because you weren't allowed to scale down by the MACA River mouth. And the reason for that was you didn't want to attract any sharks with the blood in the scaling, so they had reasons for doing that. And your first fish, you give it back to Tangaroa if that was your first time fishing in MACA River. So us kids our job was just to grab the fish, take it up to the upper lagoon, scale it, then put it and bury it in sand for our trip back to Ripinga. And I'd just like to say that was a part of our normal day of life. Now we still do it today, but we go on cars and horseback. Between Moaka and Waikare, the only way you can get there is through on horseback. And the reason for that, most of our access to the coastline has been cut off by Pākehā farmers. Once upon a time, we used to be able to get in there. But most of our coastline, we have been cut off access to particular areas. But our people, our people are very resourceful, and we all got boats, so we didn't have to put up that crap. So the commercialisation along our seashore has affected us collecting our kai moana. But we have overcome that by buying our own boats, like I said before, and going to these points. So my family have fished from Mahia, if you know the geography of our area, from Mahia to Wairo, to Waihua, to Moaka, to Waikare, Araporanui, Ahuriri, Napier, and right through Cape Kidnappers. So that's the area we cover on the Takutai Moana. Now we have seen the depletion of our fishing resources, and this is due to many hazards that have affected our water. Like the MACA River, for example, farmers affluent their cow. There we have a big cow dairy farms in the upper MACA River, and when they flush all the affluent, their cow paru into the MACA River, it affects every living thing going down to the moana. And we don't separate the river from the moana. It's all intertwined as one. There's no separation, because what happens inland affects the sea as well, because that's where all the pollution goes. And our spawning grounds of the kahawai has been affected. Our whitebait grounds has been affected. In the old days, we had plentiful, but now we're getting less and less. And we are well aware of the damages that some organisations are doing to our resources. For example, the MACA forestry is 16,000 hectares, and we all know what exotic trees are. They poison the whenua. It's just no good for our whenua. And you get acid rain coming from those trees that affect our waterways. They come into the MACA River, Waikare River, Araporanui, affects all our waterways. Yes. And that has been of great concern to us. It's not like we've been sleeping. We've been fighting this issue for many, many years. Donoho was brought in the 1980s for the first MACA River claim. So I've been involved with water since that time to now. And I still do that for Ngāti Kapakapi. And the reason why I fight for Ngāti Kapakapi as a hapu, not an iwi. I'm not into iwis, because those structures were set up by the government to disempower the hapus. Us hapus have to maintain our own mana, not the iwi. The iwis, the government, they didn't want to deal with all the 134 hapus of Ngāti Pāwera. So they formulated this umbrella called Umbrella of Ngāti Pāwera. And to this day, we have not benefited as a hapu. We haven't got any economic resources from the iwi. We had to do our own training of our people to look after our own mana pinoa, mana awa, mana moana. So we took it upon, Ngāti Kapakapi, took it upon ourselves to train our own people in how to deal with, well, environmental damage, corruption in the Hawke's Bay Regional Council. So we're all at their levels. Just recently we had a litigation in the High Court in Napier. This happened 2 months ago. So I went through that process, very quite angry about it, because who is it for the Crown to give us our customary rights? Who gave the thieves that to do? You know, really, they're the thieves. It's the Crown. We don't need anybody to give us our customary rights. We have always had it. We maintain it. It's up to hapus to maintain their customary rights under their own law, not a Pākehā law. This Takutai Moana Act is the most evilest of acts I have ever seen. I have ever come across in my life. It's the Takutai Moana Act. And I'll tell you the reason why. In the Moaka River mouth, they used a Coleman's Act to take our Moaka River mouth. And I said to the judge, our people never dug for coal in the middle of a Moaka River mouth. That's how evil they are. They'll do anything to take our resources. Unclaimed land, as soon as you've got a motorway for your whenua, it comes under their jurisdiction. But I don't want to expand on that. But it's very important with that unclaimed land. All these evil deeds coming in to take the very last of our resources. And Ngāti Kapaka, we can see through that. We don't recognise this act, and never will, because it diminishes our mana in a great many ways. I'm not accountable, and my hapu is not accountable to a Crown. No. We have our own tino rangatiratanga. We maintain it. We are not going to ask the Crown to give us customary title, because that's not their right. That's not their right to give it that to us. We already have it. If you're going to use that act to push that kaupapa, then I believe you're going down the wrong road. That's what I believed. The future for Ngāti Kapaka, like I said before, is setting up an infrastructure to counterbalance this terrible act. So what we're doing in our main points of food gathering, we are setting up PO. You know, we had no choice but to set up PO in each of these food gathering resources to protect our resources and to maintain it. And I hear people talking about rāhui, and I hear it all the time. That's none of your damn business. You know, the government want to interpret the rāhui when they blast, what they have done to the word tikanga is just beyond me. They have changed that whole concept of tikanga into a concept that they think it should go this way. No, it doesn't. Our tikanga to Takutai Moana is that if you look after the moana, you get repaid back. If you look after the awa, you get repaid back. And how do you look after it? Well, you have to keep your eyes on the fishing fleets. That's another area that needs to be controlled. You have to keep your eyes on the farmers with the pollutants coming down. You got to keep your eyes on the market forestry, and that's where we have certain people in place to do that. And you also have to have somebody in the Hawke's Bay Regional Council. Now, this organisation is the most corrupt organisation in the whole of bloody Aotearoa. It's these councils. These councils, they're not there for the people. They are corporates. And if you understand what has happened to our councils. They have become corporations. And the whole idea of corporations is a monetary gain, economic, at any expense. They will go about and destroy the ecology without a blinking an eyelid. And they wonder what's wrong with this country. Clean green image, what a joke. Biggest polluted country on the southern hemisphere. That's what this present government and past governments have done to our resources, to our whenua, our awa, our moana. They have polluted it. And do you think our mokapunas should inherit this? No, they shouldn't. They shouldn't have to put up with this crap. That is just bad news. Oh, I just got to check my submission. I don't want to expand more, but I'm just saying with this act, it's the most evilest act I have ever come across. It's the whole purpose is to take, but then give back. Kia ora koutou.
Kia ora, Mr. King. Thank you for the evidence you have put forward to the tribunal. Mr. Melvin.
Tēnā koe, Mr. King. Thank you for your evidence. I don't have any questions for you, however. Ngā mihi.
Mr. King, we don't have questions for you either, but I do want to take this opportunity to thank you for the evidence you have put forward in relation to this piece of legislation. Tēnā koe.
Thank you.
This is a waiata that the Huata family wrote. To
the maina iwi, oe, tātou, tātou e. To the maina iwi, oe, tātou, tātou e. Whai a te mamaratanga, me te aroa ina iwi, te rapatahi rā. Tātou, tātou e, tātou, tātou e, hioehi.
Well, sir, that is the Maori Council's case, so Dr. Ken is just going to close it for us, and that's us over and out.
Ko te taonga nui a te ao katoa. Ka tiritiri a te tua ngā huru mātai I pō ngā rangi ka pau ki te whenua. Ko te aroha, ko te aroha, ko te aroha. Anei mātou, te kaunihera Māori Aotearoa e mihi a te nei ki a koutou, te rōpū whakamana, te tiriti o Waitangi, tēnei ka mihi ake. Kua mutu wa mātou kōrero I tēnei ahi ai, kei te kua tanaka, kua tā mai, mātou, kei mui a koutou, te whakarongo ki wā mātou, kōrero e pāna ki te takutai moana. Nō reira ko te tumanako. Kia pai tō tātou hikoe ati ki wā tātou whānau I tēnā pito o te motu. Ki wā tātou kuia karaua, wā tātou tamariki mokopuna. Nō reira ki a tātou katoa e tau nei, rotu I tēnei whare, tēnā koutou, kia ora, tātou katoa.
Tira, taku, kei hea, kei hea, kei runga, kei raro, kei roto I taku moia.
Tēnā koutou.
Tēnā koe so, ko Miss Wilson nama tuarua tēnei. Pai ki te nuku atu mataki mo? Ai. Ki runga. He honore, he korore ki te atua, he maungarongo ki te whenua, he whakaaro pai ki ngā tangata katoa. Mā koe tautoko mā mihi kua mihia, ngā kariki e tukua i te rānei. No mātou o tēnei taha o te tepu, te honore, e te urumai ki tēnei pakiruhua, e whakakanohi ana mātou mō te puari o Ngāti Wai i te rānei. Nā reire, e tuku ana o mātou mihi mai aha kia koutou katoa, mai te ākauro o Ngāti Wai, me ona tini kōpikopikotanga. Engari, ko tō mātou mahi i te ahi nei, i te whakaatu kia koutou i te rōpu whakamana i te tiriti, te kōrero taunaki, mai Ms. Sarah Shaw, te kaimatanga turi whakahaere rawa. Ko te whakamarama i muri i te hakaritinga o tēnei kōrero taunaki, a te pātai, he aha te hononga i Wainganui i te RMA me te MACA. Ka huri au ki te reo tuarua, a tēnā tātou te whānau, may the tribunal please, counsel's name is Ms. Wilson, appearing for Y2764, but today appearing as agreed with all claimant counsel. Last year we put in a request to put in an expert brief of evidence from someone familiar with the Resource Management Act as to what influence the Resource Management Act has on any rights granted under the Turi o Te Takutai Moana. So to my left is Ms. Sarah Shaw and my senior counsel, Mr. Stuart Henderson, who, thank you sir, has given me the microphone i te rānei. And Ms. Shaw will be speaking to her 94 pages of evidence, and we have summarised it into a 20-minute presentation as we're aware of the time limits today. So with respect, B148 is the document that we are speaking to, but having arranged very kindly with tribunal staff, mihi aroha kia koutou, we have prepared a PowerPoint summary of the key points of Ms. Shaw's evidence. My opening submissions were filed on the 17th of May and can be taken as read because they are 3.3.130, And briefly to paraphrase the opening submissions, we acknowledge the historic decision of the Whakatohia decision, whereby it was shown that Whakatohia, hapu and applicants were able to get customary marine title, protected customary rights. But as Ms. Coates pointed out today, the Whakatohia decision does not yet speak to what the applicant group actually gets. And so with regards to Ms. Shaw's evidence, she will point out how the Resource Management Act impacts on any customary marine title rights granted under there. And perhaps by way of analogy, in my opening submissions at Para 7, I noted that the Whakatohia decision states that the Takutai Moana Marine and Coastal Area Act has a broad preamble, intrinsic rights inherited by Māori, mai rā noa. However, the actual Marine and Coastal Area Act only translates those rights into what we submit is a bad translation. And with somewhat of a colourful advocacy, as an example, he taonga tēnei. Anei te tahi customary marine title, protected customary rights, pia. I aha mai tēnei. This is an example, perhaps a metaphor, of a right which could be granted to you under the Marine and Coastal Area Act. But looking inside the box, there's not much in there, which we respectfully submit. With Ms. Shaw's evidence, we will analyse that further in full. And with your leave, e te tepu, I will now sit down and ask Ms. Shaw to come up and present her evidence. Ka pai? Tēnā koutou. Tēnā koe, Ms. Shaw. Thank you for making yourself available to the tribunal this afternoon to do your PowerPoint presentation. And just confirming your PowerPoint presentation is a summary of your brief B148 filed with the tribunal on 8th of March 2021.
That's correct.
That's correct. Ka pai, Ms. Shaw, we're in your hands.
So on the second slide is the order of presentation, which shows the questions that I was asked to answer and the order in which I'll address them today.
I'm just turning it on, sorry.
So on the second slide, it's just an indicator that I will go through question 2, question 3, and then skip to questions 5 and 6, and last deal with question 4 about accommodated activities, and accommodated activities is broken into 4 chunks. Next slide, please.
Tēnā koe, Ms. Shaw, thank you. Ms. Shaw, you were asked to analyse 2 sets of data to identify trends in terms of volume and types of RMA consents, coastal permits. The 2 data sets you were asked to analyse were the Ministry for Environment National Monitoring System data and the Northland Regional Council data set, which was based on the Ngāti Wairohi Moana, which overlaps with other claimants and also public, private and commercial interests. Ms. Shaw, can you tell us what you found, please?
So I was asked to look at 2 things. One of them was the volume of coastal permits and one was the type of coastal permits. So first, dealing with the volume of coastal permits, my conclusion was that the MFE data has insufficient data in terms of years to determine trends nationally partly because the MFE data didn't start until well after commencement of the Act and almost immediately prior to the application deadline. However, in Ngātiwai's Rohi, there was a large increase of coastal permit applications in that 2014 to 2017 period, with the application deadline falling in 2017. My conclusion was that it's likely that the CMT application deadline is one factor relevant to those trends in the MFE data, and also other relevant factors would be expiry dates of consents and policy and plan development.
Kia ora, Ms. Shaw.
The second question was the type of coastal permits. The applications, and my conclusion was that applications for coastal permits are largely not notified and not declined. So looking at the blue table on the right-hand side, across the MFE nationwide data, 75% of consents are non-notified, which means that there are no rights of participation. 95% are granted. 98% of renewal applications are granted. 92% are decided by council staff rather than an independent decision maker, and council staff do not refuse consents. My conclusion in terms of the term of consent, the MFE data doesn't actually contain any data about term, so I looked at the Northland Regional Council data for that, and a high proportion of the Northland Regional Council coastal permits have a term that's at or close to the statutory maximum of 35 years. This is relevant to the volume of both existing and new coastal permits being issued in the takutai moana, which are then exempt from the RMA permission right. Next slide, please.
Kia ora, Ms. Shaw. Following that, you were then asked, in your experience working with the RMA, what trends have you seen in the use of the takutai moana?
So there were two examples given. One was infrastructure with climate change effects, and the second was tourism. So dealing first with infrastructure, coastal infrastructure is at risk from climate change and sea level rise. The response from infrastructure providers is to protect their existing infrastructure in the coastal environment, including by new works. The infrastructure providers, I should break to indicate there that the last page of these slides includes an index which will relate each slide to the paragraphs of evidence, so that is cross-referenced. Infrastructure providers, which come from the private sector, Crown and council agencies, are, in my experience, well-resourced and well-represented in RMA processes. They seek consistency nationwide, recognition as nationally or regionally significant infrastructure, streamlined consenting pathways. They challenge the protection of significant areas and seek preferential status for their projects, even in significant areas. This is relevant to infrastructure being consented prior to a CMT order, which would then be exempt from the RMA permission right. Next slide, please. This is an update from my evidence. So it has been established since the Supreme Court decision in 2014 in King Salmon that you must avoid effects in significant areas, with avoid having the ordinary meaning of not do. The day that my evidence was filed with the tribunal, which I refer to as Tsunami Friday, Forest and Birds decision in the New Zealand High Court was released with respect to East-West Link, which is a reclamation for a motorway at Mangere Inlet. The High Court concluded that infrastructure can trump the mandatory requirement to avoid adverse effects in significant areas. This is relevant because it is yet another carve-out from the established law for infrastructure to get rights that others don't have. Next slide, please. The second part of this question 3 I looked at was the tourism trends, and the trend that I had identified was growth in the cruise ship market, both in numbers of cruise passengers increasing and particularly cruise ships becoming larger, which has implications for cruise ship infrastructure in the takutai moana. There have been significant coastal works since 2015-16 to accommodate more and larger cruise ships, including a new tender berth at Waitangi, 20,000 tonnes of dredging at Picton, and new large wharfs, 148 metres and 350 metres in Littleton and Napier respectively. Next slide, please. This is for a scale reference. 350 metres long doesn't mean much, but this is the Ovation of the Seas, 346 metre long vessel carrying close to 5,000 passengers and 1,500 crew. That photograph is for a scale that's docked at Picton, and the buildings and boats give an impression of what that 350 metres actually means in practice. Next slide, please.
Tēnā koe, Ms. Shaw. The next matter you were asked to address in your evidence was, what does an RMA permission right under the MACA offer to the holder of that right, and how does it differ from the rights of others?
My evidence is that MACA gives extremely limited rights of participation in the RMA. MACA, but not the RMA, requires a resource consent applicant to inform a CMT applicant before lodging a resource consent application, and to inform a CMT group, so holders of CMT title, once consent has been granted and all appeals have been resolved. Councils cannot reject a resource consent application for lack of consultation with CMT applicants or CMT groups. In my opinion, there is not a statutory power in the RMA that allows that to happen. Turning from what the applicant is required to do to what the council is required to do, the RMA does not require a council to notify a resource consent application to CMT applicants or to CMT groups except for accommodated activities. The relevance of this is that if you are not notified, you're cut out of the process. You have no rights to make a submission, no rights to be participating in the hearing, and no rights of appeal. Next slide.
Tēnā koe, Ms. Shaw. The next matter you were asked to... Aroha mai. Tēnā koe, Ms. Shaw. The next question you were asked to address is, what are the differences between rights available to resource consent holders under the RMA and customary marine title holders under the MACA?
In my evidence, CMT is a bundle of rights, that is a statutory bundle of rights defined by MACA. Coastal permits are a bundle of rights that's largely defined by the resource consent applicant, and I say that because under the Resource Management Act, the scope of an application and the consent which is ultimately granted is defined by what the applicant asks for in the first place. So a council cannot grant more than what an applicant asks for. It is the applicant who frames what it is that they are seeking consent for. A coastal permit is transferable to any person. It can be sold on the open market, and council websites include listings for swing moorings for sale on their websites as an allocation of resources. Another major difference is that on expiry of a coastal permit, the permit holder can continue operating until their renewal application and any appeals are determined. That could be years, we're talking 5 years. And also the permit holder takes priority over every other applicant, including someone who might hold CMT and have an alternative proposal that they want to put forward within their title area. The existing permit holder takes precedence over them. Next slide, please.
Thank you, Ms. Shaw. And the final matter that you were asked to address was with regards to accommodated activities. In your opinion, what is the impact of accommodated activities on a resource RMA permission right held by customary marine title holders under the MACA?
I start by pointing to the MACA purpose, which includes recognising and protecting existing lawful rights and uses in the Takatai Moana in Section 4, and accommodated activities is a large part of how MACA achieves that. I've broken accommodated activities into 4 groups: permitted activities, consented activities, existing infrastructure, and new infrastructure to demonstrate this. Next slide, please. First, dealing with permitted activities. So a permitted activity is something that's described in a regional plan as permitted and not requiring any consent from the council to be able to do it. Permitted activities are exempt from MACA, Section 20. There will be pressure, in my evidence, on plans and plan processes from developers and infrastructure providers for more permitted activities. because the permitted activity is the cleanest and fastest way to get what you want, MACA doesn't even apply. Plan processes take years. In Northland, for the regional plan, we're currently sitting at year 5. We have not completed the Environment Court hearings, and that's not including any possible High Court or higher appeals following that. However, the plans have to be reviewed every 10 years. So this is relevant to resourcing pressures on CMT applicants and groups if they are having to participate in these plan processes to carefully guard against the introduction of new permitted activities for which MACA would be exempt. As examples of permitted activities, the first, these are taken from the Northland Regional Plan, the mangrove removal in mapped areas of significance. That was mapped for a significant ecology, but also mapped for significance to tangata whenua, and yet was provided for as a permitted activity. The second is that the plan was notified with a rule that was a permitted activity to legalise existing illegal swing moorings. Next slide, please. So the second of the 4 categories of accommodated activities is that accommodated activities includes a resource consent whenever granted if it was lodged before the customary marine title order is sealed. The consequence of that is that the RMA permission right is deferred until that consent is up for renewal. And the timeline on the bottom of that screen just gives an example. If an application was lodged with a council on the 1st of January 2022, the CMT order was sealed the following day, that resource consent application would actually leapfrog the CMT order because it was received first. It could take 5 years. There's no statutory maximum, but I've estimated it could take 5 years to grant that and get through the appeals process. It could be longer. If the 35-year maximum term was applied, that consent wouldn't expire until 2057, and it's only at the point of expiry that the RMA permission right crystallises. And by crystallises, I mean that you can actually use it. That doesn't allow on that slide for the fact that there's also a period at the renewal when the existing consent holder can continue to operate for several years while they pursue replacement resource consents. Next slide, please. The third category in accommodated activities was existing infrastructure. This slide's just a reminder that Section 2 of the Resource Management Act defines this. We're talking about pipelines, telecoms and radio, electricity pylons, towers and lines, water supply, sewage, stormwater, including sewage treatment plants in the Takutai Moana or adjacent to it, rail, roads, airports and ports. Next slide, please. So accommodated activities include accommodated infrastructure. This is existing infrastructure that exists prior to the CMT order being sealed, and it includes renewals. So the RMA permission right will never apply to accommodated infrastructure. The timeline on the bottom again gives an example. If existing infrastructure was in place as at the 1st of January 2022 and the following day the CMT order was sealed, again that existing infrastructure would leapfrog over the grant of the CMT order, assuming that the infrastructure consenting expired in 2055 after its statutory term. The infrastructure provider can put in a renewal application which would again expire some 35 years later and then renew it again. The difference from the previous slide is that the CMT, the RMA permission right never crystallises. You're never able to use it because accommodated infrastructure is exempt from the RMA permission right. Next slide, please. The final category of accommodated activities is new infrastructure. The accommodated activities definition includes deemed accommodated infrastructure. So this is anything that is new infrastructure after the CMT order is sealed. The Minister of Land may waive the RMA permission right. So again, dealing with the timeline at the bottom of the slide, if the CMT order is sealed and a proposal for new infrastructure comes forward, the developer of that infrastructure can make an application to the Minister of Land. The Minister can waive the RMA permission right and the resource consent can then be granted, and all aspects of that particular infrastructure are carved out and exempt from the RMA permission right. The last slide is an example of those existing and new infrastructure side by side. So on the left-hand side, using a port as an example, on the left-hand side, an existing port before the order is sealed would be accommodated infrastructure. The RMA permission right never applies because the port is able to continue getting renewals of its resource consents, and the permission right never kicks in. On the right-hand side, after the order is sealed, if there's a proposed port expansion, if this is deemed accommodated infrastructure on an application to the Minister of Land, the RMA permission right which exists would be waived, and separately the Minister of Land must vest the title for reclamation to the port company. The same applies for airport companies. So notwithstanding that the CMT order had issued and a title existed for that continuous area of Takutai Moana, the Minister of Land must vest that title for the reclamation back to the port company and carve it out of the title. And then the final slide is just the cross-references for each of the topics I've talked about back to the paragraphs in my brief of evidence.
Koe Ms. Shaw, thank you for consolidating your evidence into 18 minutes. Please confirm that you're now available to take questions. And here's a glass of water. Are you okay to stand?
Kia ora, Ms. Shaw. Thank you for the evidence you've presented so far. There are a number of lawyers who have questions for you, starting with Mr. Benyon.
Thank you, Ms. Shaw. Just to let you know briefly, I'm going to look at the existing Act, RMA, and some of its provisions and how they relate to how they apply now. Then just going to look at the application, the notice rights that exist when a CMT application has been made but not yet approved or processed, and then go on to accommodated activities and the ability to refuse and the planning right, so the details of those things. So hopefully we can get through those. So first of all, just in terms of the way the RMA operates now, you've said in your evidence that it's section 12 says it creates a default that pretty much every activity in what we'll call, let's just call it the coastal marine area, requires you've got to go and look for some sort of permission to carry out your activity, and you've got to find that somewhere in a regional plan.
That's correct. So the default position for land-based activities in the Resource Management Act is that activities are permitted unless they are expressly not permitted in a planning document. And there's also no term on resource consents granted on land, so there is an indefinite recognition of rights and a presumption for land-based activities that you have the right to do what you wish unless there is a restriction. That presumption is reversed in the coastal marine area in the Resource Management Act, and so activities are not permitted in the coastal marine area unless a regional plan expressly describes them as permitted. The presumption is that everything requires resource consent.
So a point you were just making in your presentation is the bigger an area that can be carved out for permitted activities in a regional coastal plan, the easier it is for people to just that's the space in which they can operate without resource consents, but that's the only space they can operate.
That's right. So dealing with the coastal marine area, which is how the Resource Management Act describes this area, the only ability to undertake activities without a resource consent from the council is if the regional plan describes those as permitted activities, and it has to do that through the public plan making process.
All right, thank you. So that also means, doesn't it, that in the coastal marine area, there are no existing use rights for even quite old structures, like old groins, old power pylons that are in that area. They all have to go and look under a regional plan to see if they're somehow permitted as existing uses, or you've got to go back and get consents for them.
It depends how they got there. There are some existing lawful uses. They may have had an old resource consent under prior legislation that has carried through. They might have been pre-RMA in things like Harbours Act legislation. So it does depend how that got there. But, for example, on a land-based process, the existing use rights are very extensive and very entrenched. In the coastal marine area, existing use rights are quite limited, and they can actually be revoked by a regional plan coming through and taking them away. The opposite applies for land-based activities. If you have been doing an activity on land and you carry on doing that activity without interruption, a new plan document coming through can't take your activity away from you unless you cease and pause for a substantial period of time. But the opposite is true in the coastal marine area. The new planning documents that come through can give new frameworks, and you must comply with those new frameworks.
And just while we're there, the accommodated activities under the MACA Act kind of reverse the onus and create those activities as the equivalent of land-based activities for the purpose of the MACA Act.
The accommodated activities, well, the first one that isn't described as an accommodated activity but sits elsewhere, it sits in Section 20 MACA, is that the permitted activities are carved out already. And then within the definition of accommodated activities itself, there are these exceptions to the norm where certain things, the RMA permission right doesn't apply, which is a very successful entrenchment of existing activities in the coastal space, where that purpose of the MACA included to protect those existing uses, that the legislation has done that very effectively through accommodated activities.
Now, just stepping back to the RMA generally and the way regional plans work, if a consent is sought for an activity in a regional plan, and if a regional plan is carving out a permitted rule space for activities that don't need consents, in both those processes, Section 6E is going to be relevant, and the relationship of Māori with ancestral waters must be recognised and provided for?
That's right, Section 6E. There's also the historic heritage provisions are relevant. Section 7, 7A, kaitiakitanga is relevant, and Section 8 as well. All of those Part 2 principles in those three sections are required in both the left-hand plan and policy making and the right-hand resource consent granting processes under the RMA. Those principles of the Act are paramount. Because it's a hierarchical legislation, what tends to happen is that the national policy statements, such as the New Zealand Coastal Policy Statement, will give effect to those Part 2 responsibilities and bring them in as specific provisions in a coastal policy statement, but then every other layer underneath that has to then give effect to the one above it. So if the New Zealand Coastal Policy Statement requires certain things to happen in order to give effect, to give life to that Section 6E requirement, a regional policy statement that comes in has to then be consistent with the document above it. The regional plan has to be consistent with the policy statement. The district plan has to be consistent. So it is very hierarchical, and it's less common now to go back up to the Part 2 principles because they have been given effect to in the lower documents.
So if you've listed in your evidence thousands of consents that were sought and given, granted in coastal marine area for Ngāti Wai, if most of those decisions were being made by council officers, which I think you said they were, they have to step through those documents where they're relevant even if they're just renewing a swing mooring. At some stage in their process, they have to have thought through the documents, as you've described, where they might apply to the swing mooring issue.
That's right, and so it's important to note that for renewals, all of us in RMA practitioner land talk about renewals. There is no statutory process in the RMA for renewal. It is an application. So it's an application to continue the activity that you already had a prior consent for, but it doesn't have any special pathway or process. It is a new application. It has those recognitions for things like extending beyond your expiry date to carry on with your activity. You also get special credit for any money that you've spent investing in the machinery or the infrastructure that you're seeking to reconsent. So you do get preferential treatment, but you don't get a different pathway. So you still have to, there's only one resource consenting pathway in the Act, and it doesn't matter whether it's a new application or a renewal, you go through the same path. And so those requirements to have regard to the purpose and principles of the Act, all of the higher order documents and the tangata whenua values, those are relevant whether it's a new application or a renewal. and they are mandatory requirements of the Act.
All right. And just finally on that matter, so we can say that the law requires, and in practice, it is a practice that even council officers issuing consents on swing moorings will in some respect have gone through the recognise and provide exercise of Section 60, where it's reflected somewhere in the planning documents, because it will turn up somewhere in those documents.
That's right, and they have to turn their minds to what those values are, where they might be, whether there is any expression on those values from a cultural impact assessment or from a submission if it's a notified or limited notified application, and they have to engage with that issue of what those values are, and importantly, because the RMA is an effects-based piece of legislation, not just what the values are, but what is the effect of this proposal on those values, and that's a mandatory process.
Right. Now, I just want to turn to the question of the requirement under the Act that when someone applies for a resource consent in an area covered by an application for CMT, there's a requirement to let the applicant know that the application has been made, and Section 62(3), and then receive their comments on it. You're familiar with? So
that's a MACA requirement. It's
yes.
not an RMA requirement.
Sorry, I meant to say under the MACA Act. Yeah. So I'm just trying to. I mean, there's questions about how useful this is, and you've said it doesn't seem to be very useful, but I just note. It includes control, all consents, so it includes controlled activity consents and restricted discretionary consents as well, yes?
That's right. So the MACA applies to controlled activities, and controlled activities are described in the RMA as an activity for which consent cannot be declined. It must be granted, but the question is what conditions will be placed upon it. So the relevance of that is that controlled activities have been brought in to MACA. It hasn't excluded them, but it does mean that the questions being considered are only around what the conditions should be, not whether the application should be declined. Restricted discretionary is the next tier up, where consent can be declined, but it can only be declined or conditions imposed for the small bullet point list of matters that are included in the rule and the plan. So if that bullet point list of matters doesn't include anything that encompasses the tangata whenua values that are being raised, that is not a lawful means for turning down a consent or imposing a condition. Only the bullet points are the ones that you can look at.
So it's quite possible you might be an applicant for CMT, receive thousands of consent applications, and every single one that's controlled or restricted discretionary, and the discretion doesn't include any iwi or Māori matters, you're basically looking at bits of paper that you might send a comment in on, but under the RMA process, there's no real ability to act on that comment at all.
That's correct, and also I think in my evidence I covered the fact that to me as an RMA practitioner, that requirement to inform under MACA, to inform a CMT applicant group about a resource consent that's being lodged doesn't really change anything, because in practice, resource management practitioners will routinely inform the mana whenua of a proposal that they're bringing forward, and there are, in every council that I'm aware of, there is a list and a map of the rohi, and there's usually an iwi liaison officer, that applications that come in the door are routinely sent to those groups for their information anyway. That already happens. So I don't see that requirement in MACA as actually achieving any difference from the status quo.
Because you're saying they'd send on anywhere it raised iwi matters or Māori matters that could be looked at in the consent.
The councils that I'm familiar with, they actually just send everything. So if it comes in and it's within the rohi, and then it goes. It's just part of the local authority Crown Māori relationship of ensuring that adequate information is exchanged.
Yeah, well, I think we've got a problem here, because isn't it the case that when you say they send them, they're going to send them to who they know for RMA purposes needs to be informed about these applications, and that might be a different list of people from the list of people who've made an application under the MACA Act.
That's right. And so the RMA deals with this, I think Section 35A says that the council has to keep records about who the relevant tangata whenua groups are. Section 35, capital A, the duty to keep records about iwi and hapu. And so the councils actually have to collate this information. They must receive updates and they must ensure that the information that they hold is correct and accurate.
No requirement there for them to keep it add to that list all the CMT applicants.
No, and the CMT is not mentioned in these RMA provisions. A lot of these provisions sit in MACA but not in the RMA. So I am aware from having spoken to RMA practitioners that they are familiar with where they have to look for the information, and for example Northland Regional Council is quite proactive about saying to applicants, here is the link, this is where you need to go to find this information, because you have a statutory obligation to inform these groups. So.
Now, turning to the statutory obligation, let's say you inform a CMT, let's say you don't inform a CMT holder, and that's the complaint from one of our groups, that there's been a lot of applications they haven't been informed of, and let's say they raise that issue and turn up to a consent hearing and say, well, this hasn't been notified. Have you ever come across that situation? It hasn't been notified in terms of the MACA Act requirement. So have you come across that situation?
So if we phrase it in terms of inform, because the Resource Management Act has a special meaning around notify. So if a group were not informed, CMT applicant group were not informed, that's a breach of the MACA requirements, but there is no mechanism in the RMA to address that. It's not an RMA requirement. So the RMA requirements are set out in Schedule 4 for what a resource consent application must include. There are mandatory information requirements. If you don't meet those, your application can be rejected. It can be, we call it the courier bag. It can be sent back to you under Section 88 as being rejected, not received. And there's no ability to remedy that. You have to start again and file a new one. The next process is that the council can say, well, it's not quite bad enough for the courier bag, but you are getting a letter, a Section 92 letter requesting additional information. But there's nothing in Section 88, there's nothing in Schedule 4 that requires CMT applicant groups or CMT title holders to be informed. Those are not RMA breaches, they're MACA breaches. The second part of what you asked is that if a group finds out that there was an application that they weren't informed of and they turn up to a council hearing, well, a council only holds a hearing if it has actually notified an application and that needs to go to a hearing. And my evidence was that substantially that doesn't happen. These applications are processed in-house by the council staff. There is no hearing. There's a person sitting at their desk and they receive the information and then they issue the consent. So there was never an opportunity for that person to turn up and say anything.
Even if they did turn up and you were in the middle of a hearing, where the council had stepped through the process and said, well, we've got enough information so we can hold a hearing, is there any ability that you're aware of, or have you ever seen anything that would allow a council to say, well, there's some tools in the Resource Management Act itself that allow us to stop this process?
The tool is Section 95B, capital B, which is the limited notification section, but there's no provision in that for requiring a council to notify a CMT applicant group. There is a provision for them to notify directly to a CMT title holding group, but only if it's an accommodated activity. If it's not an accommodated activity, then there is no requirement, because the RMA is relying on the fact that the RMA permission right can be exercised, and so it doesn't concern itself with notifying those groups.
And finally on this issue, the requirement is to seek the views of the group on the application under the MACA Act. It's Section 62.3. Seek the views of the group. In terms of those words, and for example other words in the RMA about recognise and provide for, give effect to, take into account, where would you rank those words in terms of their strength?
So the RMA has a hierarchy of language, and if you look in sections 6, 7 and 8 of the RMA, I think I stepped through this in my evidence, but the Section 6 is matters of national importance, and the requirement there is to recognise and provide for. Recognise and provide for and give effect to are the strongest mandatory drivers in the RMA. Those are, the court decisions have indicated that you actually need to do something with that. Section 7 is the not levels of national importance, but that test is to have particular regard to. So you have to turn your mind to it and you have to give it some serious thought. But you don't necessarily have to do anything following that. And Section 8, which is the te tiriti section, has the lowest order of wording, which is take into account. So seeking the views, to me, sits somewhere in that take into account. And in the RMA practice, in my experience, there is a lot of asking tangata whenua for their views on things and then doing it anyway. So the view might be that that's totally abhorrent and that's accepted as being the view. It doesn't necessarily impact on the decision that's then made.
All right, thank you. Can I come to accommodated activities? Well, first of all, on accommodated activities, why is it that notification of accommodated activities is required once you have a CMT, but not for anything else? Because accommodated activities are the only thing you can't exercise your permission right on. You've got no ability there. So do you think it's some sort of saying to groups, well, just use the RMA route to make your comments on this one?
The fact that that's the only one of the RMA permission rights that has turned up in the Section 95B notification suggests to me that because accommodated activities are not able to exercise the RMA permission right, there was a recognition that there's no power to refuse permission, and therefore the views of the CMT title group need to be built into the resource consent process, because there's no opportunity later to say, well, we don't give our permission, so we don't care that you hold a resource consent, we decline to give permission for you to actually implement that consent. Because that's missing for the accommodated activities, because the RMA permission right doesn't apply, the RMA has built in a notification process there to ensure that the group is able to make a submission, be involved in the hearing and have rights of appeal.
All right. And just a couple of questions about how you talk about the accommodated activities. One of the things you've said is that there's a definition of associated operations, and you've said where it says associated operations means activities necessary for the functioning of the accommodated infrastructure, and item A there says including an activity carried out under a consent to permit the existing accommodated infrastructure to continue, and you think that's actually just talking about the renewal application for that accommodated infrastructure.
Yep, so I dealt with this in my...
You think it's at... paragraph 214. I thought it was an odd way to express that, and why you'd reached that conclusion.
As I explained, the Resource Management Act doesn't have language for renewals, right. So that renewals are not a thing. As RMA practitioners, we will talk about renewals, but under the RMA, it is blind to whether something is a new activity or an activity to continue it, other than some particular enabling of people who already hold a consent to carry on after their expiry. Other than that, there is no language in the RMA to describe a renewal. It's not a word, it's just one that we use. So when MACA talks about accommodated infrastructure, which is that infrastructure that already exists before your CMT is issued, and it has that paragraph about an activity carried out under a resource consent to permit existing accommodated infrastructure to continue in the same location, the only interpretation that makes sense to me as an RMA practitioner for a consent to permit continuing in the same location is a renewal. It doesn't make sense for it to mean anything else.
Right. Okay, and while we're there too, the slide you put up showing the port and existing port and future port, most of the development that you were talking about there was the new activity that the MACA Act can't touch, a CMT can't comment on, is actually the reclamation aspect. Is that right? Because it strikes me that new infrastructure, well, it would be, if it's regionally important, it can't be subject to the right.
No, MACA doesn't say any of those nuances. It's much more blunt than that. So for the new infrastructure, it just has to be for one of the things that was on the list. So it could have been for power pylons, it could have been for a jettied wharf structure. This happened to be an example that I had before and after photographs, which was useful for the slide. But no, it doesn't have to be for a reclamation. The difference with reclamation is that, well, for starters, reclamation consents don't expire. There is no statutory expiry term on a reclamation once you've reclaimed it and you've put the rocks in the harbour. And in fact, the reverse is almost true. You need a resource consent to remove a reclamation. So reclamation is special in a couple of different ways. The consent never expires for it. So if it was a private reclamation, not by an infrastructure provider, let's say it's from a fishing boat operator, not an infrastructure provider but has a reclamation, the RMA permission right will never apply because that consent never expires. If it is for infrastructure and it's existing infrastructure, then it's accommodated infrastructure, so you never get to use your RMA permission right. If it's a new proposal that's going in, it doesn't matter whether it's a reclamation, a piled jetty, a pylon. If application is made to the Minister of Land for it to be deemed, it could be a road, for it to be deemed, then the RMA permission right is waived. So you have your permission right, you should be able to use it because it's a new proposal, it's not something that exists, but it can actually be waived by a Minister of the Crown.
Right. That's an interesting comment about a road. So a road would be caught under accommodated infrastructure as well.
That's right. So a road could be an existing road or it could be a new proposed road. So they would fall under different classifications. In order for it to be accommodated infrastructure, it has to be existing before the title is issued. But bearing in mind that those new proposals can keep coming through and consents being lodged for them right up until the point in time that the CMT order is sealed. And so by existing, I don't mean existing as at the commencement of the Act or existing as at today. It's existing as at the day prior to the CMT order being sealed.
All right, and just on the accommodated definition of accommodated infrastructure, I see there's a definition there of emergency activity, which I think gets picked up by, it's a deemed accommodated activity. Do you see under, I'm just looking here at section 63 and emergency activity definition. It includes all necessary coastal protection work undertaken in a customary marine title area by local authority or Crown agency. Do you see that?
Yep.
That's broader than the definition of an emergency work under the RMA, isn't it? Because
yep.
I understood...
Yep. The RMA covers it in section 330.
Right.
For emergency works.
I'm looking at 330 and there's no particular definition of the word, but it says it's a structure where there's some sort of urgent, immediate preventative measures required. The immediacy is the issue, isn't it?
It talks about sudden events, immediate remedial measures.
Yes. So this definition in the MACA Act actually steps that out to all coastal protection work and drops the idea that it's of any immediate work needed. It just says anything that's out there that's coastal protection.
So the definition of emergency activity in MACA, in A, is the more familiar phrasing that I'm used to from the RMA, which talks about actual or imminent danger and immediate action. So the immediacy is in is part A of the definition. Part B is what you're, lowercase b is what you're talking about, which says coastal protection work, and it doesn't include that requirement for urgency or immediacy.
Right. Now, just a couple more questions quickly on accommodated activity, and then we'll move on. But you've said that the minister has a power to waive the, at paragraph 25, you say the minister has a power to, a waiver power over accommodated activities. What do you mean by that? When you say waiver, what do you mean there?
So this is for the new infrastructure. So this is again the right-hand side of that slide. So after the CMT order is issued, there is a proposal for new infrastructure in the Takuta Moana. There is a process, there's actually a lengthy schedule in MACA.
Yes. Just going quickly to that, isn't it a power for the minister to say, I'm going to say it's the permission right is waived, and I can consider what compensation might be given to the group for giving up for me requiring them to waive it.
That's right. So it's Schedule 2 of MACA is the deemed accommodated infrastructure process, which is where, now this is only for infrastructure, not for non-infrastructure processes, but the Minister of Land can consider deeming the project, which waives the RMA permission right. And
the minister can consider what compensation to provide, and that's entirely with the minister.
That's right. The minister must, so this is clause 8 of that schedule, the minister must consider the information and make a decision whether to waive the permission right, whether there are any other affected rights associated, what compensation to provide.
There's not even a requirement to get a valuation or anything of that nature there, is there? It's just for the minister to decide.
It's not stated as a requirement.
So turning the page in that schedule to the minerals activities, the Act permits, doesn't it, people to undertake petroleum activities, and the permission right can't be exercised to prevent petroleum-related activities in a CMT.
I haven't studied those provisions, sorry. Okay. I'm happy to answer a question in writing on that.
All right. Turning now quickly to this right to refuse permission, you've got 40 days to decide whether or not an activity for which someone has resource consent should occur or not. So let's say we've got the whakatohia group and 6 people come together in some sort of arrangement, limited partnership or a trust, and they're going to have to think very carefully, aren't they, about veto rights for any one of those groups if they've got this limited 40 days to all agree together whether to allow an RMA activity to occur in the area or not.
My first response is that I wouldn't describe the RMA permission right as a veto. I think it is a limited bundle of rights which does not amount to a veto except in limited circumstances. Those circumstances are where it's not an accommodated activity, so it sits outside that, and only applies after the consent comes up for renewal. So there's an element of time in there where it might be 35 or 40 years before you can actually act on that right. So the specific question about whakatohia and granting a CMT to a group, I don't believe that the RMA permission right provisions were drafted with that in mind. I can't see any consideration of joint or several responsibility. The detail would come down to how the order was drafted, but none of these statutory provisions talk about drilling down into that detail. They sit at the level of the CMT holder, and that description of that right sits with the holder. If there was an order that was very specific on a spatial basis, for example, and made it very clear spatially which group actually exercised those rights in which particular rohe, that would be much more clear than if it was not, for example, on a spatial basis. But these statutory provisions do not appear to have been written with that kind of group title in mind. There's no mechanisms that are available for how those negotiation processes would occur, and the 40 days is a very short time frame.
Yes, for example, if the groups were having problems and decided to take the matter to a court, that might be problematic in terms of the 40 days.
There's no extension provisions. The 40 days is an absolute deadline, and if it's not complied with, the RMA permission right is deemed to be waived for non-response.
Have you heard of anyone giving thought to the idea of an agreement around the permission right that was in effect a sort of a rental? In other words, seeking a payment and maybe review after a period to a different level of payment in exchange for giving the permission right, whether that would even be possible under this provision? Or have you turned your mind to anything of that nature or seen it talked about?
No, and again, the provisions don't prevent it. The answer that's required to be given is a yes, no, and any conditions. Because it's an RMA permission right, the applicant holds a Resource Management Act consent, but they can't implement it unless they get that approval. The RMA wouldn't normally concern itself with any kind of financial arrangements between parties, but this would be post the grant of the consent. Certainly you would never get a Resource Management Act, never. I've never seen a Resource Management Act consent with conditions that talk about financial arrangements, and those are actively pushed back against in the RMA sphere because they're not in a fixed-based condition or process.
But there are side agreements.
There are side agreements that exist, but those don't usually have that A, time constraint, and B, catastrophic consequence of missing the time frame.
If a group is presented with a completed resource consent with all of its conditions, and they seek to negotiate about the 40 days and the veto, they're not going to be able to well, what's the ability for them to actually talk about the conditions of the consent and seek change to those as part of the agreement to permit the activity in the area?
So the Resource Management Act allows you to apply to amend conditions, section 127, but it is effectively a mini resource consent process. It's another statutory process that has to go through application, consideration of who should be notified. It's a truncated version of running a full resource consent process. They're not quick. You would never get one done inside 40 days. You can ask, but of course the decision maker on a resource consent is the local authority. So you could ask for different conditions to be imposed and the council can say no.
Now just two more questions and then I'm done. One is around the planning right. So this is the ability for a CMT holder to issue a planning document, and I'm particularly interested in the way the regional council thinks about that planning document. As I read the provisions, the regional council receives the planning document that the CMT groups produced, and I had sort of two sub-questions on this. One is, as I read the provisions, it doesn't look to me like you can, the planning document produced by the CMT holder can include rules, and I want your thought on that. But the other question is, doesn't it then require, if the regional council is to adopt that planning document in some form, that it step through the full Schedule 1 process with public submissions and all those sorts of matters?
The rules aspect. Can you remind me of the MACA section number, please?
Yep. I'm looking at sections 93, particularly 9 and 10.
I think it might sit in section 85 too, which is that the purposes of the planning document are to identify issues relevant to regulation and management of the customary marine title area, and to set out the regulatory and management objectives of the group, and to set out policies. In RMA language, issues, objectives and policies have very clear and understood meanings, and they are not rules.
Okay.
Rules are separate.
But rules at the moment, when you tell people whether they need consents or not and what activities might be even prohibited or non-compliant, that sort of
Policies can be quite directive. So, for example, a policy that includes the word avoid is very directive and starts to act in a similar way to a rule, but certainly to RMA practitioners, if someone tried to put in a document that said that it included rules, there would be reference back to this section saying we don't have a statutory right to include rules. Issues, objectives and policies are defined in understood terms and they are not rules. I'm sorry, could you remind me what the second question was?
So the second question, I think I got the right section for this one, I hope. Section 93, and this is the one where a planning document comes through to a consent to a regional council, and they decide whether or not they want to put some of that into their regional plan, which does include rules.
That's right.
And as I understand the provision, I'm looking at section 93.9, they have to go through Schedule 1, which means is going to be a full process with public notification and public submissions.
That's right. And so for the Schedule 1 process, which is the public process for making plans and policy statements, it's a long process. As I said, 5+ years and not complete. Any member of the public on a plan change is able to make a submission in support or in opposition. Every person who makes a submission has the right to be heard. So these are quite long processes. They take many years. I also looked at, for an RMA practitioner, you always want to know which process does this bite in. Is it resource consents or is it plan and policy making? Because they're very much the two halves of the RMA world. So the planning document under MACA also applies under Section 104 of the Resource Management Act, which is a decision on a resource consent, but only in a temporary manner. So in Section 104 for a resource consent application, and it's quite strong language, the consent authority must have regard to matters identified in the planning document. But that provision, that Section 93.3 of MACA, that obligation then falls away once the council decides what it's going to do. So the planning document has a temporary function in Section 104 that it's relevant to resource consent determinations until the point when the council says we're either going to do nothing because we don't think that we need to, we think our plan actually already accommodates your values, or we are going to go through a full plan change process, which could take up to 10 years, but it falls out of the resource consent process. It loses its power in the consenting regime at that point.
From the moment it's notified, or does it keep going until the plan's finalised?
MACA Section 93 sub 4, the obligation under subsection 3 applies only to the matters in respect of which a council, that's able to exercise discretion. There it is in here.
I guess my short point is that if you, for example, represented a group of landowners who had a problem with a customary marine title, you could turn up in the High Court and have your objection there, and then way down the process here, you can come back in as a member of the public and have a go at the rules.
Yeah, sorry, it was
people seek to promulgate under the CMT.
It was subsection 5. It says the obligation under subsection 3 continues until the regional document becomes operative. Okay. So that temporary patch does sit there until the regional plan document comes through, or 30 working days after the council has informed the group that no, they're not going to take any action at all. So if the council's answer is no, we don't need to change our plan's fine how it is, thank you, 30 days after that letter, the ability for Section 104 to take the planning document into account drops away, and then it becomes just another document that's sitting around, and it doesn't have any power in the resource consent process.
Oh, goodness. No, it's not something I understood at all. So you would have made this planning document, and under 5B, there's this potential that after all that work, it might just have no relevance in the consent process, except as perhaps an additional document to be considered.
Well, worse than that, no relevance anymore in the consent process, but also no relevance in the plan-making process, in the sense that the council has made a determination to say, thank you for your document, we have considered it, but we don't need to take any further action.
All right. Now, just one last matter is I just wanted to understand this. There's some interest now in something called blue carbon, which is this idea of allowing areas of the foreshore and seabed to perhaps regenerate something like mangroves. So you don't touch the area, you simply let it regenerate, and it absorbs carbon, sequesters carbon, and then you think about carbon credits. under the MACA regime, is it even possible to conceptualise of something like that? Because no one owns the foreshore and seabed, and if your proposal is that in a CMT area you wish to just leave the area alone and say let mangroves regrow there, what sort of interest under this regime do you think a customary rights group might have or could talk about?
It depends on two things. First, what does the regional plan say about mangrove removal? Northland Regional Plan said that it was permitted activity to pull them out. Different authorities with mangroves within their statutory areas have taken different positions on whether mangroves are, in simple terms, a pest or a relevant and taonga aspect of biodiversity, being manawa. So Northland Regional Council's opening gambit on with this was more along the pest route, which is that they should be freely removed in certain circumstances, including in significant areas and in customary fishing areas, which had been set aside as sites of significance to tangata whenua. The decision from the Environment Court on that is still awaited. It was held up by a national environmental standard, but if a plan identifies mangrove removal as a permitted activity, we go straight back up to section 20 of MACA, and MACA doesn't apply. So there would be nothing to say about anything. If the plan requires resource consent for mangrove removal, if it was an infrastructure provider who was wanting to remove those mangroves, then that would be treated differently than if it was a non-infrastructure provider, such as a local community group. And again, it would all depend on whether that resource consent had already been granted and was in existence. If the consent was already in existence for mangrove removal, for example, there's a consent that's valid in Ruakaka Estuary in Northland, which allows for chainsaws and machinery to be taken out and for regular clearance. That consent, it could conceivably have a 35-year term on it. If it was granted relatively close or renewed relatively close to when the CMT order was granted, it could be 35 or 40 years before it comes up for renewal and the RMA application, the permission right applies. But if it's part of an infrastructure project, there's no opportunity because the RMA permission right does not apply.
Thank you, Sue. That's all I had. Thank you very much.
Thank you, Mr. Binion.
Sir, sorry, can I just check if Ms. Shaw's okay are you okay to stand or? Okay.
The next lawyer on the list was Ms. Thomas, but
tēnā koe, sir, Ms. Hiruane here. I'll be putting questions on behalf of Kaupare Law.
I see.
Tēnā koe, Ms. Shaw. My name's Aroha Hiruane. I'm one of the counsel for two hapu claimants. One of them is Ngāti here in the Bay of Islands, and the other one is Ngāti Tuma Inupo in the Whangaroa Waikato area. So I'm just putting some questions to you, a couple of questions in relation to your question 5, RMA permission right section, and your question 6. And if I can just start off by asking you some questions in relation to the 40-day timeline for response, and that's the section 67.3 provisions. And you raise the concerns at paragraph 250 of your evidence and throughout as well, in terms of the 40-day time limit. Would you agree that the ability of CMT groups to respond within that 40-day time frame depends to some extent on their capability, their capacity and resourcing of those groups?
So as an RMA practitioner, I am aware that hapu and iwi, but particularly hapu, are under-resourced and oversubscribed. So when I talked about the regional plan processes and having to be involved for upward of 5 years in that process of guarding against new permitted activities. That's something that, for example, Hapu are already involved in. They will already, in my experience, be receiving a large number of copies of resource consents from councils that may or may not have any relevance to them, as Mr. Benian said, may or may not have any ability to actually influence the process, but they receive them anyway. Potentially they're also involved in fisheries processes using the rahui or working towards mahinga mā taitai, and all of those statutory processes are very labour intensive and resource intensive. So my expressed concern about the 40-day period was that because MACA and the RMA don't require the CMT holder to be notified at the mandatory point of notification is after the consent has been issued and all appeals have been exhausted, an applicant could make contact earlier, but there's no requirement for them to make contact earlier. The point at which the applicant, the CMT holder is being notified, I mean, I've seen some of these resource consents and they could fill a room with the ring binders. The transmission gully was hundreds of volumes. So at that point, if you're notifying someone of a consent, even trying to understand what the consent is that's been granted is a mammoth task. You may have had 30 expert witnesses involved in various different coastal processes who were involved in the applicant's application and then had matching counterparts from the council side for many years working on the logistics of this application. And how is the CMT group even supposed to understand what the question is in 40 days when everyone else has had years? So there's that aspect of it. It is enormously complicated and labour intensive to understand these processes, and that's very late notice in the process. It's also after the consent has been granted and all of the conditions have actually been solidified and all the appeal rights have been resolved. So if the answer was, well, we might have allowed you to do it, but not on those conditions, there isn't really a feedback loop that allows for the conditions to be notified, to be amended, because at that point it's a solid product. It's the finished product. So the other concern I have is, so this is the extreme of you don't get notified at all until the statutory requirement, which is right at the end of the process. The other possibility is that someone could actually, either well-intentioned or through a really very clever strategy, be inundated with correspondence from the applicant on a regular basis, so that the important letter, the gold-plated letter that said you have 40 days to respond, was just one of an ocean of letters that were received, and it would increase the risk of it being missed. Because if you regularly receive correspondence about a project over and over again, the significance of that one letter which sets the 40-day ticking bomb could be missed in the avalanche of paper. And there's nothing that requires early notice, but there's also nothing that stops someone from bombarding the title holder with an avalanche of paperwork.
Am I correct to also assume that in your experience throughout the years that's a likelihood of happening through your dealings with practitioners and so forth?
I've seen a lot of really good faith negotiations take place where the Resource Management Act is involved, and engagement with tangata whenua is going to be a critical part of a project, and the consenting decision on whether to grant or decline and what those conditions are. And I've seen some really good examples of those relationships being very strong and being engaged really early and cultural impact assessments being done. I've also seen a lot of tangata whenua values being identified and opposition being raised and the consents being issued anyway. Because these are new processes, I don't have any experience of what people are doing under the MACA title holder, because there had been none granted, and so this is new territory. Resource management is a very strategic world, so we operate in a situation where plans and policy statements and national policy statements and national environmental standards are constantly changing and coming at us, and resource management practitioners are very strategic operators, and so are a lot of their clients. They understand the stakes, and they understand the rules, and they understand what they need to do to get what they want.
Thank you. And just touching on the actual 30-day, and you mentioned that that's extremely short, and with your concerns and your you have with that time frame, are you able to just provide some indication of what you think would be a reasonable time period to respond, given everything you've said about the limitations?
Just check whether it's working days or whether it's days. The Resource Management Act deals in working days.
It's got working days,
40
yeah.
working days, so that's 2 months. Yeah, I don't really have an answer to that. I mean, off the top of my head, something more like 6 months might be necessary, but my fundamental concern is actually earlier than that, which is that why is a CMT holder not required to be, under the RMA, notified of this resource consent at the beginning of the process? Why would you? So the Resource Management Act does not involve itself in questions of ownership, and that is for a very good reason, because everybody else owns things under the Torrens title system. We have the rights of trespass on our side. So you could get a resource consent tomorrow to build a hotel on my property that I live on. I would have nothing to say about the fact that you want to go and get that resource consent and spend your money on doing that, because I have the ultimate power. I actually do have a power of veto because I have that title, and I can say to you, you do not have my permission to build your hotel on my property, and if you try, I will trespass you. And that's why I'm really reluctant for the CMT permission right to be called a power of veto, because it's called a customary marine title, but it's not even a title. That T doesn't stand for title in the same way as any other title that I've ever seen, or any other bundle of rights that I've ever seen. It's a limited ability in some circumstances, in some time periods, to be able to say no. And so when the RMA traditionally doesn't involve itself in people's ownership arguments, that's because the owner of land has the ultimate sanction to always be able to say no. That's not the same for CMT, and so I would have expected to see that Section 95 capital B in the RMA would require mandatory notification to a CMT title group so that they are able to participate in the resource consent process early on and have their views recorded on the application well before the consent is granted and the appeals have been extinguished.
Thank you, Michelle. I'm very tempted to go down another route, but I'll come back to my track. In terms of, you'd be aware, wouldn't you, that in respect of Ngāpuhi at least, that treaty kings remain unsettled? And I'm just bringing it back to the point of the resourcing issues.
Yes, so in my list that I gave of plan and policy processes and receiving resource consenting and working under the Fisheries Act, the obvious one that I'd left off that list was actively being engaged in te tiriti negotiations as well, which is more resource and more time. And in the work that I do in the RMA sphere, I am very conscious that often the only people in the room for a mediation or a hearing who are working without pay are the hapu representatives. Generally speaking, other than the occasional concerned neighbour type participant, a retired gentleman, usually the only people in the room who are not funded to be there in the RMA world are the hapu representatives.
And that's definitely the experience of our clients anyway. But the reason why I raise that is that in the evidence of Ngātere here, they place importance of needing to exercise their tikanga without barriers to ensure that their responsibilities of kaitiakitanga are met. So my question for that is, would you agree that even with the title, with the CMT orders,
there are limitations on CMT groups to exercise their rights and to protect the area that they have orders over?
It is very limited for the reasons that I've given, because it only applies in certain circumstances, doesn't apply at all in other circumstances, doesn't apply for extremely long periods before it kicks in. If you can use it, you can't use it for many years, and that's not the RMA doesn't function like that. The kaitiaki aspects of the RMA are, active involvement in the resource consent process, conditions being imposed. Ultimately, something might be declined, but conditions would be imposed for monitoring, cultural monitoring, funded monitoring programs, and all of that would be built in from the beginning of the activity. Not something that you had to wait 35 or 40 years to be able to effectively take it back in whatever condition is that you receive it back. If there's been something like a reclamation or some kind of mining activity, that by the time the RMA permission right kicks in, if it ever does, the resource is not in the same state anymore, because some of the consents that can be granted are for wholly destructive activities.
Right, thank you. Thank you, Ms. Shaw. Sir, I did have a couple of other questions in relation to question 6, but just conscious of the time, if I may seek leave to put those in writing.
Yes, thank you, Ms. Hiruni. That's the appropriate course, and we've also reached the time as well for the afternoon adjournment. So we will adjourn and we'll reconvene at 3:25, and we'll continue with questions from there.
Sir, if I may seek leave, I have to catch a flight later this afternoon.
Certainly.
first time in history, we're seeing real-life superheroes fighting crime.
Do not throw that bus. I'm sorry, that's on me.
How can we not stop two chicks in their 40s?
I play dirty.
Put some more money in the bag.
Don't take this the wrong way. You're terrible at this.
YouTube Music Premium is dedicated to you. During your dinner party with friends and family, on long drives without a signal, and when your phone screen's locked. It's full of exciting features that make you feel like you're with the band, that help you find the music you've been looking for, and discover new music that you'll be listening to for years to come. Upgrade to YouTube Music Premium. Uninterrupted music dedicated to you. Try 1 month free. Listen to music personalised to you. YouTube Music Premium. Start a 1 month free trial.
Tēnā koutou. So we'll reconvene, and Mr. Silveira, I understand you're no longer seeking to question the witness. Ms. Dixon.
Tēnā koe, Sir. Tēnā koe, Ms. Shaw. Sir, is it okay if I remain seated for my questions?
Yes.
Tēnā koe, Ms. Shaw. Mihi tonu atu kia koe, me tō whānau no te rohe o whanga tāmure. Nā reira, tēnei te mihi atu kia koutou. Ms. Shaw, I'm here today representing three parties, Ngunguru Marae Trust, Te Wahapu o Hokianga and Patuhara Keke. And I also note that a lot of the issues that I was going to look at has been traversed by my friend, Mr. Benyon. So I just wanted to therefore focus on and have as a reference point the reclaimed land that is at Popo Whenua and Marsden Point. And for the record, you're quite familiar with the area and the activities that take place in that area.
Yes, that's correct. I grew up in the area. The illustrations on my last PowerPoint are actually from Marsden Point. So the right-hand side of the image is the New Zealand Refining Company, and the left-hand side is Northport. They were only example images, but yes, that's where I grew up, and I still live in that area, and I have been involved in the Northland Regional Plan processes for the last 3 years, which have included consideration of that area for the plan provisions.
Right. And in terms of layers of interests and vesting of reclaimed land, the base point is that the land is vested in the Crown at this time. And then in terms of interests that could be sought in a reclamation, that is also set out in the Act in terms of Section 35, where interests can be sought by a developer or a network utility operator, and it's only those parties that are eligible to seek an interest in the reclaimed land.
Is that a Section 35 MACA or RMA?
Section 35 MACA.
Yes, that's right. So Section 35 MACA sets out what happens in the situation of reclaimed land.
And the interests that either of those parties could seek amount to either freehold interest or some lesser interests, such as leasehold interests in that area.
That's right, and Section 29 MACA sets out the interpretation. So, for example, developer is defined as the person who holds the resource consent. Now, that might be the CMT group, or it could be somebody else, and that is whether or not the resource consent was obtained after the completion of the reclamation or not. So that definition section interpretation also talks about the different interests which are freehold or something lesser than freehold, such as a lease or licence.
And in your experience, have you come across what some of those freehold interests would translate as in terms of what that would provide that party?
So the freehold interest to a reclamation. Reclamations are quite troublesome under the Resource Management Act. Apart from anything else, they move from one jurisdiction to another. So when they are within the coastal marine area, when they're below mean high water springs, they are the territorial responsibility of a regional council, and they form within the coastal plan. Once the reclamation occurs, it becomes land. Meanwhile, high water springs moves to the outside of the reclamation, and that area of land actually transfers from the regional council through to the district council because it becomes terrestrial. It's inherited by the district council, but it doesn't have any zoning under any of the plans because it was previously coastal marine area, and it doesn't have any. So it becomes an RMA what we call innominate, which means that it's got no planning provisions that apply to it. So in terms of the rights under the district plan, it becomes just a discretionary activity to do anything on top of it, because the RMA provides that innominate, unnamed zoning is discretionary activity. That means that it can be granted or declined for any reason, and any conditions can be opposed. And in terms of the property interests that relate to the different types of title or interest, the freehold interest is a stronger interest than one of the lesser interests. But again, the RMA doesn't concern itself with the property holding aspects. It wants to know what the proposal is, what the activities are, what the effects are, and who holds those consents.
And in terms of those interests, the level of consideration that the Minister for Land Information needs to take is set out at section 36(2). In terms of determining matters specified in subsection 1, the Minister must take into account the following matters so far as they are applicable. And set out there, A to J are those interests, including such things as whether any historical claims have been made under the Treaty of Waitangi Act in respect to the reclaimed land, and F, the cultural value of the reclaimed land and surrounding area to tangata whenua. That's merely a taking into account a consideration, isn't it?
Yes, so that is a MACA provision, but in terms of the RMA language of the take into account, give effect to, have particular regard, the take into account is at the lowest level of the hierarchy of requiring action from the decision maker.
Yes. And further to that, it doesn't necessarily translate that all mana whenua interests are captured in this process for the Minister to take into account. It depends on what is presented before the Minister.
Yeah, well, the first thing I'd note is that section 36(2) in MACA doesn't say, so it's common in the RMA for sections to say that includes but is not limited to the following, or means, which are very different. This one uses the phrasing, the Minister must take into account the following matters so far as they are applicable. So there is a relevancy test in there, but other than the relevancy test, A to J are, I read those as mandatory. But for example, F talks about the cultural value of the reclaimed land and surrounding area to tangata whenua. It doesn't use the phrase mana whenua, for example, and it doesn't limit that to CMT applicants or CMT groups. It uses the wider language of tangata whenua. And H talks about natural or historic values associated with the land. Again, that is the broader. That is a broader interest. It's not narrow. And J, again, this is mirroring a provision in the Resource Management Act in section 124, special circumstances, including the amount of investment made by the applicant in respect of the reclaimed land. So this is mirroring the provision in the RMA, where on renewal there is a mandatory requirement for the council, the decision maker, which transfers to the court on appeal. There's a mandatory requirement to consider the value of the investment of the consent holder, which is a status quo bias, if you like, because it weights the decision making in favour of the status quo.
Ms Dixon, I don't want to interrupt, but you have exceeded the time allocated. Do you have further questions for Ms Shaw?
I do, sir, but I was actually moving on to another part, so perhaps I can put those further questions in writing.
That would be helpful.
Thank you, Ms Shaw.
Ms Harper Hinton.
Tēnā koe, Ms Shaw. My name is Julia Harper Hinton. I'm just asking a couple of questions for Ngāti Torahina ki Mātaka. And they're a hapu who have a CMT, customary marine title application in. They've applied to the High Court for that. Within their application area, so within their rohe, is the Te Puna Inlet. And within the Te Puna Inlet, there's consented, existing consented oyster farming. At paragraph 198B of your brief,
Yes.
You note there that existing aquaculture is one of the accommodated activities that's exempt from the RMA permission right.
That's right.
And is that under section 64 2E of the MACA Act?
So 64.2 is the accommodated activity means any of the following.
Yes,
and E is the permit existing aquaculture activities to continue to be carried out. Yes.
That's right. So you've mentioned that they continue in your brief at 198. B, I just wanted to ask about a further aspect of that section 64.2E, and that's just the Roman numerals 1 and 2, which you haven't mentioned in your brief, but if we could have a little look at them, they provide that the aquaculture continues regardless of when the application is lodged or whether there is any change in the species farmed or in the method of farming, method of marine farming, but provided there's no increase in the area.
Yes.
So as an accommodated activity that's exempt from that RMA permission right,
yeah.
This section means that a customary marine rights holder, a group, customary marine title group, won't have any say in whether or not the species are changed or the method of farming is changed.
That's right. So the definition of accommodated activity, which is carved out of the RMA permission right, includes at 64.2E the existing aquaculture, as you say, regardless of when it's lodged, or the changes to the species farmed. So that could be a change from oysters to mussels, for example, species farmed or the method of farming. But the rider there is that there cannot be a spatial change or a change of location. So if the farm changed in spatial area or was relocated, then the waiver would fall away. But as long as it stayed within its spatial confines and it stayed in the same location, then other aspects of the application could change, and in RMA terms could have quite different effects.
With no authority or say of the customary rights, customary marine title groups holder over that.
Just considering whether or not there would be a renewal right. So for the other accommodated activities that are not infrastructure, the RMA permission right kicks in on renewal. I haven't considered whether that applies to infrastructure. I'm happy to answer that in writing, because when I found some of the others, they were actually hidden in other provisions. So I'm happy to answer that in writing if that's helpful.
Okay, thank you, Ms. Shaw. That would be great. Thank you.
Thank you, Ms. Harper-Hinton. Mr. Naidu.
Thank you, Anna. The joy is of going at the end of the list, as most of my questions have been asked. Ms. Shaw, I think I have 2 points which I can ask questions on. The first one is to do with the subject of the 35-year limitation on coastal permits. Now, I understand there is a lot of uncertainty on the effects of activities undertaken under the coastal permits, and that is why the permits are limited to 35 years?
Yeah, I don't know why there is a 35-year duration on the resource management. I haven't looked at the early legislation to see why they came up with 35 years. It's a very long term, but that is the statutory maximum, other than there are some exceptions I detailed in my evidence. So reclamation doesn't have a statutory term. Terrestrial consents don't, but we're only dealing with coastal permits here. Aquaculture has slightly different provisions in it. I think there's a minimum term and a maximum term for aquaculture, but I don't know what analysis was done to come up with those statutory numbers.
Very well. Moving on to the next point, this is to do with paragraph 222 of your brief of evidence. And it's a commentary on the MACA Act, specifically section 35.
222?
Yes.
Yes.
Would you agree that the doctrine of accretion under common law is displaced by that provision, the provision you're commenting on?
I don't know, sorry.
Well, at 222, you mentioned the MACA at section 65 provides that the developer of a reclaimed land may apply to the Minister of Land Information for the grant of freehold or other interest in the reclaimed land. And then you explain what the developer is defined as under the Act. So on that provision, would you agree that the doctrine of accretion is displaced by that?
I don't know, sorry.
Okay, very well. I'm just checking my notes on my last question, sorry. If you can move to the next paragraph, that's 223. Again, you're commenting on section 37, and you say where the developer is a port company, port operator, or a company that operates in Auckland or Wellington, there's a statutory presumption that the minister must grant freehold interest to that entity unless they do not want it, or the minister is satisfied that there's good reason not to grant the freehold interest. On that comment, would you agree that the provision presumes that the port company owns the property, contrary to the scheme of the MACA Act, which says that the property is ownerless?
Because these provisions are dealing with reclamation, they are dealing with what happens to the effectively the new land that is created by the reclamation in bringing new terrestrial land, and so there is always a question of what will then happen to that, who will it be vested in. So MACA section 37 makes a very mandatory requirement there that for port companies, port operators and the airports, that there's a statutory presumption that they must receive that freehold interest. My understanding is that when this provision doesn't apply, when it's existing ports, for example, there's been processes where the Minister of Conservation has had long processes of trying to decide what the rights and interests of the port operator versus Manawana and Mana Whenua may be. But this presumption, this provision is a strong statutory presumption that the outcome is determined in accordance with that presumption.
Do you agree with the presumption? Do you think it should revert to the owners of the radical title?
I don't have an opinion on
Very well.
That's what the law says in that provision.
Thank you. I have no further questions.
Mr. Melvin.
Thank you, sir. Tēnā koe, Ms. Shaw. Thank you very much for your evidence. It's very interesting. Firstly, your evidence deals with two data sets, and you've explained these, I think earlier in your evidence around paragraph 17, there's a list of current RMA coastal permits in the Ngāti Wairohe, and the second data set is from the Ministry for the Environment and its national monitoring system.
That's right.
And that's for the period from 2014 to 2019.
The MFE nationwide data is for that 5-year period. The Ngāti data is from 1991 until current. It was a cumulative list of essentially all coastal permits ever granted by Northern Regional Council.
And your evidence, well, you acknowledge in your evidence that the analysis has its limitations, and you, for example, at paragraph 80, you say that it would have been preferable to have seen data relating to a 5-year span on each side of the application deadline.
Yeah, I'm not a statistician, but in terms of determining a trend of whether something had occurred leading up to or before and after a date, like the CMT application closing date in 2017, what I had for the MFE nationwide data was 5 years that spanned across the centre line. So there were effectively 2 years before, 2 years after, and the active year in the middle. It's difficult to see longer term trends from a smaller snapshot like that, but the information that was attached to Mr. Kiripeti Edwards' evidence included Northern Regional Council consents for a significant number of years spanning through, and that much more clearly, which was the bar diagram I had on my slide, much more clearly showed whether there was a rise in the numbers or not.
And the project plan asked you to consider the volume and type of RMA consents applied for around the statutory deadline.
Yes.
Sorry, around the commencement of the Act, but because of the limitations of the data, you instead focused on the period relating to the commencement of the Act.
I looked at both of them. So the commencement of the Act was before the data commenced, and so I had also looked at, I thought it was in the there were two questions in there. So I looked at both. I looked at what was happening since the commencement of the Act in April 2011, and then what changes there might have been associated with the application deadline, which was in 2017.
Although it's paragraph 79, you say you didn't have sufficient data to form an opinion in terms of trends in the volume of coastal permit applications made before and after the start of the Act.
That's right. So the commencement of the Act was April 2011, and the national data set didn't commence until 2000. ...2014, so after the commencement of the Act.
Would it be more correct to say that you didn't have any data then to form an opinion on that matter?
No, because I was also asked to look at the Ngāti Rohi information from Northern Regional Council, which included, as I say, data dating back to 1991 on a cumulative basis. So there was some information available on that second data set, but it wasn't in the MFE nationwide data.
Right.
And I think in paragraph 79 I said I do not have sufficient data to form an opinion. With respect to MFE, that's on the basis that there was none. And for Ngāti Wai, it didn't, the way that NRC recorded that information didn't make it possible to draw those conclusions because it's done as a rolling record rather than annual data, the way that MFE reports it.
All right, paragraph 79 doesn't actually refer specifically to the MFE data, but that's what you are referring to there.
In paragraph 78, I'm talking about the MFE data.
All right, at paragraph 86, you, and again at 93, I think, you conclude that the data sets you analysed don't tell you whether commencement of the Act or the statutory deadline for making applications under the Act was the cause of an increase in new applications for coastal permits.
That's right, because the data doesn't tell me why events happened. It just records the number of events that occurred in a time period.
So, well, yet at paragraph 94, you say other factors such as expiry dates of consents, other legislation and the notification of coastal plans are likely to also have influenced the numbers of applications for coastal permits. And at paragraph 95, you say it is therefore likely that the customary marine title applications deadline was one but not the only factor that RMA practitioners and consent holders took into account in making decisions about when to lodge applications for new or renewed coastal permits. So those two paragraphs are inconsistent with your earlier statement at 86 and 93, aren't they?
No, because at paragraph 92 I was referring to, and that's actually a conclusion summary. So paragraphs 85 and then summarised in 92, I was aware of the appendix to Mr. Kiripeti Edwards' evidence, which was Northland Regional Council consents granted per year for a long period. So that wasn't one of the two data sets I was given. It was the Regional Council statistics on a per year basis. The Regional Council statistics that I received were on a rolling basis, not per year. So the appendix to Mr. Kiripeti Edwards' evidence did show that there was an increase in applications in the 4-year period prior to the application deadline. So that was one of the pieces of information that I took into account. And I also took into account my experience of working with the Resource Management Act, the conversations that I had with practitioners about whether or not they were aware of the application deadline, how they had responded to that, and all of that is included in my footnotes.
You say in your evidence that, and you say this at paragraph 88, that in your experience, RMA practitioners are very aware of any statutory amendments or policy and plan developments likely to affect their clients' interests and provide strategic advice to RMA applicants and consent holders. Yet your evidence also expresses the view at paragraph 90 that the lodging of an application for customary marine title under the Act doesn't amount to a significant change to the RMA consenting framework.
In paragraph 9, sorry.
And you say it's because it is common for resource consent applicants or the council to routinely inform tangata whenua of applications within their rohe.
So paragraph 90 is talking about my experience, and I haven't practiced on a nationwide basis with the RMA. I've primarily practiced in the Northland region, which involves 3 districts and 1 regional authority. So I'm very familiar with the way that those councils, and to a lesser extent the way Auckland Council operates. And I also have a network of practitioner colleagues who work more broadly across the country. So in my experience and what I am aware of how councils operate, there is a common practice of providing copies of consents to tangata whenua on the basis of that, I think it was section 35 capital A RMA requirement. That may not be the case universally nationwide. In my experience of the councils that I've worked with, that's what they do.
And, well, then based on your experience in that Northland area, you wouldn't expect the fact that there was a deadline under the Act to have caused a spike or a peak in resource consent applications, would you?
It's one factor amongst a myriad of other factors at national policy statement, national environmental statement, standards level, regional policy work that's going on, plan notification that's going on. The fact that there was an application deadline that introduced a mandatory requirement under MACA, not under the RMA, to seek the views of CMT applicants was a new requirement on applicants. In my experience, it didn't necessarily introduce a change to the practices of the councils, which was to send that information out anyway. It may have increased the number of parties that they were sending that to, but it did introduce a new requirement on applicants. The Resource Management Act does not require applicants to consult. In fact, it expressly says in Schedule 4 to the Resource Management Act that for the avoidance of doubt, there is not a requirement to consult. There is simply a requirement to record whether you have consulted or not. So I'll find that. So Schedule 4 is the resource consent requirements.
Well,
so
36A covers it too, doesn't it?
And Schedule 4, Clause 6.3, to avoid doubt, does not oblige an application. So obliges an applicant to report as to persons affected, but does not oblige the applicant to consult or create any ground for expecting that they will consult. So in that sense, MACA introduced a new and different requirement on an applicant that they had to seek the views of the CMT application group that doesn't exist in the RMA and didn't exist before. So in my experience, those two things are true at the same time, is that councils may well have procedures for sending out copies of resource consents that come in the door. Applicants may be consulting, but there was no statutory requirement for them to do that consultation prior to the application deadline.
And it would be very hard in those, given those factors, to attribute any particular numbers to the fact that the MACA Act introduced this new requirement, wouldn't it?
There's no way of telling from data about the numbers of consent applications that come through the door at a council why those were made at the time. There are factors going on that are easy to quantify, such as if it was a renewal application, then it's likely to be related to the expiry date. But even then, when I spoke to the regional council staff, they said that for aquaculture renewals, the applicants were seeking their renewals earlier than their statutory term because the new regional plan introduced stricter requirements. And so if the applicants were able to get their application in before the new regional plan was notified, and a draft had gone out so people knew what was going to be in it, they were able to beat those provisions by getting their application through the door early. So even then, with something like renewals, you can't say that that's 100% because it was about the expiry date that was driving it. Certainly expiry dates are one of the strongest drivers of patterns in when applications are made, because it's expiring, and if you don't get an application in, you don't hold a consent anymore. So that's one that's much easier to monitor. But even then, in the national data set, renewals were not tracked in the data until halfway through the period. So for the first 2 years, there's no information on whether it was a new application or a renewal application. That was only picked up halfway through the data.
Now, paragraph 81, you refer to a peak in total numbers of coastal permit applications made in 2016 and 2017. And you've said that this coincides with the deadline under the MACA Act for making customary marine title applications. But you've also said in your evidence that the data sets that you've analysed are inherently duplicative. That is, they record separate coastal permits even if multiple coastal permits are linked to a single proposal or activity.
That's right, because the different sections of the RMA through sections 12 to 15, and within those sections, I think I give the example in my evidence of section 12, lists out a variety of different activities within the takutai moana, which might be dredging, disturbance, deposition, structures. Those are all separate subcategories of section 12, and the regional councils record those subsections as different consent triggers. So if something comes through the door as a package and it's a single application that triggers more than one subsection under section 12, it will get given 5 different consent numbers, typically with a decimal 0.12345 at the end of it, and those are treated in the application and in the decision as separate components of a bundle application. And so there, I acknowledged in my evidence that that's a statutory tool. There's no easy way to account for that in the data. I looked at whether it was possible to somehow sort or filter it to group things together so that it was obvious that it was the same application, but there's no information really that enabled that to be done. So that's just how the data is. It records all of those separately. So that does make it difficult, doesn't it, to draw conclusions, or at least robust conclusions from the total number of applications made in any given period? It does, with the rider that was the case before MACA commenced, before the CMT application deadline, after. That has always been the case. The data has always been recorded in that way. So it didn't introduce a new variable at the same time as something that I was looking to analyse. It was the same variable that's always been in the data. And the peak in 2016-17 that you've referred to relates specifically to the West Coast Regional Council, doesn't it? I think I said in my evidence that it coincides, and again it's difficult to... So Annex 2 to my evidence has the breakdown that I asked for by council to see whether that peak in that period was explained by any other patterns deeper in the data. And so for total applications, the West Coast Regional Council had a significant peak in 2016-17, and that was a significant number of renewals when they were split out by new and renewal. So that's probably not the entire answer, because some of the other councils in the list also had varying numbers, but that was certainly one that stood out on a statistical basis as being unusual. So for example, the number of consents for West Coast in the 2 years previous were 51 and 28, and then 1,213, and of those 1,100 were renewals, and that may have been related to the fact that they had a whole lot of consents that were expiring all at the same time. It could be also because they, for example, were notifying a new plan which would change people's rights, and that there was an ability to apply early and get an advantage. It may have been related to the CMT application deadline. I don't know, because the data doesn't explain why people do things. All it does is break down that peak in 2016-17 in the nationwide data does coincide with some unusual statistical activity in West Coast. And you didn't
contact the West Coast Regional Council to make inquiries as to whether their officials could give a explanation for that particular peak?
No, I didn't, and my evidence acknowledged that there are a number of different reasons for those statistics, and I didn't draw the conclusion that because there was a peak in that year that it was for West Coast region related to the CMT deadline. I didn't draw a conclusion at all about where that peak came from. I simply identified that it did appear to be driven by one council.
Now, I'd just like to pick up this topic that's been canvassed to some extent with my friends. And this is the issue that there isn't a requirement for a customary marine title group to be informed of an application for a resource consent by the applicant until after the consent is granted and all appeals are resolved. But wouldn't you accept that it would make common sense and very strong financial sense for a resource consent applicant to seek the views of a CMT group before they went through the consenting process?
It would, and certainly if there wasn't a 40 working day deadline before the RMA permission right was deemed to be waived, there would be no reason not to, because that waiver deadline is sitting in there. There are significant advantages to an application if the RMA permission right is waived by the deadline being missed. So I can't comment on whether how individual applicants would weigh up those risks and benefits, but certainly it would be prudent before spending a significant amount of money on a resource consent process where an RMA permission right applied to be engaging early with that process, and certainly that would play out if there wasn't that deemed waiver provision. I don't know to what extent the deemed waiver changes applicants' behaviour.
Well, they'd be taking an extraordinary risk, wouldn't they? Particularly for a large or expensive project to rely on the deemed waiver provision.
Yes, absolutely, because they could spend all of the money and all of the time on the process and find that the immediate answer was no, we do not give our permission, and that's that. There's no right of appeal. That's a final answer.
The project brief you were asked, this is question 6 of the project brief. It asked you what the differences are between the rights available to resource consent holders under the RMA and the rights available to CMT holders under the Marine and Coastal Area Act. Would you agree that these are two quite different categories of rights holders?
Yes, and as I indicated in my summary slides, the MACA rights are statutory rights. The resource consent holder, those are permission rights that have been sought through an application process. So yes, they are different animals.
So it's a bit of a apples and oranges comparison, isn't it?
It was the comparison that I was asked to make.
You state at paragraph 269 that customary marine title groups are not exempt from obtaining relevant resource consents, permits or approvals required for the use and development of customary marine title areas. while the holder of the coastal permit can rely on this as authority to conduct consented activities for the term of the consent, even if the council's plan rules change. Would you accept that the fact that customary marine title groups are not exempt from obtaining resource consents or permits in respect of the CMT area is no different to the situation that exists for private property owners? In other words, private property owners are not exempt from obtaining resource consent permits over their own property, are they?
That's true, except for designations don't apply in the coastal marine area, and councils are not exempt from the requirements either, so I can't think of any group or body that is, other than the designation process, which only applies on land, that is exempt from requiring resource consent, and that includes the councils themselves.
And you say at paragraph 271 that the delegation and transfer of customary marine title is governed under section 60, subsection 3 and section 61 of the Marine and Coastal Area Act, and is limited to delegation or transfer within iwi or hapu. And you've said in your summary that customary marine title groups have more limited rights of delegation and transfer than consent holders, who can transfer the whole or any part of a coastal permit to any person. But again, this kind of reflects the rather weird comparison that you've been asked to undertake, doesn't it? Because they're quite different types of rights. Would you agree with that?
They are different rights, yes, because the CMT is a statutory right, and again the coastal permit is a permission that has been granted to undertake activities.
Yes, and a resource consent is neither real nor personal property.
Well, the Resource Management Act says that it's neither real nor personal property, and then sets out half a page of ways in which it's treated as if it were real or personal property. I covered that in my evidence. So it says that it's not, and then gives all the reasons for all the ways in which it treats it the same. So your resource consents are transferable, and that is the statutory framework under the RMA.
Well, the Act says it's not. And yet, the Marine and Coastal Area Act says that customary marine title is an interest in property. So they are at least on the face of the statutes quite different beasts, aren't they?
I'm not a property lawyer, so I couldn't comment on what the similarities or differences are in terms of property rights.
The summary of the differences between the rights available to CMT holders and holders of resource consents doesn't, as far as I can see, address the right to produce a planning document.
I do address the planning document at some stage in my evidence, possibly
Yes.
not in that part. So under the RMA, there are two methodologies already for tangata whenua to produce planning documents. The first of those is by producing a hapu or iwi environmental management plan and lodging that with the council. So for example, in section 66, subsection 2, capital A, a regional council has to consider that iwi or hapu environmental management plan when they're producing a policy statement or a plan. And then there are the new provisions or newer provisions for mana whakahonua rohi, which were introduced, I think, in 2017. They're much more recent, and those provisions relate to, in summary, the consultative relationship between the two parties, and setting out how sections 6, 7 and 8 are going to be materially evidenced in the relationship between them, particularly in plan processes. There's no mandatory role for manawhaka hono arohi in resource consent processes. It's not precluded, but it's not in the list of things that they can include. So those two planning document paths already exist in the Resource Management Act, and I acknowledge that CMT group can also produce a planning document, and Mr. Benian's questions covered what those planning documents can do.
Yes, so you'd accept that a complete list of the differences would include the fact that CMT holders have that right to produce a planning document?
CMT holders have the statutory list of rights, which is included in MACA.
Yes.
And so there are definitely more differences than I've identified in here. I think the brief gave me some specific answers, examples that I was to look at for question 6, including section 135 transferability and section 124 priority. So I considered those examples that were included in the brief. But yes, there are more because the MACA provisions set out exactly what the rights are of a CMT holder.
At paragraph 118, you've referred to the issue of status quo bias. Which appears to or you say it influences decisions relating to the renewal of resource consents. But it wouldn't affect a CMT holder. Status quo bias wouldn't affect a customary marine title holder's ability to exercise a veto or to exercise its RMA permission right, would it?
So first, status quo bias is not my wording. It's actually from the Randerson report. And where the RMA permission right applies and is not exempted by accommodated activities, and when it applies, so after renewal, at the point that the consent holder has to come in for their new application, for their renewal application, the status quo bias at that stage is really limited to the extra time that they get. I mean, I've put a nominal number of 5 years on there, but it could really be anything, that they get to carry on running on with their activity while their resource consent and appeals were resolved, if they chose to do that, knowing that they that the RMA permission right existed. So the status quo bias is reduced where there's a CMT order and that RMA permission right applies. The status quo bias is very strongly reflected, however, in the accommodated activities, because those are exempt from the RMA permission right, and so those existing activities are able to continue without the permission right applying.
At paragraph 225, you note that the RMA permission right doesn't affect activities that can be lawfully undertaken without a resource consent or other authorisation. That's in reliance on section 20B of the Act. And you express the opinion that as such there will be increased pressure on regional councils to provide for permitted activities in regional plans. And I was wondering what the basis for that opinion is.
My experience in 22 years of working with the Resource Management Act, and again I've indicated in my evidence that in my experience resource management practitioners and many of their clients are very responsive to the processes that are going on around them at national level and at regional and district policy and plan making level, and in my experience of those processes, the least friction option is always the preferred option. So having something secured, and the majority of my experience with the RMA is in plan and policy making rather than in consenting. So in that framework, seeking a permitted activity, there's a hierarchy of preference. You want a permitted activity, and if you can't get a permitted activity, you want a controlled activity. If you can't get a controlled activity, you want a restricted discretionary activity. If you can't get one of those, you want discretionary rather than non-complying, and you certainly don't want prohibited. And that hierarchy is because of the way the RMA interacts with those various levels. So permitted activity is your gold standard because you do not require a resource consent. If you can't get a permitted activity into the plan, then you're always looking for the next best activity status with the least impact on your rights and powers to undertake the activities you want to undertake.
So whilst there might be increased pressure on regional councils, the councils won't necessarily yield to that pressure, will they?
No, so there's a whole public process for the council to notify its plan and seek submissions, hear those submissions, issue its decision. There's an Environment Court appeal process. But my experience is that those submissions will be seeking permitted activities, because that is the guaranteed way that MACA doesn't apply. And given that the RMA permission right, if someone's not an infrastructure provider, or even if they are an infrastructure provider and they're wanting to do new infrastructure rather than renew their existing, then that permitted activity is the path of least resistance for them.
But the public input process, or the processes that allow for public input that you've just outlined, would also enable others, including CMT holders and tangata whenua groups and perhaps other groups to submit otherwise, wouldn't it?
That's right, and then the whole process plays out in terms of the submissions, the hearings, the decision, and then the Environment Court is a de novo hearing system, so it's a commission of inquiry rather than an appellate court. So the Environment Court hears those appeals de novo. So at the Environment Court stage, again, everything is up for grabs as long as it was asked for in the submission. Effectively, there is a rehearing at the Environment Court stage.
Your evidence, and it's probably because you weren't asked to, but you talk about accommodated infrastructure, associated operations, deemed accommodated activities, but your evidence doesn't give a picture of how many such applications have been made in the data sets that you looked at, or just in general it doesn't give a sense of, it's not possible to get a sense from it of how often those kinds of activities or applications for those kinds of activities are made in relation to the common marine and coastal area.
So as a proportion of infrastructure versus non-infrastructure?
Yes. It could be put that way, or perhaps in other ways, but
the only way to do that would be to interrogate the data by the name of the applicant to try and reverse engineer that, and that's retrospective information to see who was seeking those consents. I'm not sure that the MFE data actually contain, in fact I'm reasonably confident that it doesn't contain that information, because even though those are public records, just have a look, I have got the contents for the data. There's a description of the legal description for the title. There's nowhere in the contents for the MFE data that indicate that the names of the applicants was recorded, and the type of consent wouldn't tell you whether something necessarily was infrastructure or not. Again, you could do a find search in the Excel data to see if you could find any keyword describers that might give you clues as to whether it was from an infrastructure provider or not, but essentially the data is not set up to provide that information.
Are you able, in light of your 20-odd years experience, to give any kind of rough and ready indication?
Of the proportion of private work with versus infrastructure work?
Well, the type of infrastructure that would be treated as accommodated infrastructure or associated operations or deemed accommodated activity.
The majority of my work is in plan and policy development rather than in consenting, which is only ever a snapshot where you see one application that's brought forward by that applicant, and then for it to be narrowed against that it was only for coastal permits, which is only the ones we're talking about here. Certainly in the regional plan preparation space that I've been involved in for the last 3 years, the infrastructure providers have been well represented in those mediations and hearings. We're talking the refinery, the port, Waka Kotahi, New Zealand Transport Agency, Kiwi Rail, the National Grid, the local electricity providers for the different regions. They were all in the room. So in terms of consenting, I can't give that information because no one person observes all of the resource consenting that happens, except the council. And if the council's recorded that data, for example, they record the name of the applicants coming in, whether they would release it, I don't know. But no, in terms of consenting, I couldn't answer that question.
At paragraph 151, you make a reference to the National Policy Statement on Electricity Transmission and note that it applies to Transpower's National Grid. Do you know how much of Transpower's National Grid would be in the CMCA?
They do have national grid infrastructure in that area because, do they? Transpower, no, I don't know actually. North Power and Top Energy in Far North were both involved in the coastal plan. So for example, again, mangroves and inlets are quite a good example of where infrastructure providers talk about being linear providers, and so the power poles and power, not so much pylons, but the power poles will go in relatively straight lines, and they won't tend to bend around an inlet and come back out again. So those poles do actually go in the CMA, and there was definitely discussion in those regional plan mediations and hearings around the footprint of those poles, what happens if they have to replace one and it's slightly different, slightly bigger, or they have to shift the whole. So there was definitely discussion. I don't recall whether Transpower was in the room, but definitely the distribution providers were in the room.
But before any decision were made, those key Section 6 principles, which include Section 6C regarding Māori interests, would have to be taken into account, wouldn't they?
So the Section 6, 7 and 8 have been given effect to in the national policy statements. So the New Zealand Coastal Policy Statement has translated those, and the Supreme Court discussed this in King Salmon, is that you don't need to go back up to Part 2 of the Resource Management Act, because the New Zealand Coastal Policy Statement has taken those statutory requirements and converted them into policies that apply in the coastal area. And Transpower similarly have their national policy statement, the NPS electricity transmission. The difference that's important for those is that Transpower's national policy statement is older than the New Zealand Coastal Policy Statement. Transpower's national policy statement uses language around seek to avoid adverse effects, which is not as a high a threshold as the Coastal Policy Statement, which says avoid. So I have had many conversations over the years where Transpower have a preferential statutory test or a preferential policy position where they do not have the same test for avoiding adverse effects on values as non-Transpower infrastructure or not infrastructure, because those sections 6, 7 and 8 have actually been translated into policy language, and you don't keep going back up the hierarchy to the top, to the RMA. You sit in the policy documents, which was one of the key findings out of the King Salmon Supreme Court decision in 2014.
Thank you very much, Ms. Shaw. Thank you, Sue.
Thank you, Ms. Shaw. You'll be pleased to know that we're getting late in the day, so I'm going to have to go reasonably quickly, and there's only a few matters that I need to cover. I just wanted to make sure, by way of record, that in relation to the answer in writing that you volunteered, or you may or may not recall, but I just wanted to reiterate that I would certainly like to see an answer in writing to you on that issue of whether or not the renewal issue was covered within the excluded accommodated activities for aquaculture.
Aquaculture,
yep.
Yes.
And also in relation to the aquaculture term, whether there was a minimum or maximum.
I do know the answer to the aquaculture term question. Right. That's in my brief of evidence.
If you can't locate it straight away, Ms. Shaw, just add it, if you would, in your written answer.
Yes, sure.
Or draw attention to it. My recollection, certainly when I ceased practice in Marlborough, was that the term was 35 years, but that some councils, like Marlborough Regional Council, which has a lot of agriculture, had imposed a shorter term than that. And
that's right.
I think then there may have been a statutory minimum.
The statutory minimum is 20, the statutory maximum is 35, and I think the minimum applied unless the aquaculture provider sought otherwise. But yes, I can confirm those. I can't place my finger on where they are right now.
Thank you. Right. In terms of the permission right, I can absolutely understand both the observation that you're making and that Mr. Melvin is putting as well to you, that it just seems so illogical and crazy to have it come at the end rather than earlier on. And there must be a bit of force to what Mr. Melvin was putting to you, and I'm sure, I imagine you must accept it, that if you're looking at a big project and an applicant involved in a big project, they're about to embark on many hundreds of thousands, if not millions of dollars in professional fees and putting that and doing the research and putting the proposal together, etc. It would just defy logic to leave it until after you go right through the appeal process, etc., and then seek a permission right. Would you agree with that?
Yes, I do. And my observation was that the requirement, the statutory requirement, is that notification occurs very late in the process, and so assuming that they have the RMA permission right and they're able to exercise it, so it's not one of the accommodated activities, then absolutely, if you were going to spend millions on these projects, because that's how much they cost, then it would make sense to engage early, because why would you invest all that money and time in a project where ultimately permission was not given? but the statutory requirement is that it's very, very late in the process. It doesn't make any sense to me. But.
Different issue. Thank you. Different issue. Mr. Melvin was questioning you about the difference between resource consents and customary marine title, or your analysis of that. And as he was doing so, it was occurring to me, and I'd be interested in your response to it, what extra above the private plan change process or request process is granted in terms of this MACA Act than already exists in terms of the RMA?
So other than the RMA permission right, and as I've said, the planning document.
No, sorry, I'm meaning in relation to requesting plan changes, so that, as you know, under the RMA, and King Salmon's the classic example of it, applicants will often bring forward applications by way of a request for a plan change.
Yes.
MACA purports to give an ability for a CMT holder to prepare a management plan, which it then has to, under Schedule 2, go to the council to get approved or not. What I'm asking you is, what extra, if anything, is there given by the MACA statute that doesn't already exist under the RMA private plan change request process?
Well, very little, because those planning documents already exist, so there are already whole shelves of iwi and hapu environmental management plans that are sitting at councils with a statutory requirement to consider those when you're preparing plans. So that process is already in there, and in fact it's in there twice, because there's the iwi and hapu environmental management plans and also the new mana whakahonua rohe process. So in terms of really the only new content that I can see that the RMA doesn't already consider is the RMA permission right, and even that I think is complicated, because I think that's actually taken something away. Under Section 95B for notification, there was an open notification requirement. So if tangata whenua values were an issue, then that was something that the council would take into account in determining who they would notify to. But the residual power, if you like, the discretionary power in Section 95B to, if it doesn't meet any of the other criteria above, consider who else you might notify, in my opinion, now can't apply to a CMT title group, because they are named as a statutory consultee only for accommodated activities. So having been statutorily named and limited to certain circumstances, from my reading of Section 95B, the council then can't use its residual power to notify them anyway, because it doesn't meet that criteria. So there is no residual power. So in that respect, I think it's actually reduced the RMA position from what it was. I think the participation rights were greater before.
And Mr. Melvin was challenging you, I think, on paragraph 226, the conclusion that you reached there, that there would be pressure for, as such, in my opinion, there will be increased pressure on regional councils to provide for permitted activities in regional plans. And as he was asking me that, I was minded to think of the king salmon as being the classic example of, in the marine area, of exactly that tactic being utilised.
So it's certainly my experience of sitting through these very long processes for policy making and plan making, is that the participants in those processes are generally seeking, as is natural and they're right, the best outcome for them and the least friction in the process. And certainly the least friction in the process is a permitted activity. In this instance, it also has the added benefit that it gives you a complete carve-out from MACA. So that's the bonus, it's the cherry on top. But they were already seeking a permitted activity. There's just now a much greater reward for that permitted activity, because That's now the only exception to, if the RMA permission right does apply, and it's not one of the accommodated activities, the only exception to that then becomes the permitted activity, which takes you right out of MACA. That's the exit door. So why wouldn't you seek that? If you're going to spend a lot of money and 5 to 10 years of expensive consultants and lawyers sitting in a room engaging in these processes, why wouldn't you seek the permitted activity?
Indeed, experienced legal or planning practitioners on any major project being put before them on, as I recall, the very first question was which of those two courses, private plan change request or RMA consent application, was the first consideration. And what you're saying is that now the private plan change request has that added benefit for someone in the coastal marine area.
Yes.
All right. Just going back to your data set again, you've been properly cautious about the weight that we should put on that, but one matter that does trouble me a bit about it is, and about the spike, the 2016-17 spike, is that I noted in your evidence that you said that the Northern Regional Plan draft was released in August, I think it was, of 2016.
Yes.
And then the proposed plan notified, I think, later in 2017. So the very period that's of relevance to the deadline falls slap bang right in the middle, doesn't it?
It does, and yeah. I acknowledged that, for example, that permitted activity rule that was included in the draft and in the notified, and the significance of that is that the draft is early warning to people about what's coming into the plan. Yes. The notified plan change takes effect from the day of notification, but that draft process seeking people's input is a window into the council's process.
It's a red flag too.
It's a very powerful window if it gives you an indication that, for example, where your aquaculture activity is, the council's proposing to introduce significant ecological areas that would change your activity status from, say, controlled activity to non-complying activity. If you've got that window of a year between, and there's no requirement to issue a draft, councils issue a draft as a way of seeking input. But if you have that window of time where you're aware that much more stringent requirements are going to fall on you, then you make appropriate strategic decisions about what actions you're going to take, which might include bringing forward your renewal application by 5 years and doing it early, because it'll be a lot easier to get it through if you come in early. And I acknowledged that in my evidence, and the other one that was in there was the swing moorings, where the notified plan included, the draft and the notified rule included legalising existing illegal swing moorings of 1 per residence. And so absolutely there was an incentive in there for people to get an application in. That one was for a permitted activity, sorry, but the aquaculture one was changing the activity status. So I hope that I appropriately and cautiously recorded in the evidence that there are many things going on in the RMA space, always. There are always multiple layers.
I thought you did that very appropriately, and I'm sure that Mr. Melvin will be picking up on that when he makes closing submissions to us. The next thing that I just wanted to ask about was, no, in fact I may have covered the main points. No, I have. So thank you very much.
Thank you.
And thank you for the care and not only the care, but just the clarity with which you've given your evidence today. It's been very helpful. Thank you.
As you would have seen, unfortunately, Tāpau has to catch a flight, so he has had to leave. But Ms. Shaw, I do have some questions for you as well. Unlike Mr. Crosby, when I was in practice, I wasn't an RMA lawyer. And these days I sit in the Māori Land Court, not the Environment Court. So I have found both your written and your oral evidence to be very informative. And I'm also trying to establish the bases for the uninformed questions that I'm about to ask. The first of those is in relation to the definition of accommodated infrastructure. So this is in section 63 of the Act, and you've spoken about that at paragraph 211 of your brief, but it's really the definition that I'm seeking your assistance with at this stage, given your experience in the resource management regime. So the definition says that accommodated infrastructure means infrastructure that is A, lawfully established, and B, owned, operated or carried out by one or more of the following, and it lists their various operators. It then jumps straight to C, reasonably necessary to the national, social or economic well-being or the social or economic well-being of the region in which the infrastructure is located. Now the reason I'm a bit unclear about that is there's a clear and express connector between subparagraphs A and B with and. There's no express connector between B and C, whether that's an and or an or. And you can contrast that with all of the other definitions in section 63 where all of the subparagraphs are expressly connected by either an and or an or. And I'm not sure if that has significance or not. It seems to me that definition could be interpreted in one of three ways. So it's either accommodated infrastructure is either A plus B plus C, option 1. Option 2, it could be A plus B or A plus C. Or option 3, it could be A plus B or C is a separate standalone provision. So I'm interested in your view as to which of those options you think applies, or if you think it may be a different option.
No, I think it's the first, which is that all three are requirements. I've been squinting at the grammar, but that is actually a colon on there, right? So it's not just that the word and is missing, but also for the others there's the semicolon and that one's a colon. I had read it as being three requirements. That makes the most sense to me because those clause A about being lawfully established is sensibly links into the MACA purpose for protecting the existing uses. So the lawfully established could be that it was consented, it could be that it didn't need consent at the time that it went in. That's RMA language, so I'm familiar with what that is. Sub B is directly linked into that RMA definition of infrastructure, which is imported into MACA. So that makes sense because it links back to the definition of infrastructure. And then C makes sense to me because I don't think that C could stand alone, certainly not without B. So it makes most sense to me that the interpretation is that all three of them are requirements. I note that C is a reasonably low bar. Infrastructure, in my experience, in a consenting or a plan scenario, by the very definition of it being infrastructure, will sail past reasonably necessary. Reasonably is already in there, so it's already got softening language, and national social or economic well-being or social or economic well-being of the region. Well, you've already got two options, so the national grid, for example, would come in under the first one. Everything else would come in under the region. So it's a pretty low bar in C. It's almost a self-fulfilling prophecy because if you are infrastructure, you've already met that test.
Yes, well, that was my concern too. If it was only C, it would seem to include a very large number of activities, but that's helpful that you think it's qualified by A and B.
And all the chapeau to that, sorry, that's RMA language, but accommodated infrastructure means infrastructure. So it's already got to be infrastructure, and that is the defined term. So yeah, the most sensible interpretation to me is that all three of those are required. But even if it was the worst case scenario that C was standalone, it would still have to be infrastructure that was reasonably necessary. So B isn't really needed because those are infrastructure providers that are essentially already covered off by the definition of infrastructure anyway. It would be interesting if A, lawfully established, wasn't in there, because that would mean that they weren't existing, but that would be inconsistent with the way that the accommodated infrastructure is defined, and certainly the way that I have seen accommodated infrastructure versus the deemed was very much that difference between existing for accommodated and proposed. I might be wrong on that, but certainly the answer that makes most sense to me is that all three of those are mandatory requirements.
Thank you for that. Now, just moving to permission rights, and at paragraph 250 of your brief, you have expressed concerns around the limitation of those rights. And I'm interested in particular at your statement at paragraph 250B. So there you say, if the CMT group decide to grant permission, any conditions they may wish to place on that permission have to be negotiated within the 40-day time frame. And I'm just looking back at sections 66 and 67 of the MACA Act, and it's not clear to me whether those allow a CMT group to impose conditions within a permission right. It seems that their options are to grant or decline the permission right. So I'd be interested in your view on that.
So in 67.2, the title group must notify in writing its decision to the applicant and to the authority, and if permission is given, specify the activity for which permission is given. That could be component parts of a proposal. So, for example, if it was a bundle of different activities that all comprised the same consent, and there was a wharf and a reclamation and dredging, the activity for which permission is given could specify some parts of those and not others.
Yes, and I see that. So if there were 10 different activities, you could presumably approve 6 and not the other 4.
Yes.
But it's not clear to me if you could say, I'm going to approve this provided you comply with conditions A, B, C, and D.
In RMA world, that is always an option if it's the path to getting a yes. So as an RMA practitioner, if you've got an applicant who is consulting with someone and that person says, I will give my approval, or the council, as the consenting authority says, it's a yes from me if you reduce the footprint or introduce a monitoring requirement for birds, or then we talk about the goalposts of the. So what the applicant applied for, the council can't grant more than what the applicant applied for, but they can grant less than that. So as long as it's within those 4 foundation posts, it can come in, and so the applicant can volunteer some narrowing of what they seek, and it's quite common that they go in with an application and it morphs over time. So to me, and I accept that this is not written in there in language of any conditions on that approval, and certainly given my concern about how late this occurs in the process, that wouldn't be capital C conditions that the council would impose if it was after the consent was granted and all the appeals were resolved. It might be if it was earlier in the process, but to me, in my professional experience, it's always an option for someone to say yes if.
Yes, and I took that view as well, that it would seem to be open to the CMT group to say to the consent holder, we're only going to grant permission if you comply with conditions A, B and C. If you don't, we're not going to grant permission.
Yes.
So it seems, and that seems to be what you're referring to around this negotiation within that 40-day time frame. But let's say that occurs and they say yes, but based on these conditions. The next question I have is whether those conditions can be enforced, and it's not clear to me whether they can, and I'll just set out for you my reading of that so that you can respond. Firstly, if you look at section 66(3) of the Act, once they've granted permission, it can't be revoked.
Yes.
So that's a fairly clear part. There are then some enforcement provisions under sections 69 and 70, which sets out offences and penalties and also the court making enforcement orders. But it seems to me that those provisions are restricted to where a consent holder carries out the activity without receiving permission from the CMT group.
Yep, so an outright breach.
Yes, so it doesn't seem to me that those provisions would apply if they failed to comply with an agreed condition that's outside of that statutory framework.
To me, this is similar to the RMA world where someone, might have been Mr. Bennion, referred to side agreements. And so, again, you won't find the word side agreements anywhere in the RMA. It's language that we use to describe some stuff that happened outside the formal record of the conditions of consent. Side agreements are very common where there are submitters involved or where you're on appeal and you're trying to find your way through. It's the stuff that the council or the court would not impose as a condition because it's not really for a resource management purpose. They became famous for petrol stations effectively cashing out neighbours, was where side agreements really sort of became infamous. So a side agreement records outside the consenting process and therefore outside the RMA enforcement processes the manner in which you've come to an agreement. You are for the RMA, and I think the same would apply for MACA, then looking at your civil rights and remedies, because under MACA, once you've given that RMA permission right, it's irrevocable. There's no give-backs, so you would be wanting to ensure that you had some either formal record that the applicant, that the strongest is that the applicant formally records that they have restricted their application down. So when you're dealing with an RMA consent, your best outcome, your strongest outcome is that the applicant agrees to limit their proposal, and the conditions record that. So there's a new plan produced, or there's a new description of the activity, or new conditions imposed. That's the strongest way of recording that, because that then is enforceable under the RMA. If the consent had already been granted, the conditions were in place and it was too late, or if these conversations were taking place much earlier but they related to things that the council or the court didn't think were appropriate RMA conditions to impose, they would have to sit outside that consent, and that's a dangerous place to be.
And so in those circumstances, the only option would be to try and take civil proceedings to enforce contract.
A contract.
Okay, that's helpful, thank you. I now want to turn to reclaiming land, and to make sure I understand how these provisions in the MACA Act apply. Now, firstly, have you seen the decision of Justice Churchman for the Whakatohia
I
case?
have.
Because I see he did comment on reclamation there.
And I heard Your Honour this morning referring to that. It was the paragraph where he described, was it paragraph 77? Where he described that it was taking the land out of the...
Yes. Yes, and it's, so this is paragraph 271 of that
Sorry.
judgment.
The land in question is no longer in the Takutai Moana.
Yes, and that's consistent with what you were saying about the RMA space, that once the land is reclaimed, it's no longer in the Takutai Moana and falls under the
That's right.
district council.
It changes sides,
Yes.
effectively. So it moves from the regional council's jurisdiction to the district council's jurisdiction because it goes from below mean high water springs to above mean high water springs.
Yes. Now, in, to look from in the right part, but in his judgment, Justice Churchman also found that other than limited circumstances where land is reclaimed, it vests in the Crown. And he seemed to be referring there to section 30 of the MACA Act.
Right.
Have you seen his comments on that?
I haven't read that part of the decision. Let's have a look at section 30.
Sorry, I think I was in the wrong part there of his decision. Let me make sure I'm in the right part.
Section 32, the full legal and beneficial ownership in any reclaimed land vests in the Crown, absolutely.
Hmm. Sorry, yes, so this is section, paragraph 239 of his decision, where he is analysing those provisions and makes the statement, the subpart therefore sets out a range of provisions which comprehensively vest reclaimed land from the common marine and coastal area as the absolute property of the Crown outside of the limited exceptions in subpart 3.
And subpart 3 deals with unlawful reclamation.
Well, he also says at paragraph 234 that land reclaimed either lawfully or unlawfully is vested in the Crown.
Yeah, I think that's because subsection 3 says unlawful, and then 4 says it still vests in the Crown if the minister signs a certificate.
Yes.
So there's two different ways of getting there, but it seems like the train goes to the same station.
Yes. So if we're looking at reclaimed land, there's those comments around it vesting in the Crown, or those provisions, I should say. There are then the other provisions that Council went through with you earlier today. So that is firstly under section 35, a developer can apply to the minister to get an interest, and it seems that a developer is the consent holder.
That's right. And then there is the priority that if that developer is a port company,
yes,
port operator, or an airport company, then they get the statutory presumption.
Yes.
But the others, it's an application.
Discretion. Yes. Yes, so I saw that, and you've referred to that. The presumption under 37 for those port operators and airports, everyone else makes an application, and section 36 sets out the factors that the minister has to take into account, and you considered that that phrase "take into account" was at the weakest end in terms of how those matters are considered.
In terms of the RMA use of that language, which is what I'm familiar with, then that is the lower order language. Take into account is, okay, thank you for telling me that.
Yes.
It's not the more mandatory, stronger directive language of give effect to or provide for. So the strongest two examples we have in the RMA is the give effect to, which is lower documents have to give effect to higher documents, and in section 6, which is those nationally significant issues, then it's a recognise and provide for, and it's the provide for that bites. The recognise is, but it's provide for. So that take into account to me is one of those lower levels of, I'll take it under advisement.
Yes. And you also commented on the fact that subsection 2 there appears to set out a prescribed list of factors rather than those being examples, I suppose, of types of matters to be taken into account. And there's a number of matters listed out there, and it seems that Māori interests would likely fall under subparagraphs E or F.
Or possibly H,
Yes.
historic values.
Yes. So E, historical claims made under the Treaty of Waitangi Act, so that's referring to claimants here in this jurisdiction. It then says whether there are pending applications under Part 4, and presumably that's Part 4 of the MACA Act. So it seems to be referring to people who have filed applications, but which applications haven't yet been determined under MACA.
Just looking for where Part 4 starts.
So
Part 4 is...
It starts just before Section 94, and that's the
recognition
part around,
of PCR and
yes,
CMT.
And also filing applications under MACA.
Application, yes.
Yes.
So to me that suggests that if there are... sorry, which section were we sitting in?
So this is Section 36, subsection 2E.
That's right.
So it's referring to pending applications. So it seems if you filed an application that hasn't been determined, then the Minister has to take into account your views there.
Yes.
Interestingly, though, it doesn't seem to refer to a group who has been granted either a CMT or protected customary rights.
No, they're not on the list as named. Are they in the list above?
Doesn't seem to be in subsection 1 above.
No.
I mean, arguably, again, they could fall within F, the cultural value of the reclaimed land and surrounding area to tangata whenua, but it seems strange that there's no express reference there to someone who had been granted either a CMT or a PCR.
That's right.
And it may be perhaps because of that concept that once the land is reclaimed, it's no longer part of the CMA item. I'm not sure.
And it could possibly come in under 36(1)D in terms of encumbrance restrictions or conditions. So whether or not, if the title is granted to the developer, whether that comes with any particular consequences. But I suspect that Your Honour is correct, that because the reclaimed land is no longer part of the takutai moana, I mean, in the most extreme example that I had on the slide there is that if the CMT had been granted for that entire spatial area and then the reclamation is approved, then it actually gets deleted out. Surely it has to be deleted out of the CMT order because it's no longer part of the takutai moana, it's no longer part of that title, it forms part of a different title.
Yes, well, that was the next question I had. It wasn't clear to me what effect reclamation had on an existing PCR or CMT. Justice Churchman made it clear that where land has been reclaimed, a PCR or CMT can't be granted because it's no longer within the coastal marine area. I haven't seen, and I'm not sure if you've seen, whether there's any express provision to address what is to occur if land is reclaimed in an area that is subject to existing rights. And on the face of it, it seems from what you were saying that that would be the effect, that the CMT or PCR rights would be extinguished in respect of that area.
Just having a look at section 39, which is the vesting of that reclaimed land. The Gazette notice describes the position and extent of the reclaimed land, describes the interest vested, issue a record of title in respect of the interest in the land in the Gazette notice. So this is section 39, 3A. And record B, record on that record of title that the land is reclaimed land. So it gets a new title.
Mm.
And the CMT references and the PCR references, certainly all the ones that are in the RMA, because that's where my evidence was focused, they all talk about the area. So, for example, in the policy and plan making space and in the consent notification space, they talk about if it's occurring in the area to which the CMT. So it's definitely a spatial based. CMT and PCR are both described in spatial terms because it's the area, or certainly where it interacts with the RMA, it's a spatial basis. But I don't see anything in here. I'm happy to submit a written answer to see whether I can find anything that explains what happens if CMT has already been issued and then there's a reclamation and a title is issued for that reclamation, whether there's a statutory process for what happens to that CMT, or do they coexist?
Yes. Well, to the extent that you're able to provide a further answer, that would be helpful. Well, keeping that in mind, I would like to just step through a hypothetical situation, I suppose, to see how all of these various factors would come together for a group on the ground. And it may be a little bit difficult for you to give a definitive answer to my hypothetical scenario, but we'll see how we go. So let's say I have a customary marine title for an area of the Takutai Moana, and I then have a port operator who comes and wants to establish a port on that area. That would fall within accommodated infrastructure and accommodated activities.
If I'm correct that accommodated infrastructure has to be lawfully established before the CMT order is granted, then it couldn't be accommodated infrastructure because it would be a new proposal after the title was issued. So if those three, A, B and C that we talked about, are conjunctive requirements, and it does have to be lawfully established, then it can only be accommodated infrastructure if it already existed before the CMT was granted. So if we assume that that's correct and you've got your CMT and it's a new port proposal, then the applicable sections would be around deemed accommodated infrastructure, which is where there's a proposal for this infrastructure and the applicant can apply to the Minister of Land to waive the permission right.
I see. So that's only for existing. So if it was a new one, then they have to go through the process of applying to the Minister to waive the
Yes.
permission right.
But if it's an existing port that already exists before the title, before the CMT is issued, then that is accommodated infrastructure, and its renewals, on my interpretation of the legislation, its renewals mean that it just keeps rolling, and the RMA permission right, it never applies to it.
Okay. Well, let's stick with that hypothetical situation, that it's an existing port.
Okay.
I've got a CMT around the area, but not for the port itself. They're wanting to expand. So that would then, on your analysis, seem to fall within that. So I don't have a permission right.
You don't have a permission right for the existing structure and the existing activities on the existing structure. The new proposal for the application that comes in, because MACA says that it protects things that are existing prior to the order being granted, if anyone, infrastructure or otherwise, wants to do a new proposal, because the definition of accommodated infrastructure is very much focused on what they already have. So if they want to do a new proposal, which is an expansion of existing port, or it's a whole new wharf or something, then the RMA permission right would apply to the new proposal after the CMT was granted, but that's the one that they can apply to the Minister for the waiver.
I see.
But if it's the existing port and all they want to do is carry on using it, let's ignore the fact that it's a reclamation, it's no longer in the Takutai Moana, let's say that it's a wharf-based port, then those consents for the structures, the activities that occur on top of the structures, the consents for the discharges, dredging, all of those aspects. In fact, dredging is specifically mentioned in MACA as being carved out. Port dredging is not subject to the RMA permission right, it's considered to be maintenance, then the RMA permission right never applies to any of those, ever.
Okay, that comes to what I was going to ask next, but just to make sure I'm clear about this then, so in terms of those large infrastructure projects, if it's existing infrastructure, there's no permission right. If it's a new piece of infrastructure or to expand existing infrastructure, there is a permission right, but the operator can apply to the minister to have that right waived.
Yes.
Okay. Now you've mentioned, because I was wanting to then move into a quick fire round of what is and is not accommodated activities. One of those was dredging.
Yes.
And so that's different again.
So in that multi-page definition of the accommodated activities and accommodated infrastructure, just very circular. So the definition of accommodated infrastructure at subparagraph F of the definition, so we're sitting in section 63, accommodated infrastructure subpara F, dredging as part of the ongoing operation of a port. Now, interestingly, in the RMA there is a significant difference between maintenance dredging and capital dredging. Maintenance dredging is where you already hold a consent for a dredged channel or a dredged basin, and you are just maintaining it. You are keeping those levels at the consented levels. Capital dredging is a consent to do a new dredge operation. This definition in MACA does not differentiate between them. So it says that dredging as part of the ongoing operation of a port. Now, arguably that's limited to maintenance dredging, but it certainly doesn't say that. And a port, for example, could say that their ongoing operations included the fact that they need to extend it a bit out this way for the bigger vessels. So there was a consent for the refinery for larger supertankers. In fact, I don't even think they were called supertankers. They had a far less pleasant name for them, but maxi tankers, I think. But those were such large vessels that they needed to do significant additional dredging to be able to accommodate them. Now, this provision doesn't say that capital dredging is excluded. The operation of the port includes on its daily basis receiving vessels and tying them up. And arguably, capital dredging to extend the footprint to accommodate those vessels to come falls within this provision. Doesn't say it doesn't.
So my quick fire round is not very quick, but pipelines, council pipelines for the discharge of sewage, stormwater.
Yes.
So that would be the same, presumably, for a port if it's existing, no permission right. If it's new or an extension, a permission right.
A permission right that can be waived, yes. And so the pathway to get there is that in the definition of accommodated infrastructure, it means infrastructure, and that's the RMA Section 2 definition, and that's the one I had up on the slide. That was that list of pipelines and ports and telecom providers. And so there's a statutory definition of what infrastructure is, and you have to be infrastructure to be accommodated infrastructure.
Now, you also referred to the associated operations because dredging is part of the ongoing operation of a port, as you noted, no permission right. Now, yes. I see one of the other ones there is the relocation of existing infrastructure, and if those apply.
And those are reasonably stringent in our RMA practice. We're familiar with those same or similar in character, intensity and scale. So that is language that comes out of the RMA around your existing use rights. So if you go, change of character is the change of the nature of what you're doing. Change of intensity is often around things like hours of operation or vehicle movements, dealing with terrestrial side of things. And scale would be more in terms of your footprint. So character, intensity and scale, the triptych captures that changing nature of something, and so relocation has to be necessary for continuing operation, but the effects of the new location have to be the same or similar, similar being less stringent than same, in character, intensity and scale. So it's reasonably limited. Yeah.
Okay, well, let's say I have a CMT over area A. Next to me in area B is an existing council pipe discharging sewerage. If those provisions are met and they want to relocate the pipe from area B onto my CMT area, area A, and all of a sudden sewage is going to be discharged into my CMT, permission right or no permission right?
I don't know whether it says in here that anywhere that implies that it's within one CMT area. I don't think it does. It just says that the RMA permission right doesn't apply if it falls within the definitions of the accommodated activities.
Yes.
And so arguably the relocation of existing infrastructure, that they can establish that the effects on the environment of the new location, let's say it's only moving 5 metres from its old position to its new position, but that happens to be a significant 5 metres because it crosses the Rohi line and goes into the CMT area. A council could make a very strong argument that those are the same or similar activity effects in character, intensity and scale, because it's a very small relocation. The receiving waters are the same. There would be a benthic change potentially in how that structure is secured to the substrate for potentially, but let's say that wasn't an issue and it was quite a minimally invasive process. That would appear to fall within the definition and be exempt.
Thank you, Ms. Shaw. That certainly helped me a great deal, I must say, to try and understand some of these complicated provisions. So I want to thank you for your evidence and the time that you have put aside to be with us to present that today. It's certainly been very helpful for us and for this inquiry. Ka nui te mihi ki a koe.
Thank you.
Ms. Wilson, nothing further from you in relation to your witness?
No, sir, but thank you everyone in the inquiry. Thank you, Ms. Shaw, and thank you, Tribunal. It was a very enlightening time.
Ka pai. Well, that brings us to the end of week 4. So I just want to take this opportunity to thank all of the witnesses who have presented evidence to us. It's certainly been a very helpful week in terms of the evidence we have received. I want to thank Council as well for the assistance you have provided, both in terms of leading the evidence, assisting with the conduct of the hearing this week and the questions you have put. Ka nui te mihi ki a koutou katoa, as you would have seen, Matua Pou has left already. So Mr. Silveira, perhaps I can invite you to close our hearing.
Ka pai. E tuku anō I ngā whakaaro ki ngā atua o te pō, kia kara ki a tātai. Te wheriko te tapu haere I tua, haere waho, haere te wai ko patapata e rere nei, kia hoki mai ai ko te wai māhuru. Ko rau noa, ko rau ora, ko rau ora, ko rau noa, whāno, whāno, haramai te toki, haumie, hui e, tai ki e. Tēnā tātai.